believe that.
Your university of what? I have one year?
It
was 1 year.
Yeah, but you'll have to.
This coming year.
Yeah.
I feel like you've been like, so like, you know, because I like followed group or stuff prior to this. I feel like you've been, well, you've been a part of the work for a long time. Yeah. Okay. Civilian, whatever that.
I know.
I guess
Maybe take some breaks.
You just said you all have to.
more spread out.
Oh, wow, that seems like a lot.
It does seem like a lot.
I mean, we're married. We sit
Or we're about to have all the way up to the 27th.
Okay, so y'all spread out and then, you know, it just.
How many, can we have 4 per row? Is that okay?
They want 3 to have them march. Or 3 is fine. You know, if it's 2, but 3 is fine.
Okay.
He just wants people to be spread out.
Okay. So yeah, 3 per row. 3 per row. It won't let us.
Next year.
Oh. I think you can put that. Well, I think that takes up a lot of we drink water. In here. I know. I've been on probably like a lot for 8 years, so it's like in nonprofit work, it's like this gas. So I was already kind we're supposed to sit 3 per row. We had to really reorganize ourselves.
We had a little bit of a tiny tantrum about it. I'm about it, so it's good. Oh, really?
Yeah, I know that's
As teachers, I have not liked it all. Oh, did I do that? No, I didn't. They forgot it by the building. These guys, I guess I could go that way. Okay. I just, I took my head out with my neck.
I this stuff started happening, and then like my board doesn't have a lawyer. I've been like a lot of that stuff. And like explaining to everyone about that. I was a part of everyone. So they will have, they'll be like I don't anymore, but it's very the sort of urge. That is when people are all just like, oh, this, I want to go. Like, with the last time, not talking. I miss our clients more than like. This time they're like, they can tell her some of that. Yeah.
Oh, no, that wasn't a leaf. That was a document. And I ran up and grabbed it. I was like, this is gonna mess with her. I have to go. I was like, it's not gonna go well. I like knew it. I was like, it's not gonna go well. Yeah, because everyone was just like still, and I was like, you did great. I mean, there was. Yeah, you didn't even know what it was. Yeah, that's very telling. I mean, wow.
We decided if this was gonna be too. Andrew.
How are you? Good to see you. Hey, Andrew. Hey, how are you? Good to see you.
Morning, Andrew.
Hi, Andrew, I'm Alex.
Hi, Alex.
Deputy Public Secretary.
Oh.
Documentarian.
All rise.
Thank you, Steve. Good morning. Before I call the case, I want to let everybody know you can, the lawyers, you can wear masks when you want to. Obviously, when you're talking, you don't need to. I'm not going to wear one. You're welcome to do as you please. Just be sensitive to people that might care about that who are sitting next to you. I'll leave it up to you all. Let me go ahead and call the case of Stean versus Texas Right to Life. Call the case for hearing. The first thing I want to do is get a list of the things that you all want to talk about, and we need to talk about the sequence in which we take those. Okay, we got a motion for continuance by the defendants, a motion to dismiss on the basis of the Texas Citizens Participation Act and plead with jurisdiction, and we have motions for summary judgments by both sets of plaintiffs and of course responses to those. And have I left anything out? That covered?
Judge, we did file as well a motion for designation of the council.
Yes,
in
yes.
jail, so we would add that to the list. And I also do have a proposed order from the last hearing that on the motion to seal that I would just ask that Your Honor enter today, so we can resolve that.
Has the other side approved that at the point?
I had provided it to them, but not heard back. So we can address that later. once
Let's
we
just
have a
save
chance.
that for later, but while everybody's here, it's a good idea to look that over. I'll make a note of that too.
The other motion that we filed, Judge, is a motion for ruling on the plea of the jurisdiction and the TCPA anti-SLAPP motion. So that's another.
You want
motion.
ruling on those before the summary judgment?
Right, right.
It seems to me that the proper sequence would be to take up with Mr. Stevens your motion for continuance. I'm going to take up the motion concerning lead counsel anytime you think that's appropriate. And then let's just hear argument. What sequence, Mr. Stevens, do you propose? And then I'll ask the same thing on this. Who's going to be lead over here? Anybody? Is that going to be you?
Your Honor, I'll be lead for the plaintiffs. The non-Planned Parenthood plaintiffs and Ms. Murray, I believe. Good morning, Your Honor. I'll be lead for the Planned Parenthood plaintiffs, Julie Murray.
Yes, Mr. Stevens, what chronology do you propose?
We would propose the plea of the jurisdiction be heard first, then the TCPA motions, because we think those are the threshold issues that the court should address. And then the motion for ruling on those two motions, the motion for ruling on the PTJ and the TCPA motions. And after those motions have been argued and the motion for ruling on those motions have been addressed, we would then suggest or propose the court hear the motion for continuance, because that pertains to the summary judgment motions. And then if that is granted or denied, it would affect whether we go forward with the motions for summary judgment. And so we would put the motions for summary judgment at the end. And we also have evidentiary objections. I know Your Honor suggested prefer to address the evidentiary objections on summary judgment motions at the end. But we could incorporate that argument into our response to the motion for summary judgment, or our argument on the motion to summary judgment, or before we address summary judgment.
I still want to take up those objections at the end because I just understand the context better if I've heard the main motion. I know that sometimes people don't like that. Same question to the plaintiffs.
Your Honor, on behalf of our 13 plaintiffs, I think our hiccup with this plan is really that the issues in the summary judgment motion overlap entirely with the issues in the TCPA motion, because the TCPA motion basically has the plaintiffs put on their prima facie case. I understand that they want the ruling on the TCPA motion because as soon as they have that, they're going to have an automatic interlocutory appeal. But there is case law that we've provided to the court already that allows the court to make determinations on TCPA and through the jurisdiction and motions for summary judgment based on issues of law all at the same time, so they can go up on appeal together. And so our request would be that, I mean, to the extent we need a hearing on the motion for continuance, that does make sense to go first. But our request would really be that the TCPA and the MSJ hearing take place at the same time, because it'll be a lot of the same evidence and law that Your Honor will have to look at, given that it's a declaratory judgment case and not a case with traditional tort elements.
I understand that you all don't want a ruling on the TCPA motion and the plea of jurisdiction before the summary judgment. I understand that, and we'll talk about that. But does it matter which sequence, what the order is that I hear discussion of those?
Your Honor, I don't think it does matter in terms of hearing the discussion of it. I just wanted to alert the court that the issues will overlap significantly, and so it may make sense to sort of be doing that all at one time, to the extent we're going to go issue by issue as opposed to a traditional, one side presents, the other side argues.
If there's overlap, and I hear discussion, for example, about standing on the motions to dismiss and the motion with the plea of jurisdiction, then I hear it again on summary judgment, can I stop that and say I've already heard it and move on? Okay, Mr. Stevens, let's go ahead.
Your Honor,
Yes, I'm heard.
Julie Murray for the Planned Parenthood plaintiffs. We would agree with the non-Planned Parenthood plaintiffs that the MSJ and the TCPA should be heard together. And I would say, in particular, for the discussion and for matters of judicial efficiency today, to streamline the argument, I do think for purposes of the TCPA, the court can and should consider the summary judgment evidence. So I think there is going to be significant overlap between the two. And we would actually suggest, if the court is going to consider the motion for continuance, that it do that first, so that we either hear everything today together or continue to a later time all of the matters, that those can remain together as a matter of efficiency. And I would say as well, for the motion for designation of lead counsel, we would urge, of course, Your Honor could hear that at any point today, we would urge you to deny, but to the extent that you are not inclined to do so, we would urge that you hold that motion until a later time to determine what remains of the case after the court's decisions on today's dispositive motions.
Okay. And by the way, I had mentioned to you all during one of our previous hearings that I would be open to letting more than one person on each side talk within reason, but certainly I'm willing to relax the traditional rule that only one lawyer per party can discuss. If that gets out of hand, I'll change that, but I'm inclined to do that both ways on that, okay? I think the motion for continuance should be heard first. And then I'm going to allow the plea of the jurisdiction and the motion to dismiss to be heard next. But, Mr. Stevens, it does seem to me, having looked at those, that there is a lot of overlap. And I think it does make sense for the movements on the summary judgment motions to go first on those. And let me, before we hear the motion for continuance, let's discuss the issue. Mr. Stevens, your side wants rulings on the plea of jurisdiction and the TCPA motion And if I do that and make rulings on those, then that stops the summary judgment dead in its tracks. And that doesn't get reviewed by the appellate court, is that right? Either way?
Well, if the plea to the jurisdiction or the TCPA motions are granted, then the case is over, so there would be no summary judgment.
How about if I deny those, but sign a written order, wouldn't that also stop the summary judgment motion?
If there's an appeal of the TCPA, then it would stay the proceedings in the trial court, that's correct, but not as to the PTJ.
Why would that be in the public interest to do that?
Judge, because the purpose of the TCPA is to protect the rights of the parties that are at issue and that we've raised to petition for free speech. And when those issues are raised in the TCPA motion, the purpose of the act is so that the court is to decide those issues before requiring the party to proceed with the merits or with summary judgment or hear the final judgment as the plaintiffs are proposing the summary judgment. And furthermore, it relates to our motion for continuance because the filing of the TCPA motion, which we think should be granted, has precluded either party or in particular us from conducting any discovery that we need for purposes of responding to the motion for summary judgment. And so, as I understand the plaintiff's argument as to discovery, it's that it's our fault. We filed the TCPA and therefore we're not entitled to discovery before responding to summary judgment. We don't think that's at all what the purpose of the TCPA is. The purpose of the TCPA is to get a ruling on those issues before either party has to proceed with merits. And so that's why we would ask the court to rule on that. And then if it goes up on appeal and once the appellate process is resolved, the case comes back down and the case proceeds in the normal course with discovery and then the summary judgment once the parties have an adequate opportunity to test the allegations and facts raised.
Wouldn't it also be true, though, that the summary judgment, that the work on the motions for summary judgment has already been done?
There's been briefing on the legal issues raised on summary judgment, but there are significant factual disputes and there are allegations that are supported by facts that are in the exclusive knowledge of the plaintiffs that we haven't had the opportunity to test. And that we dispute, but we can't dispute through affidavits because the knowledge is exclusively within the declarants, the plaintiff's declarants or filings.
Now, wouldn't you expect, though, that after I've heard everything, if I could do that, if I think there is a fact issue that would preclude summary judgment on one or more issues, presumably I would follow the law and not grant that. Wouldn't you think? Wouldn't you hope?
Correct. And that's, of course, what we would ask the court to do, that if there are factual disputes, then summary judgment would be denied. The concern we have is that there are factual allegations the plaintiffs rely on that we can't adequately respond to without discovery. And that's essentially the basis of our motion for continuance under 166AG is that we don't believe that we're given a fair opportunity to contest their allegations without discovery. On the TCPA ruling, the plaintiffs responded to our request for ruling by identifying several cases that they believe or they argue supports their position that the court can proceed to summary judgment without first ruling on the TCPA. We don't think that those cases apply in this context. And those cases are not in circumstances where a party is prejudiced by not having the opportunity to conduct discovery before going to summary judgment. And we're not aware of any case where a court proceeds to resolve the merits of the case on summary judgment while they're before issuing a ruling on the TCPA in a case where the movement on the TCPA is arguing that discovery is necessary for summary judgment. Cases they cite are not similar to the facts that we're faced with here. So our argument, and it would be one of our arguments on appeal, would be that the purpose of the TCPA is to get a ruling and not, it may resolve the case on a motion to dismiss, and then, but not to prohibit a party by filing that motion from proceeding with discovery before the merits are reached.
Ms. Eklund for the non-Planned Parenthood plaintiffs. Your Honor, we are in a unique space here because 2 weeks ago, the defendants agreed to a temporary injunction where they conceded that there was a justiciable controversy and that we were the correct parties and there was threat of imminent harm. At that point, their TCPA motion became frivolous and became sanctionable, frankly. They're taking a position in their plea of the jurisdiction and the TCPA motion that there's no standing as between these two, but between the opposite sides of this declaratory judgment action. We believe it's unequivocally obvious that there is standing and there is a controversy between these two, but that's why there's so much overlap between the merits of this case and the motions that they put forward. At the point at which they conceded the elements of the temporary injunction in form and substance, as they were required to do for an agreed temporary injunction, the TCPA motion became moot, essentially. They've already told this court that they agreed to that in form and substance, that there is a justiciable controversy. The point of the motion today is to stop this case in its tracks so that we have to wait longer to get to the merits. The only thing that they've identified that they need discovery on related to the summary judgment motion is standing. And almost every single thing that they identified that they needed discovery on comes from Planned Parenthood plaintiffs as opposed to the other 13 plaintiffs. Now, strangely, they've taken a position in their response to the summary judgment motion that there were no declarations put in by the other plaintiffs, but that those declarations are in this court's record at least 3 times, including attached as Exhibit A to the temporary injunction that they agreed to. So it's a mystery from our perspective why there would need to be discovery on pure issues of law. The question of standing, we believe, is clear to the court already from the facts and evidence. And there's nothing that they could dispute in that regard that the court doesn't already have access to. So from our perspective, Your Honor, our concern is that that motion is solely for delay. And by ruling, it just stops the merits of this case from being considered when really it's just issues of law.
Ms. Murray, you have anything to add?
Sure, Your Honor. So I would just add a few points. One, to Ms. Eklund's point about the defendant's stipulation to a temporary injunction. Of course, they did that as well for the Planned Parenthood plaintiffs, both with respect to the imminent harm and with respect to the showing made of a likelihood or probable right to success on our claims, probable right to relief on our claims. The other thing that I would say as to Mr. Stevens' point about Rule 166 AG, it is certainly true that that rule provides a mechanism for a party to provide a declaration saying what kind of discovery they need, but it does not follow that this court cannot, in addition to reviewing that request for discovery, decide the summary judgment motion at the same time if it concludes that any of the facts, as is the case here, that the defendants have identified is not actually material to the resolution of claims. And I would point, Your Honor, to page 10 of our opposition to the TCPA motion, where we do in fact cite cases where there was a motion, a TCPA motion filed by one party and a motion for summary judgment filed by the opposing party. And the court in those cases granted the motion for summary judgment on behalf of the non-movement in the TCPA context, thus mooting the TCPA motion. So there is case law that would provide for that. And I believe that's all we have in addition to what Ms. Eklund said. I would just say one final thing, Your Honor, about standing. I mean, certainly we can get into the specifics of this later in the day, but our clients are the 3 Planned Parenthood abortion providers in the entire state of Texas. They operate roughly half of the facilities in the state providing abortions, and before SB took effect, they all provided
We may be getting ahead of ourselves here.
I just want to say, Your Honor, to the extent that what you are considering is whether discovery is needed and sort of how to prioritize or order these motions, the argument that it is unclear whether Planned Parenthood abortion providers have standing to challenge SB8 is, I think, in the words of Ms. Eklund, quite frivolous.
I want to hear the motion for continuance first, and then we will move to the motions for summary judgment. And after that, the motion to dismiss and plea of jurisdiction. I think that's the best way to take them up. So Mr. Stevens, go ahead and say what you want to say in support of the motion. for continuance. Then I'll hear responses.
Judge, our motion for continuance is a motion for continuance of the summary judgment hearing, and it, while it also addresses our request in part for the court to first rule on the jurisdiction and the TCK motion, I want to focus on the summary judgment aspect of it, because that's the 166 AG motion for continuance. The law is well settled in Texas that a court may grant a continuance of summary judgment and permit a party to obtain affidavits or deposition testimony when it appears from the affidavits of a party opposing the motion that he cannot, for reasons stated, present by affidavit facts essential to justify his opposition. That is what we face here with many of the factual allegations and the affidavits that are submitted by the plaintiffs in support of their summary judgment motion. In particular, we've submitted an affidavit identifying what facts we dispute and what facts we would need discovery on as the basis for the motion for continuance. It's attached to our motion, and it lays out what facts are an issue that we need discovery on. I can give the court several examples. Bobby Kumar is one of the parents or affiants for the plaintiffs, Planned Parenthood plaintiffs. He states in his affidavit that the act would likely bar at least 38 people from getting an abortion in Texas in September alone. That's information that we would inquire at a deposition and seek document discovery from Planned Parenthood as to that allegation. That's something that they're alleging to prove to the court what the effects of the law may be. Another example, they say prior to the law taking effect, approximately 85 to 90% of people who obtained abortions in Texas were at least 6 weeks into pregnancy. There's no way for us to contest that fact without imposing the declarants, Mr. Kumar and Ms. Barraza, Mr. Lambrecht, and Ms. Linton all say that in their declarations. They have a number of other assertions about estimates, predictions of what they think the effect of SBA will be. We have evidentiary objections to many of those allegations, especially the lack of foundation, but to the extent there is some foundation or there is some basis for those conclusory allegations, we can test them and discover. There are a number of allegations and other statements made by the plaintiffs in their affidavits. They're set forth on pages 5 and 6 of our motion. In addition, the plaintiffs contend that the defendants have an interest in the declaration sought by plaintiffs because defendants are engaging in continued encouragement that others file lawsuits under SBA. We dispute that. We don't know the basis for that allegation, for that statement by the plaintiffs in the non-Planned Parenthood motion for summary judgment. They allege or they argue that the UDJA permits pre-enforcement relief if the law has, quote, a direct and immediate impact on its challenger and carries with it the possibility of sanctions. That's a disputed fact and something we certainly contest in discovery. Again, we've not had the opportunity to conduct any discovery because of the pending TCPA motion and cannot until that motion is ruled on and resolved on appeal. The continuance that we're asking for is to allow us the opportunity to conduct requisite discovery regarding defendants' alleged violations of plaintiffs' constitutionally protected rights. Plaintiffs allege that their patient's constitutional right to privacy is violated by the Texas Heartbeat Act. Determine whether the plaintiffs have standing to even bring that claim. That we need to identify who violated plaintiffs' privacy rights, for example. That's something that they're alleging, but there's no evidence to support it. And if there is any, then we would test it in discovery. They claim that their constitutionally right to sue was violated. Unclear how the defendants, John Seago and Texas Right to Life, could possibly have violated that right. That's again something that we would seek discovery to contest. They argue it's that the law is unconstitutionally retroactive, another example of something we would seek discovery on. The specific or more specific types of requests that we would seek are set forth in the affidavit that I submitted in support of the motion. And there, we reference the allegations and statements by their witnesses that they are relying on for their motions for summary judgment. And we also lay out, or I lay out in that affidavit, the specific types of discovery that we think is necessary for us to adequately respond. For example, declarations or depositions of the party declarants, Ms. Barraza, Dr. Kumar, Mr. Lambrecht, Ms. Linton. Those are the 4 declarants or clients who have offered testimony in support of the Planned Parenthood motion for summary judgment. We think that we need depositions of the plaintiffs or their corporate representatives. We would depose third parties with relevant information to plaintiffs' claims or the information that's referenced in the plaintiff's pleadings, declarations, exhibits, and motions. We would serve written discovery, requesting documents, answers to interrogatories, requests for admissions regarding what harm the plaintiffs have suffered as a result or are alleged to have suffered as a result of the actions of the defendants or the Texas Heartbeat Act. We would serve written discovery on the effects of the Texas Heartbeat Act on the plaintiffs. And there are a number of other more specific requests that are laid out in the affidavit offered in support of the motion for summary judgment. So the defendants here, Texas Right to Life and John Seago, respectfully request or enter a continuance so that the defendants have a full and fair opportunity to conduct discovery and test the allegations raised by the plaintiffs in support of their motion for summary judgment.
Your Honor, on behalf of the non-Planned Parenthood plaintiffs, I want to point out that he didn't identify a single fact issue with regard to my set of plaintiffs. All of the declarants he discussed were Planned Parenthood folks, and I leave it to Ms. Murray to defend her folks the way that I know she will. But he also did not identify a single fact issue with regard to our case. Our case is a declaratory judgment action that asks this court to decide the rights and legal statuses of the parties, one who contests that SB is constitutional, and the other that argues and says constantly on their own websites that it is constitutional and they intend to enforce it. That Mr. Stevens just said that they want to know what the basis is for our clients say they're encouraging others. The basis for that is attached in the evidence that Your Honor has in response or in our summary judgment and TCPA responses, which include all of the website postings from Texas Right to Life that they posted themselves to the internet, including the whistleblower website that they set up, including trainings that they held for other attorneys. But they're the source of that information, not anything that our clients could provide. There's no fact issue with regard to the declaratory judgment sought here, Your Honor. The questions are solely whether this law is constitutional on a variety of different bases. There's not a single fact issue that he identified with regard to the abortion funds or the counseling plaintiffs or the individual plaintiffs. The only issue theoretically would be whether there was irreparable harm. But they, the defendants, mooted that issue when they agreed to the temporary injunction. The only relief sought left in this case is a declaratory judgment, and it does not have the same elements as a temporary injunction. Since that has been conceded, since the irreparable harm has been conceded, the only questions now are questions of law, including the question of standing. We're not arguing that Texas Right to Life and John Seago are currently violating our plaintiffs' rights. We're arguing that the law is unconstitutional. And if they were to be sued under that law, it would violate their constitutional rights. We're seeking a declaration as to the status of that law and the status of our client's constitutional rights, given the infirmities with that law. And there's not a single fact issue that has been identified or could be identified that would change that and make a need for a continuance appropriate here. Once again, I just want to make clear the only fact issues that might have existed in the case would have been addressed at a hearing for a temporary injunction. They were not, because the defendants conceded irreparable harm. That means the only question left for this court is the question on the declaratory judgment, whether or not this law is constitutional.
Honor, just a few things to add to what Ms. Eklund said. On behalf of the Planned Parenthood plaintiffs, I would point out the following. First, setting aside the specifics of what Mr. Stevens has argued, his clients do not dispute that since SB8 took effect, it has prevented abortions across the board throughout the state of Texas at any time when cardiac activity is detectable. They don't dispute that. And their own statements, which we cite, we quote, for example, in our opposition to the motion to a continuance, TRTL has stated repeatedly that that point when SB8 applies, the point of cardiac activity, is at approximately 6 weeks of pregnancy. There is absolutely no dispute about who is being prevented from obtaining abortions in this case. I would also point, Your Honor, again, we have this in our opposition to the motion to continue. Mr. Stevens says, for example, that he wants to ask questions of Dr. Bhavik Kumar about his estimates with respect to the number of people who have been prevented from obtaining abortions since SB8 took effect in Texas. They don't need to ask those questions of Dr. Kumar because, again, Texas Right to Life has, in its own statements, admission of the party against its own interests, it has stated in an estimate that we cite in our opposition to the motion to continue that they are estimating SB8 prevented at least 5,000 abortions between September 1st and October 22nd. There is no genuine dispute. This is a delay tactic in order to avoid, Your Honor's, final resolution of the facial challenges to SB8 in this case, all of which can be resolved based on the evidence already in the record that is not genuinely in dispute, and on the legal arguments presented before this court. I would say, however, Your Honor, and I think this may be kind of a difference in the way of framing, our argument is that by threatening to enforce SB8 against our clients, which again is well supported by the evidence in the record, Texas Right to Life and Mr. Sego are in fact violating our clients' constitutional rights, both in their capacity as state actors, the state authorized enforcers of SB8. And even if Your Honor does not think that they are acting on behalf of the state, the enforcement, the use of courts and the threat of using this state's courts to enforce SB8 against my clients by Texas Right to Life is in fact an ongoing violation of their constitutional rights under the Texas Constitution. And on that basis, we think Your Honor can enter both a declaratory judgment and a permanent injunction based again on Texas Right to Life's concession that there is a threat of imminent harm with respect to the Planned Parenthood plaintiffs.
Just one issue that's come up now twice in argument by Ms. Eklund, I think we should address now because it appears to be significant for purposes of this motion and apparently their summary judgment motion, at least the non-Planned Parenthood party's motion is we entered into an agreement, an agreed order with both parties as to a temporary injunction. And I've heard Ms. Eklund say now twice that it's her position that there are now no factual disputes because the defendants have conceded all of these issues by agreeing to that temporary injunction. That's just so that's patently false. That the order, and we put it in the order for this exact reason, says that we're not waiving any of our arguments or defenses in the lawsuit. So if that's the basis for their motion for summary judgment, and that's the only thing they're relying on, which it appears it may be as to the non-Planned Parenthood plaintiffs, I think the court can just deny that motion for summary judgment right now.
One thing I hear them saying in addition, Mr. Stevens, is that because there was no temporary injunction hearing because there was an agreement,
Right.
they didn't have a chance, and you didn't take an opportunity to cross-examine witnesses and that kind of thing that you're asking for now.
That's correct, but I don't think that by agreeing to a temporary injunction to resolve that preliminary issue and give them the relief that they were asking for
pending final resolution of the case somehow waives our rights to pursue discovery. I mean, otherwise, anytime a party consents or agrees to a temporary injunction, you can just move to summary judgment and deny that party's discovery. I frankly, I'm a little bit surprised that they're trying to, game the system by saying that some agreed order has waived all of our defenses when it expressly says it doesn't.
Your
Anything
Honor.
that hasn't been said, Ms. Murphy?
Your Honor, we're not, we agreed to the form of the order that said that they were not waiving their defenses. What I'm saying is that there are only two causes of action for the non-Planned Parenthood plaintiffs in this case. One was a legal action for temporary injunction. That has been resolved. So all the fact issues with regard to irreparable harm are conceded because the injunction is in place. The other thing that we brought, the other cause of action, was for a declaratory judgment as to the constitutionality of the law. While it's true that we still have to demonstrate that we have standing for the declaratory judgment action, there is no longer a question of irreparable harm that existed under the injunction standard. My position is that they conceded that the injunction is in place. We don't have to worry about that standard anymore because all we're seeking now is a declaratory judgment. We filed our motion for summary judgment well in advance of the temporary injunction being set for hearing and the motion for temporary injunction. The motion for summary judgment relates solely to fact or to legal issues. There is no factual dispute with regard to whether the law is constitutional or not.
Thank you, Ms. Eckman. Anything else, Ms. Murray, that hasn't been said? That hasn't been said?
Yeah, yes, Your Honor, I'll be very quick. I guess the one thing that I will say with respect to what Ms. Eklund just said to add to is that we are seeking, in addition to a declaration of SB unconstitutionality, a permanent injunction against Texas Right to Life and Mr. Seco. So with respect, that is the scope of the relief that we are seeking, but we think that it is well supported by the evidence before Your Honor. And of course, irrespective of what Mr. Stevens says about their concessions or waiver, the fact of the matter is this court, in our case, earlier found the threat of irreparable harm in ordering the temporary injunction. And there is absolutely no reason for the court to revisit that determination in entering a permanent injunction against the defendants as well.
And that was one of the Travis County judges?
Yes, that's correct.
Was there a hearing on that?
There was, Your Honor, and all of our plaintiffs were subpoenaed. They showed up to provide testimony. And at that point, Texas Right to Life and Mr. Seco refused to testify and stipulated to a temporary injunction, thus essentially ruling out the very same information that Mr. Stevens now says he needs before summary judgment could be considered by the court.
Word, Mr. Stevens.
Judge, frankly, if their position is that these facts that are at issue in summary judgment have somehow been waived, I can't believe they're making that argument, or that we've somehow conceded everything that we're disputing in our opposition and in the other motions that we filed. I'm a little bit shocked by that. I can't imagine that they want to take that argument up on appeal and try to, sustain some order that resolves this case on summary judgment on that basis. I think they should present their evidence in support of summary judgment, regardless of what happened on a temporary injunction. And, maybe, if there is some case law they think they can rely on about us resolving a preliminary issue in the case, I certainly haven't seen it.
The motion for continuance is respectfully denied. Now we'll move on to the summary judgment motions, and it occurs to me that it might be efficient to deal with all the standing issues at the beginning. And I'm talking about the standing of the plaintiffs to be in court, and the other standing issue, which is the standing of any person to bring one of these lawsuits. Anybody want to? I'm willing to be reasoned with on that, but that seems like an efficient and helpful way to start.
Judge, I think as the plaintiffs counsel has said, a number of those standing issues relate to plea of the jurisdiction as well as the summary judgment. I think it would make sense to just start with the jurisdictional question on the plea, which will address standing, and then when we get to the summary judgment motion later and have to deal with whatever evidence there is on that question, deal with it then.
How's that different from just dealing with standing across the board and then moving on to another issue that might be present in all three, the summary judgment motions and also the plea of jurisdiction and the motion to dismiss?
Well, because the second issue is a merits question. And so the jurisdictional question, we would ask the court to address first without addressing the merits or the evidence that the plaintiffs have submitted on that question. It's just purely a question of does this court have jurisdiction on standing?
The merits will come up during the TCPA motion, will they not?
The prima facie case, but I don't think it will go into the exhibits or affidavits to the extent that the summary judgment motion would have to.
May I briefly respond?
Yes, ma'am.
We're happy to take up the standing issues on both sets of issues with the court's permission. This is one of the areas where we would like to have two lawyers potentially speaking, and I just wanted to alert you to that before we undertake it.
I think it makes sense to talk about the standing area of the law first and foremost, and it's both sides are making arguments that some people on the other side, maybe all the people on the other side, don't have standing, although the kind of law may be different. Mr. Stevens, I'm gonna let you go first and present what you want to present on your challenge to the standing of the plaintiffs. And
Okay, Your Honor,
then reply on that, and then we will move to the standing of any person who gets the merits of that. Go ahead.
Ms. Hacker's gonna, we'll start with addressing standing.
And if both of y'all want to talk, just as long as you don't interrupt each other, that's okay with me.
Yeah,
And the same thing over here. I think it works best that way. Go ahead.
yeah, sorry, Your Honor. We had divided up according to the motion, not according to topics. So thank you for your indulgence.
Well, is that going to be hard for you to put it all together?
We'll accommodate the court's requests here, but we may have to switch back and forth a little bit. So before the court does anything else in the case, it's important that the court first ensures that it has jurisdiction, which is critical to preserving the separation of powers under the Texas Constitution. The one main reason that there is no jurisdiction here, which I think we should talk about as an initial matter, before we even get to standing, Your Honor, is that the plaintiffs don't have a cause of action here. The plaintiffs have sued the wrong people to get the relief that they want. They've sued two private actors, Texas Right to Life and John Seago. And John Seago is just a guy. He's just a man who happens to be pro-life, who believes that abortion is wrong. Yet he's being sued in this case because the plaintiffs think that the state enacted an unconstitutional law. Mr. Seago is having to defend a state law because the plaintiffs sued him rather than somebody else who was responsible for that. The plaintiffs, and I think an easy way to think about this that illustrates that the wrong parties are here, at least on this side of the beat, is that if Mr. Seago loses, the plaintiffs are asking Mr. Seago to pay hundreds of thousands of dollars in attorney's fees to them because the state enacted what the plaintiffs think is an unconstitutional law. That's just unfair, Your Honor. And Texas Right to Life and John Seago are private actors. And as the Texas Supreme Court held in Republican Party versus Dietz in 1997, and which is also a fundamental understanding of constitutional law, the Constitution only restrains the government. A private party cannot violate the Constitution. And that's whether we're talking about the Texas Constitution or the federal Constitution. Yet here, the plaintiffs have sued Texas Right to Life and John Seco, claiming that those two private parties have somehow violated the Constitution. And again, the Texas Supreme Court said in Republican Party versus Deeds in 1997 that the private, in order to bring claims under the Texas Bill of Rights, you have to have a state actor. Texas Right to Life and John Seco are not state actors. The fact that this law creates a private cause of action does not make them state actors. The Texas courts have never held that. And in fact, if that argument were accepted, that means that all of the other Texas statutes that create private rights of action under the Natural Resources Code, under the key TAM provisions of the Texas Medicaid Fraud Act, for example, those provisions would somehow create state action, and no court has ever held that private plaintiffs in those contexts are in any way acting on behalf of the state. These plaintiffs here, who have not filed any lawsuits and who in fact have said they don't want to file any lawsuits against the plaintiffs, are not acting for the state, Your Honor. So the plaintiffs don't have any causes of action against these defendants. And I think it's important, just as an initial matter, that the court not get distracted by the plaintiff's arguments about the unconstitutionality of the law, because the court has to first ensure that the right people are here. And Your Honor, the right people are not here.
Help me understand how you got the wrong people being sued. What does that have to do with whether the plaintiffs who are suing have standing to even be accused?
Because in order to have standing, the plaintiffs have to show an injury in fact that was caused by unlawful conduct of the defendants and can be redressed by relief granted against those defendants. And so the question of whether the right defendant is here can be answered when you look at specifically the causation and redressability prongs of the standing test. So
Are at least some of the lawsuits had named not only Texas Right to Life and Mr. Segal, but some John and Jane Doe defendants have been.
yes,
Are those still in the case?
they have not been non-suited, Your Honor. But we don't represent those parties. Those parties are unrepresented and have not been heard.
Even if Mr. Segal and Texas Right to Life got dismissed, then wouldn't we still have the question of whether the plaintiffs have standing to sue the unnamed people that might file lawsuits?
Perhaps, Your Honor, but I think we would also have significant other issues because those people are unidentified and therefore any relief that would be entered against them would violate due process because those people hadn't been heard or given notice.
But I'm just focusing on the standing to bring the lawsuit. Go ahead.
Yes. I mean, I think just in terms of the standing question, you know, one problem I would raise would be that if it would be totally speculative as to what injury they're suffering based on unknown people doing unknown things. So I think that would be an initial problem. But going to the standing question, even assuming that there is an injury, and this gets into the merits of the summary judgment motion, but as Mr. Stevens noted before, the non-Planned Parenthood plaintiffs did not submit any affidavits in support of their summary judgment motion that support a claim of injury. So I'll just note that for the court. Even assuming that the plaintiffs have an injury, there is no causation or traceability because there is no action of Texas Right to Life or John Seco that is causing the plaintiff abortion providers not to perform post-heartbeat abortions, or the aider and abetter plaintiffs to not aid and abet abortions. The aiding and abetting claim is even more attenuated because it's impossible to aid and abet an illegal abortion if no illegal abortions are occurring. So that's even one chain, that's even one link down in the chain of causation from what we're talking about here. But Texas Right to Life and John Seago have said multiple times under penalty of perjury that they have had no intention, that they had no intention of suing any of these plaintiffs at the time the lawsuit was filed. They don't even know who some of these people are, Your Honor. And an easy way to tell that the harm is not being caused by Texas Right to Life or John Seago is if we imagine what would happen if the court gave them everything that they want. They still wouldn't perform post-heartbeat abortions. If they get an injunction and declaratory judgment against Texas Right to Life and John Seago, there are literally millions of other people that could sue them. They will not change their behavior as a result of any relief this court could grant, so it's basically useless. Partially that goes toward the redressability question, but I think it also helps to illustrate why these are not the right people here. Texas Right to Life and John Seago are not preventing the plaintiffs from performing post-heartbeat abortions. The reason that these abortion providers are not performing those abortions is because of the law, not because of the defendants. That does not give them standing to sue the defendants. Another causation problem is that, as the Texas Supreme Court said in 2018 in Myers versus JDC Firethorn, and as the US Supreme Court has held for many years and recently reiterated in California versus Texas, the injury for standing purposes must be traceable to the allegedly unlawful conduct, that's a quote, of the defendant. Nothing that Texas Right to Life or John Seago has done here is illegal. Saying that they support SB 8 is not illegal. Saying that they think abortion is wrong is not illegal. Advocating for the legislature to pass SB 8 is not illegal. Creating a website that asks people to submit evidence of violations of the law is not illegal. And even assuming that SB 8 was completely unconstitutional, if Texas Right to Life or John Seago were to bring a lawsuit under SB 8, which they've said they don't plan to do in front of any of these plaintiffs, but even if they brought a lawsuit and SB 8 was totally and completely unconstitutional, that still would not be an illegal act, because Texas Right to Life and John Seago, like everyone else in Texas, has a constitutionally protected right to petition under the First Amendment of the US Constitution and the open courts provision of the Texas Constitution. They have a right to bring a claim under a duly enacted law by the legislature, and that is not an illegal act. So all of these things that the plaintiffs have accused the defendants of doing to cause their injuries are not illegal. In fact, they are protected by the First Amendment of the Constitution. And that's why we brought those TCPA motions, Your Honor, because the whole purpose, the whole underlying basis for their claims and their lawsuit against Texas Right to Life and John Seago is their constitutionally protected activity. And that's exactly what the legislature enacted the Texas Citizens Participation Act to prevent. But going back to the standing question, the redressability issue. As the United States Supreme Court made clear recently in California versus Texas and in the federal heartbeat litigation, courts don't enjoin statutes, they enjoin people, and more precisely, they enjoin people from enforcing statutes, usually government officials. Thus, for plaintiffs' requested relief to redress their injury, it must effectively prevent the person causing their harm from doing so any longer. The relief they want here will not do that. Planned Parenthood admits that any relief this court can give would only apply to the parties here. That leaves everyone else in the world able to sue the provider plaintiffs if they violate the law, and to sue the aider and abettor plaintiffs if they aid or abet an illegal abortion. That does not rectify any chill leading the providers not to provide post-heartbeat abortions. And it doesn't give the plaintiffs freedom to violate the heartbeat law. fact, this relief would be completely meaningless because Texas Right to Life and John Seago, again, have already said they don't have any intention of suing these plaintiffs at this time. And a related thing that the court should consider with regard to standing is that the plaintiffs have also brought a claim under the UDJA. But the UDJA itself, as the Texas Supreme Court said in Chenal, does not confer standing in and of itself. So there must be standing to bring claims before a UDJA action can be brought. So they can't bring a UDJ action and claim that that itself gives them standing. That's not the case. They have to have standing first. They don't, therefore they can't bring a UDJA claim.
Wouldn't a declaratory judgment help them stay in business? That's what they want to do.
No, Your Honor, it
And
would
it
not.
might be ignored, but it might be followed by some people.
It would not help them stay in business because they would not, they've never said, and I believe it's just true as a fact, that they would not, if the court issued a declaratory judgment against Texas Right to Life and John Seago, the provider plaintiffs would not start providing post-heartbeat abortions. And I think another way that you can tell that that's true, Your Honor, is that the Planned Parenthood providers are the only providers suing Texas Right to Life and John Seago. There are a lot of other abortion providers in Texas that are not suing Texas Right to Life and John Seago. So I think that indicates, number one, that Texas Right to Life and John Seago aren't preventing anybody from doing anything. That is the law itself that's having that effect, which Texas Right to Life and John Seago are not responsible for. But also the fact that these other providers are also not going to provide post-heartbeat abortions, regardless of what happens in this case. I would find it extremely surprising as a business matter if the provider plaintiffs would start providing post-heartbeat abortions because they got a judgment against 2 people out of an entire state of millions of people. And again, there's no evidence in this record that if they got that relief, they would start performing abortions again. Now, Your Honor, oh, go ahead. Oh, sorry. Your Honor also mentioned the standing provisions of the heartbeat laws as being related. As Mr. Stevens said, I think that those provisions are more properly considered in the context of the merits of whether or not SB8 is constitutional and not as a jurisdictional matter. But I'm happy to address that issue right now if the court would like.
Yeah, I think that's right. I just thought the concept of standing ought to be dealt with together instead of scattered all over the place. Yeah. Go ahead and finish it on from the other side.
Okay. Well, if the court wants to hear.
On your challenge with their standing.
Okay. I think that was about all I had at this time, Your Honor, but I would just encourage the court to think in terms of the fact that the defendants are not the right defendants here. They have not caused the injury that the plaintiffs claim they are suffering, and the relief that this court would grant would be completely ineffectual to rectify the injury that they are claiming here. So there's no standing under established long-standing precedent of the Texas Supreme Court and of the U.S. Supreme Court.
Your Honor, may I approach?
Yes.
Which side is the approach to? I know you're stuck in a box. And then I have this here on where on the PowerPoint. Your Honor, I'm going to address the first issue that we wanted to talk about, which is whether our clients have standing. And then the second will deal with the challenge to SDA itself, and that it doesn't require standing. I do want to correct just a few things, and then we're gonna see how good Mr. Anwar is here, because we're gonna jump to the evidence, which is actually at the end of this presentation. I just want to note for the court, it's been said several times now that our clients, the 13 non-Planned Parenthood plaintiffs, have never offered any evidence of injury in fact, and that is just patently not true. The defendants seem to believe that this court cannot consider anything on file when it considers the Rule 166A MSJ. Rule 166A allows the court to consider anything that is on file prior to the before the court hears the MSJ, and with leave of court to consider anything that is on file after. Our clients' original declarations in support of the TROs, which were all 3 contested hearings, where defendants appeared and made basically the same standing argument to the Travis County judges. Those declarations were offered into the record at each of those TRO hearings. All of those TROs were granted. They each contain findings about imminent injury, irreparable harm, and a reasonable belief that our clients fear lawsuits under SB 8 from the defendants. Those are also in the record. They were entered by the court. The declarations, the original declarations of our clients were also attached, as Ms. Eklund noted, as Exhibit A to the agreed temporary injunction that you entered 12 days ago. That agreed order was agreed as to form and substance. That doesn't mean that the defendants waived their right to make defensive arguments, but it does mean that they agreed to the findings in substance that this court included in that order. Those findings, again, say that this court found imminent harm, irreparable injury, reasonable belief, and fear that lawsuits were coming. It also contained an express finding that there was a Declaratory Judgment Act claim as to the constitutionality of SB 8, and that our clients had presented a likelihood of success that SB 8 violates the Texas Constitution. In response to the TCP motion, as your Honor knows, we provided a very lengthy appendix of evidence. We did that not because we think that there's actually a need for this court to look at all of that evidence, but we all know this is going to go up on appeal. And with respect to the TCPA, we have to respond to the arguments that they're making. They challenge standing there again, even though that argument's already been rejected. So we put in all of the evidence related to standing. Again, that evidence also contains the temporary injunction, the original declarations, the TROs, and supplementary declarations from several of our plaintiffs who are aware that after Judge Pittman entered an injunction requiring the state of Texas not to enforce SB 8, that there was a 48-hour period during which post-cardiac activity abortions occurred. Several of our plaintiffs have now admitted publicly and in sworn testimony that they are aware those occurred and that they helped facilitate them. Those are in the record as well. The idea that we have not established standing at this point, again, I'm going to echo Ms. Eklund and Ms. Murray. It is borderline frivolous at this point to assert that our clients, whose entire existence is based on helping Texans access abortion care, and who have, since SB 8 was filed and became enacted, have actually admitted to performing an abortion that under the terms of SB 8 is illegal, that they do not have standing to say SB 8 itself is unconstitutional and cannot make my activities illegal. Your Honor, I'd like, if I could, since we gave you so much evidence, I've given you a notebook that has a copy of what we were calling our opening presentation, but given how the court wants to operate, we're gonna jump around.
I didn't realize I was
No, it's absolutely fine. Again, we have very capable people who will help me. And so what I'd like to do is, the first part of the presentation actually goes to the legal challenges to SB8, so I'm going to jump to the second half. And just highlight for you some of the evidence that's already in the record that the court can absolutely consider. And actually, before I do that, let me make this clean. I realize that the defendants have filed objections to our summary judgment evidence. I know we're going to hear those later. I would ask the court to take judicial notice of everything that's already in the file in terms of what has been submitted, including everything that was submitted in the 13 original cases that have now been transferred over here.
Judge, to the extent she's trying to supplement the summary judgment record with evidence that was never offered in support of summary judgment, we object. And to the extent she tries to rely on it, we strike any of that evidence. I can tell the court exactly what she offered in support of a motion for summary judgment because it's listed in her summary judgment motion. For her to now come in and try to say that she gets to supplement the record with, whatever evidence or allegations it may be isn't supported by Rule 166A. She needed to provide that with her summary judgment motion, which she didn't do.
Your Honor, actually, Rule 166AC says that court can consider anything on file. And to the extent you're suggesting that we didn't incorporate it, there's a footnote, it's footnote 9, where we incorporate the declarations in support of the temporary restraining orders. We were required to identify anything that is not already on file with the court, which we did.
Judge, I'm probably looking at the same thing you are in Congress on page 714. It talks about summary judgment evidence. Pleadings is proof. As a general rule, pleadings are not summary judgment evidence. Laidlaw Waste Systems versus City of Wilmer, Texas Supreme Court, 1995. Hidalgo versus Surety S&L Association, Texas Supreme Court, 1971. Petitioner answer.
Now I'm looking at 166A sub C. Let me finish reading this.
Okay.
Convinced me that I shouldn't be limited to what he singled out for this hearing. Does refer to pleadings, admissions, affidavits, stipulations.
Here, I actually have a Texas Supreme Court case from 2018 that that says that evidence submitted in a temporary injunction setting was on file for purposes of their summary judgment motion. They approach.
Yes.
It's Lance Robbins. This is Fox.
Lance versus Robinson, 543 Southwest 3rd, 723 Supreme Court, 2018.
You're right, I would also, I'm sorry.
I think I want to go ahead and use our time today. Go ahead and let you all argue. And when it gets to decision time, whatever rulings I make, both sides can look at them and we can argue then about whether I've relied on something that's not admissible and I'll just deal with it at that time. I think that's a better way to do it. Go with saving objections to the end. Just get the arguing done. And I just think that's a better use of our time today. So I'm just going to carry that along. Okay. Go ahead.
Real quickly, judges, with that ruling, is it acceptable to the court if we just have that a running objection so that we don't have to make the objections anytime evidence?
I'm going to do what I said, which is make these decisions based on the proper record. And I think it would help me if it comes to that, to let people single out whatever disputed evidence there is. And if it's important to me, and that's one thing, if I think it's inadmissible, I'll just deal with that then. And it's certainly my intention that you be able to make that objection throughout. You clearly made it, and
Thank you, Judge.
Thank you, Aaron. And I also just wanted to note the standing arguments made in the context of the TCPA motion as well. And obviously, we're allowed to attach evidence to our TCPA response. I just want to make it clear that some of this evidence was attached to the TCPA response. Some of it was attached to the summary judgment.
understood that the summary judgment record, the TCPA record, and including the jurisdiction record, those may differ. Time to deal with that is at decision time, not in the middle of this hearing.
Thank you, Your Honor. And so I do want
By the
to.
way, we don't even have to have a record. There's no requirement for oral argument to be reported by the court reporter for what that matters. I wanted it for this case for obvious reasons, but at the time that I make rulings and sign orders, we need to have a discussion about the evidence and so forth that my rulings are based on, and be clear about the record, and I will make every ruling that anybody wants me to make at that time. I just think it's better use of our time today to have the arguments, not deal with it.
Thank you, Your Honor. I'm gonna try to make this PowerPoint useful for you. And I'm gonna skip to the evidence, because since we're talking about whether our clients have standing to go forward, again, we've put a tremendous amount of evidence into the record in response to the TCPA motion, in particular, but also in response to summary judgment.
Let me just say, it's easier for me to read this as layer. That way, don't worry about that, because I've got it right here.
Okay, terrific. And so what you have before you, Your Honor, and I think if you hop to page 36, what we're endeavoring to do with this, what I hope is final binder we'll give you, is highlight for you the key evidence from all of the evidence that's been submitted. So the first has already been discussed at length by Ms. Eklund. It is the agreed temporary injunction that you entered 12 days ago. Attached as Exhibit A are the supplemental, or are the declarations of our clients that speak to the current injury that is being inflicted on them, which is that they cannot go forward with their business as usual because SB8 creates the ability for the defendants to file lawsuits and hang over their heads financially. They're doing nothing more than their normal business. So there are 12 of those declarations, Your Honor. Again, those were first submitted in support of the TROs that were before the Travis County courts. And all of those TROs have the findings we've already discussed. The court there found our clients will be imminently and irreparably harmed. Our clients reasonably fear the defendants and those they act in concert with will file claims against them under SB8. That is the harm that is being posed by the defendants here. There are 12 of those. Those are tab 2, Your Honor. Tab 3 are the supplemental declarations I mentioned a moment ago. They were provided in our response to the TCPA motion. Again, to deal with this assertion that no post-cardiac activity abortions have been occurring. That is just not true. When Judge Pittman entered an injunction in early October, there was a 48-hour period where those abortions occurred. It was widely reported in the media, and several of our clients have firsthand knowledge that those abortions were occurring and actually assisted in getting Texans access to those abortions. There is no doubt, even the declarations they've now put in say we would only consider suing if people are not complying with SB 8. Our clients have now admitted in open court, in sworn testimony, that they are not complying with SB 8, that they did not do that while that injunction was in place. And so even under their theory of the case, which candidly is also wrong, because the threat of harm is sufficient for an injury, we've now established that the condition precedent to them not bringing lawsuits is false. Exhibit 4, Your Honor, is Mr. Sego's declaration in one of the federal lawsuits that he put in August, so before these lawsuits were filed. And frankly, it's the reason that
Why don't you tell me what page of your PowerPoint that is?
Oh, I'm sorry. 47. Everyone is telling me it's 47. Frankly, the behavior of Mr. Sego and Texas Right to Life's behavior in August is what prompted them to be named as defendants in this lawsuit, which now only seeks a declaratory judgment on behalf of the non-Planned Parenthood clients. We are supposed to name people as defendants if they have an interest in the declarations that we are seeking. Mr. Sego put in sworn testimony in August in another matter that said Texas Right to Life is publicizing the availability of private civil enforcement lawsuits through social media and other forms of advertising. And we are encouraging individuals to sue providers and funds if they defy the law. They have an interest in whether SB 8 is constitutional. They made that interest known before these lawsuits were filed. This is, I believe, August 5th was when Mr. Sego put this in. And the encouragement that he's referring to is the whistleblower website, which is a website that Texas Right to Life created and hosted that was soliciting information and tips and people to bring these lawsuits. This is their own website. It is their own admission, their own statement. This came online in August as well. I'm at slide 88. They were asking people to give them information so that they could organize lawsuits. Our clients took them at their word that they were going to be the people who filed lawsuits under SB 8. They took them at their word because Mr. Sego advocated for SB 8. Texas Right to Life has proclaimed it as their own victory that SB 8 was enacted. They've said that they're the enforcers of SB 8. They clearly have an interest in whether SB 8 is actually constitutional. And the only claim before you for our clients right now is a declaratory judgment. There are two elements for a declaratory judgment. The first is whether there is an actual controversy between the parties. There is. Our clients think that SB 8 is obviously, patently, facially unconstitutional and is therefore void. And is actually not a law because it's void. Because Legislature cannot enact a law that violates the Texas Constitution or the federal Constitution. The defendants clearly disagree with that. They believe SB 8 is constitutional. They've now put in a response on the merits, saying why they think we're wrong. They thought SB 8 was constitutional before we filed the lawsuit. They were encouraging people to file lawsuits underneath it. If they didn't think it was constitutional, they wouldn't be doing that. They're still claiming it's constitutional. They're still out there saying that even if you provided an abortion or gave access to help someone get an abortion while a federal judge had an injunction pending, you are violating SB 8. There's just no dispute that there is a controversy and it's live. Second element is, can that controversy be resolved by the court? Will a declaration from this court resolve the controversy of whether SB 8 is constitutional? Your Honor, a court of proper jurisdiction is the only place where that controversy can be determined. And the Declaratory Judgment Act specifically authorizes this court to make that declaration and declare what the respective rights of the parties are, and to allow our clients to challenge the constitutionality of a statute. As to the idea that what this court does is meaningless, and so there's therefore no standing, I think what this court does matters greatly. I think a declaration by a court that a law is unconstitutional is the proper means by which to get the relief we need. It is this court's duty and job to declare what the law is. And I honestly don't know how to respond to the idea that a judgment that you might render here is meaningless. Of course it's meaningful for a court to determine whether a co-equal branch, the Texas legislature, has enacted a law that is void because it violates the Constitution. Of course it's meaningful. And our clients are the right parties to be here. Their rights are impacted by SB 8. The defendants, through their own admission, worked on SB 8. One of their counsel wrote it. They've been talking to the media for 2 months about what a victory it is, that SB 8 is in place and abortions aren't happening. And they specifically said they're going to target people who violate SB 8. I honestly don't know who a more proper defendant is in terms of making sure that the declaration that we're seeking actually has an impact and they have the right to be here to argue why we're wrong. I also just want to note, Your Honor, so tab 6 are the admissions by the defendants and various websites. Actually, not various websites, they're all admissions from their own websites, I believe. And then I also want to just note for you that, as you know, SB 8 is being challenged in many different places. And it was just before the US Supreme Court 10 days ago in 2 cases. In one of those cases, the Solicitor General for Texas said that a declaratory judgment claim is the proper means by which to challenge SB 8. It's tab 7, Your Honor. And it's not the entire transcript. We did put the entire transcript into the evidence that we submitted to the court. Now I'll try to get you the page number in the presentation as well. As soon as I can find that specifically for you, I'll direct you to it. Your Honor, in the second case, one of defendant's counsel actually appeared, Mr. Mitchell did, where he also discussed SB 8. And in briefing in that same case, which we've also highlighted for you in the motion, in the response to the motion, Mr. Mitchell says that the constitutionality of SB 8 has to be decided between private parties because it was designed to not allow you to sue government agencies. So it has to be decided between private parties. He went on to say, and this is up on page 95 of the presentation, if there's a danger that a private individual might sue someone under an unconstitutional law, then the remedy is to pursue an anti-suit injunction. That is what we've done. We have done exactly the thing that defendant's counsel told the US Supreme Court is the right thing to do. For all these reasons, Your Honor, we think standing's been resolved multiple times. And I'm happy to continue discussing any questions you might have. But at the risk of beating the dead horse, I'm going to sit down if you don't have any questions.
You have anything to add, Ms. Murray? Anybody?
I do, Your Honor.
Oh, Your Honor, may I just say it's page 77 is where the Solicitor General's discussion about the private parties. My apologies, Ms. Murray, I didn't mean to step on your time.
Thank you, Your Honor. I'll try to be brief, but I do want to respond to a number of the arguments made by Ms. Hacker, in particular, the ones that focused and targeted the Planned Parenthood plaintiffs, my clients. So to start, Ms. Hacker says that we have sued the wrong people and that Mr. Sego's just a guy who's being sued because he happens to be pro-life. That is simply not true. Planned Parenthood, certainly I, and on behalf of my clients, we understand that people come to the issue of abortion care with a variety of views. People are free to support abortion access or to not support it. They're even free to support SB 8 and think it's a good law, or to think, as we do, that it is an unconstitutional law that is violating people's rights. What they are not free to do is threaten to enforce an unconstitutional law against my clients that has the effect of not only threatening a constitutional violation to my clients, but to actually violating the constitutional rights of thousands of pregnant Texans who need abortion, and because of SB 8 and these threats, cannot obtain it today and have not been able to since September 1st, with the exception, as Ms. Myers mentioned, of a couple of days when a federal injunction was in place blocking SB 8. During that time, of course, two of my clients, the Planned Parenthood Greater Texas Surgical Health Services and our Planned Parenthood Center for Choice affiliate, it has been reported, and we have this in the record, that both provided abortions during that period of time under the protection of the federal injunction that, of course, was lifted by the U.S. Court of Appeals for the Fifth Circuit. So it is not the case that Mr. Sego and Texas Right to Life have been sued here solely because, or at all, because they are, we are not, and I do want to make clear where the Planned Parenthood plaintiffs stand on this. We are not suing Texas Right to Life and Mr. Sego because they advocated for adoption of SB 8. We are not suing them because they have talked about SB 8 in the media. And we're not suing them because they have decided to retain counsel who may, or it has been reported, was the architect of SB 8. We are suing them because they have threatened to enforce SB 8 against the Planned Parenthood plaintiffs. And I know Ms. Myers had some of these threats, but with respect to our clients in particular, I do want to direct you to some of the evidence that's in the record. There are a number of Texas Right to Life statements and statements by Mr. Sego that were attached as exhibits to the Muniz declaration in support of our motion for summary judgment. Those statements include, on July 14th, Texas Right to Life's president publicly declaring, quote, "And after the Texas Heartbeat Act takes effect, we're going to sue the abortionists ourselves," end quote. Then I'm sure, let's see, the Exhibit 6 to the Muniz summary judgment declaration, Mr. Sego told CNN, quote, "If we do have reports that we do see evidence that they're violating the law," referring to abortion providers, "then we can actually enforce the law ourselves." It is simply not the case that Texas Right to Life and Mr. Sego have not threatened to enforce SB 8 against my clients, who, again, as I mentioned earlier, operate roughly half of all facilities that provide abortion in the entire state of Texas. It is just not credible to say that they didn't have Planned Parenthood in mind in thinking about how to enforce SB 8. And nothing that they have submitted to this court has changed or disavowed that intention. I would direct Your Honor, for example, to the declaration by Ms. Cook, who is the general counsel for Texas Right to Life. She submitted a declaration in support of the opposition to our motion for summary judgment. And at paragraphs 12 and 13 of that, she says, "Texas Right to Life fully expected that each of the plaintiffs," so that's including my clients, "would comply with the Texas Heartbeat Act." When they filed their lawsuits in late August and early September, "No rational abortion provider would subject itself to the risk of civil liability under Senate Bill 8. And then she goes on to say in paragraph 13, "For these reasons, Texas Right to Life has never had any intention of suing any of the plaintiffs under Senate Bill 8. But that's not saying that they will never sue any of the plaintiffs. It's saying we won't sue you if you do exactly what this law is designed to do, which is to violate your constitutional rights and the rights of patients by not providing abortion care." We would not say, for example, imagine if Texas had passed a criminal abortion statute. It would be no answer to a criminal abortion statute if our clients had challenged that and sued, for example, a local prosecutor. For the local prosecutor to come in and say, "Well, Your Honor, we're not going to, charge them with a felony crime so long as they comply with the law." Of course, that wouldn't be sufficient to effectively insulate yourself from suit. And I would say also to this point about Mr. Sego, and Ms. Hacker says that it is simply unfair that Mr. Sego might be subject to attorney's fees in the event he loses this case. But of course, it goes both ways, Your Honor. Mr. Sego and Texas Right to Life have threatened to enforce SB 8 against our clients, which, as Your Honor well knows, would stick our clients with unrecoverable costs to defend themselves in that litigation. And potentially, if they were ultimately held liable under the rigged scheme that SB 8 creates, to pay Mr. Sego's attorney's fees as well. So it is just not the case that there's something unfair about bringing claims against Mr. Sego and Texas Right to Life, who have very clearly threatened to sue our clients. The second thing that I wanted to address was Ms. Hacker's statement that Your Honor's ruling would be meaningless. And because we represent the abortion providers, I do want to be very clear about the impact that we think that declaration would have. As we said in support of the motion for temporary injunction, it is true that an injunction against Texas Right to Life and Mr. Sego only will not address all of the harm that our clients are suffering, because as Ms. Hacker said, millions of people could still sue them. And I would note it is not just limited to Texas. It is anybody anywhere in the country who could sue our clients. So it is true that that is not going to address all of their injuries. But it's also the case that under well-established standing law, you don't need to show that the declaration you're seeking or the injunction you're seeking would prevent all of the injury of which you can complain. So long as it is addressing that injury to an appreciable extent, it is, there is standing for the court to enter a judgment. So as to final resolution on summary judgment, our position is that, one, that declaration would bind Texas Right to Life and John Seago, who have been among the most vociferous, who have made some of the most clear threats of suit against my clients. They say that there's no harm because under SB 8, you could only recover $10,000 once. But of course, that ignores what is the threshold harm of SB 8, and that is the threat of enforcement in the first place through these harassing proceedings. So a declaration of SB 8's unconstitutional nature running against Texas Right to Life and Mr. Seago would provide valuable relief to my clients because it would mean that Texas Right to Life and Mr. Seago could not sue them and force upon them the litigation costs of having to defend themselves in SB 8 lawsuits involving those defendants who would be SB 8 claimants. The other thing that they ignore is that, of course, a declaration, as Your Honor has recognized, can have persuasive effects more generally. It is true that some people may not honor a declaration of invalidity against someone else, but lots of people would, and more importantly, some of their attorneys might as well. So I do think that it would have both an appreciable effect in removing an actual concrete injury to our clients from Texas Right to Life and Mr. Seago. It would have a persuasive benefit more generally because of the value of the declaration. And of course, if this, Your Honor has, and I think all would recognize that this case is going to go up on appeal. And of course, whatever the Texas Supreme Court does, its statements about SB 8's constitutionality or unconstitutionality would bind courts throughout the state. And that, of course, would have much greater effect, even if it is not an immediate impact. So I do think that a ruling is valuable. It would help our clients get back to focusing on the work that they do and are trained to do to care for patients in need of abortion throughout the state of Texas. And then the final point that I would make is with respect to Ms. Hacker's arguments about the declaratory judgment claims. So it's just not true that a court can't consider constitutional invalidity as part of a declaratory judgment action between private parties. And that makes good sense, right? I mean, if you had, for example, a law that said Mr. Kaplan could take Ms. Myers' house, she wouldn't have to wait until Mr. Kaplan comes and tries to change the locks. It would be no answer to that law to say, well, yes, it's completely unconstitutional that the legislature did this, but you can't have a declaratory judgment between the private parties. Of course, that would be wrong, and it's wrong here too for the same reasons. So I do think that a declaratory judgment action is available here, even if Your Honor is thinking about Texas Right to Life and Mr. Seago as purely private parties. But as we have said in our motion for summary judgment and in our opposition to the TCPA motion, they are not, in fact, acting as purely private parties. It's not the case, as Ms. Hacker suggests, that if you treat them as state actors in this case, because they are performing an exclusive function of enforcement of abortion bans and sort of standing in the shoes of the state, or using the machinery of the courts to enforce an unconstitutional law, it's not the case that saying that is state action as it is would mean that any key TAM plaintiff, for example, or any other plaintiff relying on a private right of action would itself be engaged in state action. There is a well-defined standard for what constitutes state action when undertaken by nominally private people. And we go through that case law in our opposition to the TCPA motion. But it is just not the case that it would sweep in all of those other private rights of action as they suggest. SB 8 is a unique law, and this court can and should determine that its mechanism of essentially pushing enforcement onto the general public for anyone, no matter how untrained, how unrelated to the abortion, that is in fact conferring the authority to act on behalf of the state, and it should be treated as such. With that, Your Honor, those are the only additional points that I would make.
Take a 10-minute break.
All right.
Good to see you.
Do you know if there's a Coke machine downstairs?
There is. All the way by the cafeteria.
Okay, thanks.
Do you want anything?
I'm just gonna go get some more. It was fine. We left. It was only 1 hour time, but careful when you go in there. We left at like 7:20, so a little bit later than we wanted to. Because like traffic was so bad, and I was like, we want to stay late. So, and then we stopped every hour so I could get a 10-minute walk. Okay, so this week I was like 90%, which was like way so much more than I could do. And work. So you got a little rest. I know, she's all. Yeah.
Thank you so much.
Well, no, they don't. Yeah, well, y'all are taking, y'all are killing.
I saw your expression here a few times. You were like, you keep looking around and you're like, oh.
Well, no, I feel like. You're like, I'm going all out, I don't care.
Say how I feel. I've never even heard.
Never even Small, 30. That's my jet.
It goes the same, second good jet. It goes the same.
Oh, that's good. Oh, nice.
Driveway. That's not at the
If you can either do, I'm coming back next. I know she's. Why are you looking at me like that?
No, that's not.
But I have to come back? Yeah. Yeah, so I, have it really, Dan's not being set.
Just because I haven't heard something.
A bunch of dance recording and it's like, hey, $10 or it's so I had a really different sheet for one. Like, and there's one probably like our work process. Yeah, it's been I try to tell my clients, so I you're gonna watch out, but I have a bunch of administrator, but they like, and so then and I'm like, it's been too much of a mess. Really need to get that happened once. It happened like 15 times. So we use it. No, well, no, but you have to let the business and our and our credit card, they don't address. We have to go in together. We're gonna get it.
Yeah, we had to go into the.
I can't get these ads to
Would you ever do that?
So I'm just like,
Make sure you're.
yeah, exactly. Get on the bank account.
You just. Yeah, I'm gonna refill on water.
Thank you so much for. Oh, absolutely. Nice to meet you.
Just a couple of brief responses, Your Honor. There were two very important things that were absent from both Ms. Murray and Ms. Meyer's presentations. The first thing is that I didn't hear anything explaining how a single thing that Texas Right to Life or Mr. Seago has done would be legal. Nothing that they've described to this court as to the reasons why Texas Right to Life and John Seago have been sued. None of those things are illegal. That is required under the standing analysis. Again, I direct the court's attention to Texas Supreme Court 2018 Myers versus J.D. Firethorn, U.S. Supreme Court California versus Texas. Their injury must be traceable to unlawful conduct of the defendants. Everything they've said that Texas Right to Life and John Seago have done is not illegal. And not just that, it's actually affirmatively protected by the Constitution of both the United States and Texas. All of that is protected First Amendment activity, which again, not to preview coming attractions, but that's just what makes this a prototypical case under the Texas Citizens Participation Act. The second thing that I didn't hear anything about in either Ms. Myers or Ms. Murray's presentation that I think is fatal for their case is that there was nothing explaining how an order from this court would cause the plaintiffs to change anything about their behavior. They are not going to start performing post-heartbeat abortions as a result of anything this court will do. Their injury, therefore, is not redressed by any order of this court. Ms. Murray said that an order from this court, a declaratory judgment, could be persuasive upon others. That is the epitome, Your Honor, of an advisory opinion. Certainly anything a judge says may persuade others, may persuade lawyers, may persuade the public. But it is a long-standing factor of both Texas and federal law that judges do not issue advisory opinions for that very reason. What they're asking the court for is essentially an advisory opinion because it will not redress the harm that the plaintiffs say they're suffering, and it will not prevent any person other than Texas Right to Life and John Seco from suing the plaintiffs. An order of this court is not binding on anyone besides Texas Right to Life and John Seco. An order of this court is not binding beyond Travis County. And an order of this court will not redress the injury they say they are suffering by not being able to perform post-heartbeat abortions. Another thing I wanted to address is that Ms. Murray said that Texas Right to Life and John Seco have threatened that they will sue the Planned Parenthood plaintiffs. I believe that is a disputed fact, Your Honor, because in the declarations that Texas Right to Life and John Seco submitted, they said they had no plans to sue the Planned Parenthood plaintiffs. And I don't believe there's been any evidence presented to specify any threats made expressly against the Planned Parenthood plaintiffs. So to the extent we have competing declarations or contentions by the parties, that fact is essential for deciding this case, and that is a disputed fact that would preclude summary judgment. Another point that I wanted to address is that Ms. Myers said that she questioned how we could say that the plaintiffs don't have standing to bring this lawsuit. Your Honor, the plaintiffs are obviously very upset by this law. They are obviously upset by the actions of Texas Right to Life and John Seco, but that doesn't mean that they have standing to sue these defendants. These defendants have to be the right ones in this case. Now, as far as the references go to the argument in the US Supreme Court, I was there in the room, Your Honor, and I don't recall any admissions that anything going on in this case is the proper avenue or approving the validity of anything going on here. I would point out that a reference to being decided between private parties and whether that is the proper avenue for deciding this case. I believe that that would have been in reference to being asserted in a defensive posture. Because, Your Honor, that's a fundamental flaw in this case and the federal cases. It's because they're trying to do this in a pre-enforcement posture that they're running into these problems with standing. Certainly, if Texas Right to Life did sue one of the plaintiffs could raise all of their arguments about unconstitutionality in the context of that proceeding, and there would be no standing problems because the injury would be there, it would be ripe, it would be proper as to those defendants, at least not that I can think of standing here today. That is the proper posture for raising the arguments that they make. The problem here is that it's being asserted pre-enforcement, and that's how they're trying to sort of shoehorn this in to the existing standing doctrines, and that's why it just doesn't work, Your Honor.
Would it be your position that nobody would have standing to make a pre-enforcement challenge to this law?
I think it could be possible depending on what the facts are, Your Honor, but I think that based on the facts, I think it would be difficult, but I think, there could be a possibility that there might be facts that could allow for that. I don't think that those facts are present here, Your Honor.
Let me put an admittedly unlikely hypothetical. Suppose legislature decides to pass a law saying anybody who files to run against one of us can not do that unless they get pre-clearance from a committee we set up. And somebody who wants to run says, I'd like to run, and this is stifling my ability to talk, surely that person could go to court and get a pre-enforcement, pre-licensing declaratory judgment and or injunction, wouldn't you think? I mean, I find it hard to believe that where everybody agrees on the constitutionality or unconstitutionality of something like that, the law would deny standing to someone who truly is affected by it and who's holding back for fear of being sanctioned. I mean, it seems to be the principles you're arguing for would make that wannabe opponent of an incumbent legislator we get that person standing.
So I think I'm going to start with just a general principle, and then I'm going to answer your direct hypothetical as you've asked it. The general principle is that there is not a right, either under Texas law or federal law, for pre-enforcement review. And constitutional rights are often asserted defensively. But going directly to the hypothetical that you've asked, I think that would be different because there would be identifiable parties that are, right, there would be a candidate that's one person and there would be an opponent that would be one person. The person suing wouldn't be trying to get relief on behalf of a bunch of unknown people. I think the other thing about it is that if in fact that would be clearly unconstitutional, which it sounds like it would be to me, then
It's being enforced by private people that have an incentive to do it.
right, then
Could be.
I think if I'm understanding the question properly, then I think that would certainly present different facts, but I would also point out the fact that there wouldn't really be any reasonable fear of enforcement that could cause any liability because the law is so clearly unconstitutional.
Well, I
So,
guess I could add to the, my high flow that any person could be authorized to sue and get damages. If somebody doesn't go through the licensing scheme, that kind of thing. And if you transplant these rules, these procedures to other areas, it just seems troublesome to me that there would be no standing for someone. And in this case, I don't remember the doctor's name. One of the plaintiffs is a doctor who says I perform abortions. Why wouldn't he have standing if he says I've been stifled and chilled by his law?
because his chill is not being caused by Texas Right to Life and John Seco.
But would he have standing to seek a declaratory judgment issued to the people of Texas?
No, because a declaratory judgment under the statute cannot be issued as to parties who are not made, or to people who are not made parties to the proceeding.
And they've named, I think it was 100 people. They don't know their names, so they call them John and Jane Doe, I think. And stand-ins. Would that not be a way to issue it to people who might want to bring one of these SBA lawsuits?
No, Your Honor, that would violate due process because John and Jane Doe's 1 through 100 are not parties to this proceeding and have no notice of any judgment being entered against any of their rights.
Thank you. Go ahead.
So one quick point about Ms. Meyer's presentation. She said several times that this is a void law, but that is a misstatement of how the law works. I believe it's the writ of erasure fallacy. A judgment of the court does not declare a law void, does not remove it from the books, does not erase a law. All it does is prevent enforcement of an unconstitutional law, which is why redressability is such an important factor to consider in whether the court even has jurisdiction to entertain these challenges. Ms. Murray's example of this being in a criminal law context, that you know, we would expect people to be able to raise a pre-enforcement challenge there. I would say that situation is factually distinct, and I think there's a lot of case law on this point that because of the fact that if you're being threatened with prosecution, first of all, the case law says that there has to be an imminent threat of prosecution. And also there's a presumption that applies to district attorneys or state officials that they will in fact enforce the law. So I think that example is of limited relevance to a case involving a private right of action. So I guess just to sum up, Your Honor, I would reiterate my point earlier that the Texas Right to Life and John Seago are not the right defendants here. The court does not have standing, or the plaintiffs don't have standing, and the court does not have jurisdiction because nothing they've said has explained to the court how there is causation under the law, because nothing Texas Right to Life and John Seago have done is illegal. Certainly the plaintiffs don't like what they've done, but that does not make it illegal, and in fact it is protected by the First Amendment. And also we've heard nothing from them to explain how they would change their behavior to eliminate their injury, which they say is not being able to perform post-heartbeat abortions, if this court issues an order in their favor. Persuasive authority from an order of this court is not a reason to exceed the court's jurisdiction under the Texas Constitution. And asking the court to issue an order that's not binding on anyone else because of its purported persuasive effects is the epitome of an advisory opinion. And the court should resist that temptation.
Very briefly, then we'll move on to something else. We've got to pace ourselves.
Thank you, Your Honor. I promise I'll be brief. I won't even go to the lectern. With all due respect to Mr. Mitchell, who wrote the law review article that Ms. Hacker just referenced, the Texas Supreme Court has said that a legislative act that violates the Texas Constitution is void. The Texas Court of Appeals in Dallas in 1987 said the same thing. As recently as last year, the Texas Court of Criminal Appeals said the same thing, and then the Texas Supreme Court said it again. It is just absolutely not true that the legislature can enact a law that violates the Constitution and have that law be valid. With respect to the elements in standing for declaratory judgment. Again, there are only two elements for a declaratory judgment. An actual controversy as to the rights and status of the parties, that a declaration will actually resolve the controversy. There is clearly a controversy between the parties before you about whether SB 8 is constitutional. Your declaration can resolve that controversy. Specifically with respect to standing under the Declaratory Judgment Act, plaintiffs must show a particularized, legally protected interest that is actually or imminently affected. Our client's interest is being affected right now. They are having to change their behavior because SB 8 unconstitutionally exposes them to financial ruin, which the defendants are very happy about. It's not as if the defendants have come in here and said, they're right, SB 8 is unconstitutional. We will not ever bring a claim under SB 8 because it is unconstitutional. What they've come in and said is we'll do exactly what we want as long as you do what SB 8 tells you to do. You can't moot an actual controversy by coming in and saying, well, don't worry, I won't do the thing that you're worried about as long as you do the thing that I don't want you to do. You look at standing as of the time the lawsuit was filed. At the time it was filed, all of the evidence in the record, including Mr. Seago's declaration and all the admissions from Texas Right to Life's website, indicated that they were going to sue under SB 8. They can't now come in and say, well, as long as you just do what we want. We didn't mean that. Of course they mean it. It's why they haven't come in and said, absolutely on the record, we will never sue under SB 8. One issue with respect to the actual harm inflicted, Your Honor. Again, deprivation of a constitutionally protected right is a harm. The imminent threat is injury in fact. Frankly, Mr. Mitchell conceded that in briefing in the federal court system as well. He said it's an injury in fact under Article 3 to have your constitutional rights chilled. The idea that he's going to say that in federal court and then come into the state court and say, actually, it's not, and I realize he's not here, but you can't put in those competing assessments of the law. In terms of the actual immediate financial threat, Ms. Murray was correct in her presentation when she talked about the financial burden of having to defend against invalid, frivolous lawsuits that are created solely by a statute that violates the Texas and US constitutions is a real financial harm. It exposes these plaintiffs and her clients to financial ruin, which Mr. Sego and Ms. Cook have said in their declarations. They don't expect anyone would violate SB 8 because of the financial ruin imposed. That is a real harm. I neglected to mention to the court a harm that is being imposed separately from that, which is there's a provision of SB 8 that is codified at the Texas Civil Practice and Remedies Code, section 30.022. And we'll talk about this more when we get into the constitutional challenges. That provision makes any person who seeks a declaratory judgment that any abortion regulation, including SB 8, is in fact unconstitutional. It makes them liable for the other side's costs and fees. It also makes any attorney who deigns to represent them in a pre-enforcement challenge jointly and severally liable for their costs and fees. Literally every person before you on this side of the courtroom is subject to a claim for fees that they are seeking. They ask for it in their TCPA motion. They invoke a provision of SB 8 against our clients and against us. The idea that there's no harm being caused, again, it's hard to fathom how that's possible. I forgot my other points, Your Honor. So I'm gonna sit down.
Your Honor, so I just have 3 points, and I will try to be brief. Ms. Hacker said there's a general principle that you're not entitled to pre-enforcement review of a constitutional challenge. I would direct Your Honor to In re Abbott, which we cite in our briefing. That's 601 SW3 3rd at 812. And that makes clear that plaintiffs who are seeking pre-enforcement review of a challenged law can do so where they have an intent to engage in a course of conduct that's constitutionally protected but proscribed by the challenge law. Each of our clients, the Planned Parenthood plaintiffs, have an intent to engage in the provision of needed abortion services to Texans, but for SB 8. And those services are constitutionally protected both by the federal constitution and the state constitution. The second point that I would make in response to Ms. Hacker's presentation, she said a couple of times, the plaintiffs have said they're not going to change their behavior, but that is not the analysis for standing. This court's opinion would not be advisory, and it would not just have a persuasive value to others. Although I will say, as to persuasive value, again, I would direct your court to a case that we cited in our briefing, Steffel v. Thompson. That's a U.S. Supreme Court case, 415 U.S. 452, in which the U.S. Supreme Court recognized that declaratory judgments, of course, can have persuasive value beyond the parties who are actually in a lawsuit. But even if you set aside the persuasive value of the declaratory judgment, Ms. Hacker does not dispute that her client's behavior would be changed. They say in their declarations, oh, we're not planning to sue your clients because we know they're going to comply. For that reason, we're not going to do it. But of course, if your honor enters a declaration of SBA's unconstitutionality as against Ms. Hacker's clients and permanently enjoins them from enforcing SB 8 against my clients, that would in fact change their behavior by preventing them from something they have threatened to do. I would also direct your honor, we do have evidence in the record from the Planned Parenthood plaintiffs about the harm that comes not just from the threat of suits if our clients were to violate SB 8, but from the threat of suits even if they're trying to comply based on perceived violations of the statute. So I would direct you to Ms. Linton's, the declaration of Melanie Linton at paragraphs 14 and 15, and the declaration of Ken Lambrecht, for example, at paragraphs 18 and 19. Those declarations talk about the threat of harm that comes even if our clients are trying to comply with SB 8 because of the targeting of abortion providers and of course the very real possibility that untrained individuals, including Texas Right to Life and Mr. Sego, will perceive a violation even if there has not been one. And third, to your hypothetical, Your Honor, I think you are exactly right to be troubled by the possibility that if you transplant the procedures of this rule to other areas of the law, the argument made by defendants would still apply under Ms. Hacker's theory, and it would bar people from suing. I think at bottom what defendants are saying here is that because the state has made the harm so widespread, because it didn't say you local prosecutor, you can enforce this, or you 10 people can do it, it said millions of you, even if you're not Texans, you can come and enforce SB 8, that somehow that, because the threat of harm is so overwhelming that no one has standing to challenge it. Because of course, even if someone else, like Ms. Hacker said, you know, maybe someone else, if they had clearly threatened to sue the Planned Parenthood plaintiffs, maybe then you could have a pre-enforcement challenge. But that makes no sense under her theory, because of course, if in that circumstance, I'm sure they would still make the same argument that a declaratory judgment isn't going to bind the millions of other people who could sue them, and it's not going to stop those people from suing. So I think this pre-enforcement challenge distinction that the defendants are trying to draw doesn't work even under their own theory of the case. Their theory really would prevent any effective review of SB 8's constitutionality. With that, I have nothing further.
Let me ask you, Ms. Hacker or Mr. Stevens, that any person, in reference to anybody in Texas or beyond, places in the briefing, I think one was the reply to the summary judgment motion, the other was the TCPA motion. The statement was made that anybody in the world could bring one of these suits. That's the position, I think. Not any Texan or any American, but anybody in the world.
I mean, I think that if I'm not mistaken, I think that SB 8 says any citizen.
Says any person. And it makes a distinction on venue. It says, you know, you can sue where the defendant lives and so forth, where the event took place, or if the plaintiff is a natural resident of Texas, that person can sue in his home county. But that's a distinction between if any person is a Texan, they can sue in their county. That implies that other people wouldn't be able to, don't have a county to sue in. But twice in pleadings signed by Mr. Mitchell, the statement was elsewhere in the world or anywhere in the world. And I'm just wondering if that is your position.
Well, I would say, Your Honor, that any person means any person. That's what the statute says. This question, I think, goes to the merits of SB 8. But I will say that the idea that standing, so Texas law allows standing to be conferred by statute. So that's something different than what we're talking about here. What we're talking about is the constitutional standing issue, but under Texas law, the Texas legislature is free to confer standing by statute, and it has done that in several other occasions. SB 8 really isn't that unique in terms of creating a private right of action. It's unique in that it applies to abortion. But there's 100-year precedent in the Texas Supreme Court on the idea of private citizen, any citizen enforcement of a law. And that's discussed in our briefing, Your Honor.
I think I'd like to move to that part of the challenge to SB 8, that is standing of any person and the $10,000. But you briefed those pretty well. We have basically half a day left, and more than that, we go after dinner or through dinner. So and I need to leave some time for the motion to dismiss and the plea of the jurisdiction to be discussed. Whatever's left over on those that hasn't been discussed when we finish the summary judgment. So what issues do you all want to take up next? We go till about 12:15 and then break for lunch.
Your Honor, I'd argue that standing in terms of SB 8 is probably the next most logical issue because it involves some of the same case law and Texas constitutional provisions.
Let's go ahead and let me hear from you all first on that.
But just in terms of ordering for things that could be heard, we would be interested, Your Honor, in making sure that we get to talk about the non-delegation claim that's at issue in the summary judgment motion, which has some overlap with standing, but not entirely.
Okay. Go ahead.
In our binder that we provided you earlier today, there's in the slides, I just want to direct you to the language of the civil liability provision that affects standing under SB 8, just so that we have this as a reference as we talk. I think what was just discussed is relevant here more so than anywhere, which is that SB 8's provisions, including the civil liability provision at bottom, perhaps the most important one, challenge the integrity of our entire legal system. They do that by making our system of checks and balances out of whack. They do that by seeking to preclude judicial review. And the real issue with all of the constitutional challenges that we have brought on behalf of our counseling plaintiffs, the individual plaintiffs, and the abortion funding plaintiffs. The truth is that all of those challenges, if you superimpose them on any other issue, any other constitutional right, they would still be equally problematic. It doesn't matter whether it's abortion or it's the right to own a gun. It doesn't matter whether it's free speech or another clearly protected right. These procedures imposed on any constitutional right are unconstitutional for their own reasons. And that therein is where this question of standing becomes the most obviously important one. Ms. Hacker made the comment that the Texas legislature can confer standing at will. That is not accurate insofar as there's a qualification to it, which is that when the legislature confers standing, it must be within constitutional limits, which their own cases provide. The constitutional limitation has been interpreted by both the Texas and the United States Supreme Court. The United States Supreme Court, while considering Article 3 standing, which I concede is not the standing we're talking about here, but the TransUnion versus Ramirez case made very clear last year that there had to be an actual injury to a claimant for the courts to have the authority to hear the case. The same really is true under Texas law. There are certain very narrow circumstances in which the Texas legislature has conferred standing, but in those instances, there is always an injury. If you look at the key TAM provisions, which confer standing on folks to bring actions on behalf of the government, there is an injury to the government.
and the person is given the standing to take that injury and move on behalf of the government. The government also notably retains an interest at that point, which they have explicitly disclaimed with regard to SBA. If you look at taxpayer cases, the taxpayer has to demonstrate that they have in fact paid taxes and therefore can challenge the government's actions and how they've used those taxes. There has to be an injury to their constitutional rights regarding the use of their funds as a taxpayer. The only case cited by the defendants, which suggests that there doesn't have to be any injury whatsoever, is a 1915 case about a brothel in El Paso. In that case, the plaintiff did allege injury. The plaintiff alleged that it was a nuisance that was depreciating the value of their property, and the court said, you can confer standing. We look to the legislature to tell us what to do. In every case since then, and I would direct your honor to a string site that is in the Best Buy stores through Danucci versus Hagar case, which is out of the Austin Court of Appeals. The court goes at length, Judge Justin Howell, to talk about all the cases in which standing has been conferred and the exceptions to the general rule that there must be injury. And as he says in that opinion, the Texas Supreme Court has held that the legislature cannot set a lower standard than that set by the general doctrine of standing because court's constitutional jurisdiction cannot be enlarged by statute. Herein is the problem, Your Honor, is that the question of standing dovetails into the problem of separation of powers. And standing has to be enacted, even if it's conferred by statute, within constitutional limits. And the open courts provision of the Texas Constitution provides specifically that the courts will be open to individuals for injury done to them. There is no injury for an SBA claimant. There doesn't have to be. What SBA does is create a strict liability tort where any person, Texan or not, can go into court and claim $10,000 because they know an abortion has taken place. In fact, they can go into court 17 times if they know 17 people who had anything to do with that abortion. That's what this statute does. There is no injury whatsoever to the government or to the individual who's claiming it. And there's no requirement that there be an injury. That the Texas legislature cannot do under either the United States precedent under Article 3, which is informing of the Texas Supreme Court's decision-making in the process. But the Texas Supreme Court has held repeatedly that the legislature can confer standing within constitutional limits. And here we are way beyond the constitutional limits of requiring that there be an injury and requiring that the courts be open and requiring, frankly, that any random individual can, at the state's behest, but without the state's involvement, walk into court and somehow uphold the state's interests as it's laid out in SBA. That has never happened before. There's not precedent to rely on for this court to determine how and why that's problematic, other than what I've directed your honor to in terms of the constitutional requirements and limits that necessitate an injury take place. And the only exceptions that exist in terms of Texas law conferring statutory standing do not disclaim the requirement of an injury. SB 8 requires no injury or even connection to the abortion at issue. And the particularization requirement with regard to injury is really, I mean, I'll go down a rabbit hole if I go too far, so I won't. But the exceptions to the rule and the key TAM provisions, the taxpayer case, even the El Paso case from 1915, is the question of whether the injury has to be particularized to the individual, not whether there can be no injury whatsoever.
That statute in 1915 said any citizen.
I don't know the answer to that, Your Honor. It was an ordinance in El Paso that allowed it. I think it was any taxpayer in El Paso to raise it.
Okay, so it's an ordinance, not a statewide statute.
That's right. The other problem that I think is patently obvious on the face of this statute is that the state doesn't have the ability to confer standing or power that it does not have. While our challenges to SB8 in terms of the abortion funds and the individual and counseling plaintiffs do not take on the 6-week ban on its face, Supreme Court precedent for the United States is clear, and Casey and Roe very clearly demonstrate that a 6-week ban is beyond what can be regulated. The state has chosen to give the right to any person to go enforce this ban because they know they can't do it. They can't do it. It's an end run around the constitutional rights of women who need abortions, but for my plaintiffs, for the abortion funds, for the counseling plaintiffs, for the individuals, for the doctor, it's an end run around their own constitutional rights as well, which is detailed in our motion for summary judgment and our petitions, which include the right to free speech, petition, assembly, and so forth. New York Times versus Sullivan did say explicitly by the US Supreme Court that the state cannot do by civil statute what it can't do in a criminal context. And that is exactly what SB8 has attempted to do. The next problem in terms of standing with regard to the civil liability provision here is the $10,000 bounty or penalty, although it's referred to as statutory damages. We provided Your Honor with briefing, I believe, on the question of whether the $10,000 amount is more properly characterized as penalty or damages. And I believe the Supreme Court precedent in Texas demonstrates that it is more properly characterized as a penalty, but it makes another point with regard to standing. One is there's no injury. There's also no duty inherent in the statute as SB8 is written. So there's no way to calculate what a measurable damage would be. Rather than operating as a damages award, which would compensate for the non-existent injury, it is akin to a criminal penalty. In fact, it's a criminal penalty in excess of what a felon might receive. There's no way for the court to know how to adjudicate or measure damages since there is no injury requirement. And it's intended as a deterrent, not as compensation. I also think it's important in light of some of the arguments made last week in the United States Supreme Court on the issue of outrage, that we take into consideration that under Texas law, mental anguish damages are almost never recoverable and only in very narrow circumstances. I know the state of Texas has chosen not to appear before this court to be heard on the issue of whether this law is constitutional, but to that end, to the extent that it is meaningful, I would like to point out to the court that the damages associated with someone's mental reaction to knowledge of abortion would be very difficult to prove in any normal setting. SB8 does not require them to prove anything at all. It doesn't even require them to be damaged. It's an unconstitutional statute because it completely dispenses with the idea of standing in terms of our civil tort system. The standing issue is also problematic, as I noted before, with regard to the separation of powers under the Texas Constitution, and it can't be detached from that problem. Essentially, the legislature has displaced the judiciary, even by the argument that pre-enforcement review is almost never going to be possible, according to the defendant's theory of the case. It eliminates the judiciary's role in deciding what the law is. The Uniform Declaratory Judgment Act makes very clear that a court can decide a controversy about the constitutionality of the law as between two parties who are interested. And I'll leave the dead horse that we've beaten on the issue of standing to the side for now, but it cannot really be claimed that the parties on either side of this have an interest in the constitutionality of the law. The law is specifically written to evade judicial review, not only at a pre-enforcement level, but also in defensive posture. Because, as my co-counsel mentioned, every person who raises the issue of constitutionality and every lawyer who helps them to do it will be liable and responsible for the fees associated with the other side if they don't prevail on every single claim in their case. That's unheard of under Texas law or elsewhere, and it deprives clients of the opportunity to raise meritorious defenses without being worried about that burden. It also deprives those clients of counsel if they can't find someone who's willing to take that risk on with them. The legislature has also supplanted the executive with regard to standing here. Typically, the executive would enforce the law that the legislature puts forward. Here, that is specifically disclaimed. There is no involvement by the government in recovery. And so, as the defendants and their counsel have argued, there's no state defendant that is appropriate to sue in order to determine the constitutionality of this law. But the executive, in an ordinary case, would be hampered by an early injunction, because even though only the one party would be enjoined, let's say a district attorney, the decision that a court made with regard to constitutionality would have a ripple effect as to every other district attorney. That's the whole point of deciding constitutionality. Mr. Mitchell's writ of erasure fallacy conceives of a world where we don't take cues from the judiciary as to what is lawful conduct and what is not. And only those particular parties are bound. But that is not how the American judicial system has ever worked in practice. And it's not how it should work simply because the Texas legislature decided to deprive the state of any involvement in the case. Further, the statute deputizes private citizens to do the work of the executive. Notably here, also an end run around the constitutional rights of the people affected, because the state itself could not do it, because the constitutional rights of its citizens would be impacted. The defense argues in their response to the summary judgment motion that separation of powers is not applicable here because deputized citizens get the power, not another branch of government. But that misses the point with regard to separation of powers, Your Honor. This highlights the usurpation of the legislature of the other powers of government. Even though there's a new entry into the branches of government, apparently, from the deputized citizens of Texas and beyond, those are not really a co-equal branch of government. And by deputizing folks to do what the state cannot do, the legislature has told the courts what they can and cannot do. It's told state actors that they cannot enforce. It has taken power away from the other two co-equal branches and conferred an attempt to confer standing on any other person who wants to exercise that power. With that, Your Honor, I'll stop for now. To the extent that Your Honor wants to take a look at the Best Buy case that I referenced, it was filed on April 16 of this year. I believe there's no petition on review at this point, but it does have a really nice layout of all the cases on both constitutional conferral of standing and the narrow exceptions.
Is that in the briefing that I've gotten so far?
It is, Your Honor.
Thank you, Your Honor. So I'm not going to go through what Ms. Eklund just very ably did on the standing piece. I think we generally agree with everything she said. I would note with respect to the cases on which defendants are relying that she addressed, to some extent, that each of those cases dealt with a statute that allowed any person or citizen to vindicate an injury to the government. Whereas here, as she said, there is no assertion that there is an injury at all to the people who are permitted to sue under SB 8. As Ms. Eklund, what I would like to focus on, and I think Ms. Eklund talked about it a bit, is this issue of non-delegation, that SB 8 is effectively an unconstitutional delegation of power to private individuals. And I think I've provided to the parties and to Your Honor a couple of handouts that we created basically to help the court hopefully match the claims that we have brought to the specific kind of features of SB 8. And then in the second handout, that handout goes specifically to the test for whether a delegation of government authority to private parties is an unconstitutional one. And I think it does have an overlap with standing. Much of what as I understand your honor's concern with the attempt by SB8 to create standing for individuals where there is none, I actually think that the most effective and kind of streamlined way to think about that is not as a quote unquote standing claim or a standing issue, but as the manifestation of why SB8 is an unconstitutional delegation of authority.
Delegation. is a stronger argument than thing.
I do, Your Honor, for a couple of reasons. I think that the delegation, it is in this context where we are making the argument affirmatively in a pre-enforcement context. I think that the case law is just quite clear where a statute confers authority on private parties, and we've laid out, and I believe it's a little small there, but the 8 factors that the court would consider. I think that the case law on that is just incredibly clear that this is an unconstitutional delegation. So, for example, as I said, there are 8 factors that the Texas Supreme Court has laid out in the Bull-Weevil case. We cite that at the bottom. It then, of course, reaffirmed those 8 factors in the FM Properties case, also cited at the bottom of the handout. And defendants have said in their briefing that this standard, as Ms. Eklund indicated, doesn't apply because, you know, the private parties here, essentially the delegation only, an unconstitutional delegation is only problematic if it's taking power from one branch and giving it to another. And this is sort of something wholly different. But I actually think SB8 is kind of doubly bad in that respect, because Ms. Eklund is absolutely right that the act tries to take executive authority that would normally be exercised by the governor and the attorney general and give it. So it takes that authority to the legislative end, but then it confers it back out to private parties. So the fact that private parties are involved does not in any way indicate that the non-delegation case law from the Texas Supreme Court is inapplicable here. And in fact, the Bull-Weevil case very clearly sets out the factors that you should consider in the context of a private party. So I do want to go through those individually. We have here the factors in bold, and then underneath those factors, our responses or application of those factors to SB8. So the first one is, of course, are the private delegates' actions subject to meaningful review by some branch of the state government? And SB8, the answer is clearly no. In fact, the statute says, go forth, private enforcers will have nothing to do with it from here on out. Factor 2, are the persons affected by the private delegates' actions adequately represented in the decision-making process? Of course not. Here, the regulated parties, abortion providers, and those who could be liable for aiding and abetting conduct prohibited, they aren't represented in what came out of the legislature, and they certainly are not represented in the multitude of decisions that could be made, including on behalf of Texas Right to Life and Mr. Sego, to enforce SB8 against them. They also, for factor 3, SB8 gives private individuals not just the power to rely on SB8, but to actually apply it to individuals. And it gives them a pecuniary, for factor 4, it gives them a personal interest in enforcement of SB8 that would be in conflict with whatever the state was trying to accomplish. Here, of course, we know that that was actually a violation of constitutionally protected rights, but it doesn't have to be the case that an SB8 claimant shares that view. Of course, you know, we have seen from the one abortion that was performed by a non-Planned Parenthood provider in violation of SB8, that person has been sued by someone who very clearly says he's in it for the money. And he, you know, if there's $10,000 to be had, he'll be there every time. So for factor 4 as to a delegation, it very clearly SB8 gives a pecuniary interest to individuals to bring suit for money or to kind of grind an ideological axe. For 5, you know, as Ms. Eklund said, we do think that the penalties here, the statutory damages are actually penalties and are quasi-criminal in nature. 6 is the delegation narrow in duration, extent, and subject matter. Far from it. SB 8, of course, allows people to sue anywhere. Anyone who has violated SB 8, they can do so indefinitely, and they can file as many suits as they would like without ever having to be responsible for paying the other side's attorney's fees. So it incentivizes suits in a broad range of circumstances. First, factor 7, does the private delegate possess special qualifications or training for the task delegated to it? I think this is where the delegation argument actually really intersects with the standing argument in a very close way, because of course, by authorizing any person to sue, SBA doesn't require any training. I realized after we did this, there is one exception other than government officials who can't bring suit, and that exception is someone who caused a pregnancy through rape or another crime. That is the sole exception for who is quote unquote unqualified to enforce an SBA claim. Otherwise, people have free rein to bring suits. And factor 8, has the legislature provided sufficient standards to guide the private delegate in its work? Again, the answer to that is plainly no. This is a free-for-all, what SB 8 has created. And the entire goal, what Mr. Sego has said, I can get you the site if you need it, is that the only way it works is with a credible threat of suits from anybody against abortion providers like my clients. That's what makes it work, and that is also what makes it an unconstitutional delegation. The Boll-Weevil case that we cited for your honor, the one thing that I would also focus on in that case is that, one, it did not involve just what one would consider legislative authority. The foundation in the Boll-Weevil case also had authority to impose sanctions, so similar to an executive authority, and it had authority to conduct inspections of premises. So I believe that the defendants have tried to distinguish that case on the ground that it involved the delegation of legislative authority to private individuals, but I don't think even on the facts that it can be distinguished in that way. And of course, we cite other non-delegation cases in our briefing as well. It's not just the Boll-Weevil case. So one, Boll-Weevil involves authority that could not be described only as legislative in nature. And two, Boll-Weevil makes clear, and I think this is why we think it is perhaps the clearest, cleanest way for you to resolve the claims in this case. Boll-Weevil makes clear that where an unconstitutional delegation is involved, that delegation is itself void. And Boll-Weevil is an example, I believe the FM Properties cases as well. Facial invalidation of the statute is the appropriate remedy for that. So if your honor were to decide that SB 8 is an unconstitutional delegation of executive authority to private parties, you could facially invalidate that delegation of authority, that of enforcement authority, across the board in SB 8, and you would then not need to consider, our own view, all of the ways in which particular aspects of the enforcement proceedings violate due process, violate the right to equal protection. We believe that those are meritorious claims too, but I think there's actually a very simple way to resolve the enforcement piece of this case, and that is by holding that SB 8 imposes an unconstitutional delegation of authority to private parties. And I believe that that would get at what I understand to be some of your honor's concerns with respect to SB 8's attempt to create standing where there is no injury to the person bringing a claim, and giving to that person not only the ability to collect $10,000 or more per abortion, but to obtain an injunction going forward against conduct that violates SB 8, even if it has absolutely no effect on the SB 8 plan. with that, Your Honor, those are the only points that we have on non-delegation. Certainly happy to answer any questions if you have them.
Judge, your question, you asked about the standing provision and whether it's constitutional. And to frame that discussion, the argument the plaintiffs are making is that that the Texas legislature is constitutionally forbidden to confer standing on uninjured persons. That's our understanding of their argument. That under the Texas Constitution, the legislature does not have authority to confer standing on someone unless that individual has some injury or has met the standing requirements that they think by the legislature. That's false. The case law does not support that. What they're doing is they're trying to argue that federal standing requirements are the same as the standing requirements under the Texas Constitution. You asked about the 1915 case. There's a long line of precedents dating back to the 1915 case that established that the Texas Constitution allows the legislature to confer standing by statute. And that standing can be conferred by statute upon any person, any taxpayer, or any citizen. That's what SB 8 does. It's consistent with the Spence case from 1915, which was cited with approval by the Texas Supreme Court in 1966, and then also cited with approval by the Third Court of Appeals, which is binding on these proceedings in the Grossman case more recently. And that was Grossman case was the 2019 case from the Third Court of Appeals in Austin. Those cases and the line of precedents the precedent that relies dating back on Spence create a standing analysis that is different from the analysis that would apply under federal law. So to address that issue, we think it's fairly straightforward that the case law supports exactly what SB 8 does as to the constitutionality of the legislature conferring standing on any citizen.
Let me be sure I understand what you're saying, and I have read.
Right.
That Spence case was long and old. But the Scott case and the Bell versus Hooter, the 1984 case of the Supreme Court, just have incidental references to ordinary standing rules unless there's something different by statute, and they say basically that. And the question I have, and I simply don't, I need to dig deeper. It's one thing for the court to say, we've got these usual standing rules, which require injury and so forth, unless there's something different in the statute. Because it is certainly true that the legislature can change the common law in many ways. I don't know whether it's the same thing, and I'm interested in your argument on this. I don't read those cases to say whatever the legislature does to create standing is okay with us, no matter how far it goes, because I don't think they say that. They may mean that, but I don't think they've said that, and I don't think they've had those kinds of statutes before them, like this one, which not only gives standing, I think the newspaper said yesterday we have 17 million registered voters. So I don't know what the number of adults in Texas is. You add to that adults in this country and conceivably around the world. And the standing that is granted is the ability to get a mandatory injunction and also mandatory damages. I'll have a discussion on this too. Ordinarily, when a plaintiff proves $10,000 worth of damages, once that amount is paid, you can't get the same thing from additional defendants. If all you've got is 10,000 in damages, you don't gain anything by suing 5 people. If you get 10,000, you can't go get another 10 for a total of 50. But under this law, you can, because there's no harm linked to it. So I just am wondering if the standing question, the SB 8 standing for any person, is really answered by those cases that, admittedly, 3 of them by the Supreme Court. And then I think that the response to the motion of summary judgment mentioned others that have the phrase that mentions, unless the statute says otherwise. But I'm just struggling and want help on whether it is the Supreme Court's position that we're going to stand back no matter how far standing is granted if the legislature does it, which it seems to have done here. So that's just, that's a long question, but it's something that is on my mind. I think the statute and the cases raise that question.
I think that's right, Judge, but I don't know how far the Supreme Court would extend that precedent. Would there be some limit on those cases? Perhaps, but there's not under existing law that, as we're here today. And the Grossman case, I think, does address at least part of your question, where the court says that, and the court relies on the earlier cases, Spence and Scott, the third court, and says that the individual has standing to sue to restrain and enjoin violations, even though he has not suffered a particularized injury distinct from the general public. And so that was the issue. And that question was raised there, and the court, at least the Third Court of Appeals, went back and said, well, the Supreme Court has said in those cases that the legislature can confer standing, presumably, even if it's the individual who is provided standing by statute has not suffered injury distinct from the general public. So I think that the body of case law that is binding as we address that issue here is fairly well established on the question. You'd asked about the standing question, and then I think that plaintiff's counsel also argued delegation issue. The delegation question, and again, we think that there's no jurisdiction to consider these arguments, and that's obviously why we've urged the court to consider and rule on plea to the jurisdiction first. But to the extent that the court finds it does have jurisdiction and is considering these questions, the delegation issue, I think is a different, well, the first question is they sued Texas Right to Life and John Seco. And Texas Right to Life and John Seco haven't delegated anything. It goes back to what Ms. Hacker was arguing, that they're suing the wrong people here. John Seco may have been provided some authority, or if that's their argument, to sue under SB 8 by the legislature. But he's not a defendant who is delegating anything. They originally sued legislators. Maybe those would be proper defendants, maybe not. They dismissed the legislators from the case. But I don't think there's any way they could say that John Seco and Right to Life are liable for an unconstitutional delegation of legislative or executive authority. It's just not possible, and there's no case law that would ever support that. Now, as to if they could bring that claim against John Seco and Texas Right to Life, then the questions of whether their problem is with the law itself. It's not with John Seco or Texas Right to Life's delegation or non-delegation or involvement with that issue. Even if they could bring that claim against John Seco and Right to Life, my understanding of their argument is that that delegation that they allege that they believe that it's unconstitutional because it violates the separation of powers provision under the Texas Constitution. And that's the basis of the constitutional claim that they're making on delegation to John Seago or to anybody else. In that, the argument first, it disregards what the text of the separation of powers provision of the Texas Constitution says. That provision of the Constitution applies to a delegation to an individual between the legislative, executive, or judicial branches. It doesn't apply to private actors. And so that is, I think, to a certain extent, consistent with the argument that they're suing the wrong person here as well, because there is no delegation to someone within those branches, at least as that provision of the Texas Constitution is written. There's a question, at least raised by the non-Planned Parenthood plaintiffs, about eliminating a defense, that SB8 eliminated any defense that SB8 itself is unconstitutional. That's not an accurate argument as to what the statute does or does not do. But in any event, that doesn't affect the separation of powers argument or the delegation of power to private parties. That our understanding of the claim they're making is that it violates the separation of powers provision, and the separation of powers provision doesn't apply in this context because there is no delegation to another branch of the government. And I haven't seen any case law that would suggest it in this context that it is violated.
I need to read that Boll Weevil case, but I think what they're saying is that if there's a delegation to private parties of something that would have been an executive function, like prosecuting, under certain circumstances, that's not valid.
Right, and I don't think those circumstances exist here, and it appears that they take the other position on that. I believe those were the two challenges that they argued in response to your question. There are others that I imagine that we will get to, or that they would argue. But that's our position. That's our position. It's laid out in our motion for summary judgment. We don't think these are as complicated of issues because we think the case law is clear on the standing question that you raised, and we don't think it's complicated on the separation of powers issue because the provision, the Texas constitutional provision they rely on is clear that it has to be between the parties who are members of those branches.
Before you sit down, let me direct a question to both sides. There's a reference to existing law. And I want to be sure my understanding is correct on a couple of things. Number one, the cases before me, everybody has agreed that I'm not asked to say make any ruling on the Supreme Court area of abortion law. It could be before this court, but it's not. Am I right? And you're nodding your heads affirmatively on.
We're not challenging it for the non-Planned Parenthood.
That's okay with you all, I'm sure.
I think Planned Parenthood is, but I'll let Ms. Murray speak to that.
So, Your Honor, we have brought exclusively state law claims, but one of our claims is a right to privacy claim under Texas law on the ground that SB8 bans pre-viability abortion. And we have cited in our motion for summary judgment cases in which the Texas Supreme Court has relied on Roe v. Wade and the right to privacy established under federal law to interpret and give meaning to what that state law right would be. So it is correct that it is not before this court whether, as a matter of federal law, SB8 violates a right to privacy or substantive due process. It is, however, before this court whether SB8, by banning pre-viability abortion and by putting at issue a patient's personal medical care and decision-making in litigation with strangers, whether those two aspects of SB 8 violate state law right to privacy.
Thank you for that clarification.
And I would add, Your Honor, although federal law is not directly at issue, I do think, of course, some of our claims rely on the fact that SB 8 is not, for example, like a key TAM statute that is furthering a public interest or a public good. It is a statute that is directly targeted at a right that is unquestionably protected by federal constitutional law. So although we're not asking Your Honor to make a ruling on that question, it is certainly part and parcel of some of the claims that we are making, because we're saying SB 8 is not furthering a legitimate public interest, for example, for equal protection purposes. The sole purpose and effect of SB 8 is to prohibit the exercise of a constitutional right. And we think that the court can, of course, take stock and notice of what federal constitutional law would unquestionably provide here.
I could reply to the question of whether SB 8 is furthering a legitimate public interest fairly easily by saying that I think that's a significant matter of dispute, that the Texas legislature and many members of the public would believe that SB 8 in fact does further a legitimate public interest. And so if Ms. Murray's suggesting that that is an undisputed fact or is somehow necessary for purposes of her getting summary judgment or her motion for summary judgment on the right to privacy claim or the federal claim in a row or under some state constitutional right to access abortion, that the purpose of the law and whether there's a legitimate public interest is certainly in dispute.
The phrase existing law also, maybe you want to ask this question. Would I be right in saying that there is no existing law squarely on point? The point being a statute that has several procedures that have never come together before. Unlimited standing, automatic damages with no harm, fee shifting, venue where the plaintiff lives, automatic injunction, things like that. If a statute like this one had ever been enacted in this country, ever before, we would know about it and there would be some law on point. Am I correct about that?
I'm not aware of a statute that has each of the components of this law that are being challenged. So I think you're right. If there were, I imagine it would be part of the litigation.
On this side, you agree? So we've got bits and pieces that deal with the bits and pieces if you fragment and look at them one by one. But
yes, that's our understanding too.
Yeah,
This is the
it's never
first
been
time that all
gathered
that's
together before, and that's the reason that there's not any factually the same statute and case that we have in this case.
I think that's right, and I think there's an important follow-on point to that, which is that in SB 8 there's a severability clause that express, and I can't quote it, but it's in the statute, and the implication of that is that if a court finds that any one provision or any of these issues we're talking about today is unconstitutional,
Every sentence, every word, every punctuation mark.
right, then that unconstitutional provision is severed from the constitutional provisions, and so
The Supreme Court case on that point is cited in the statute.
right,
11, I think. Yeah.
right. So
Let's go ahead and break for lunch, and is an hour long enough? Get back at 1:10.
In your offices.
Oh my gosh.
Oh, I ordered it.
Okay.
I'm like, what I did.
Gotcha. Gotcha.
Huh?
You don't want to flip it.
I mean, you have here. You have right.
I don't know if we know what it is. Yeah. Well, they wouldn't pick ours up and they're coming back. I wonder if anyone's going overflow.
Real world is still just like chopping me back in.
Yeah.
You know?
Yeah, I haven't worn dress shoes
Why?
since 2020. Everything that I've like dressed up for. Haven't worn dress shoes under like this.
Right.
Oh, wait, are you guys at the same firm?
We're not,
No,
but he knows
no,
where to find us.
Yeah, I can,
Okay.
I think you got one.
Oh,
online,
yeah. I just didn't know if it's the same firm. I'm sure you're all over the court's case file. I've had access to that.
That is true.
That's okay.
That is. Yeah, it sure does. Forgot that that's always true.
All rise.
You see, please. Okay, did we get finished with that last issue? Y'all ready to move on? We need to talk more.
Your Honor, I only need like 1 minute. I just have one thing to point out to the court.
I've never seen anybody abide by 1 minute.
I think I can do it.
Go ahead.
Got me timer?
Oh. At one point in Mr. Stevens' rebuttal to our presentation, he said that he thought what I was saying was that the legislature is confined by the Constitution, and that is in fact what I'm saying. And their case, the Scott case from 1966, says that specifically. It says within constitutional bounds, the legislature may grant a right to a citizen or a taxpayer to bring an action against a public body or right of review when it's discussing the spent plan of cases. And that has been the ongoing holding and is now the holding of the Court of Appeals in Austin, which is the appeals court for which the MDL sits, if I understand correctly. And that is the Best Buy case that I directed you to. The only other thing I wanted to say is to the extent that there is continuing argument about unlawful conduct being required by the defendants, that is not the standard for standing on a declaratory judgment. The standard for standing on a declaratory judgment is the two elements that we've already covered, that there's a live controversy that's justiciable, and that the declaration sought will resolve it as between those parties. And while it may not bind millions of people across the state of Texas, it is definitely meaningful to the plaintiffs that this law is declared unconstitutional by this court in this controversy with the defendants, because they are the primary source of enforcement organization going on. So those are the only two things I wanted to bring to the attention.
What's the next issue anybody wants to bring up?
Your Honor, there are several other provisions within SB 8 that we're happy to discuss with you. We did brief them in the summary judgment motion. I also want to be respectful of your time and answer any questions you may have, but I'm happy to sort of walk through the other provisions of SB 8 as well.
All, both sides ought to walk through whatever issues they want to raise. I know that the defendants want to raise the TCPA, please, jurisdiction, understand that. We'll do that before I leave. Let's just go ahead and deal with whatever you all want.
Okay, I
Deal with orally.
Your Honor, I think I'll come back up to the lectern and try to point you to pages in the PowerPoint again to talk about the provisions of SB 8 that we haven't fully covered just yet.
We're going to be focusing on the language of the statute.
I am, Your Honor, and so it'll be the first. I don't want to say few.
I've
There's
got
several
my own
slides.
copy that I've marked.
That's perfectly fine as well, Your Honor, of course. So you've already touched on the venue issue. And I just want to point out all of the provisions of this statute that you're correct, work together in a very unique and novel way. And we agree with Mr. Stevens that no law like this has ever existed. I think the parties before the U.S. Supreme Court acknowledge no law like this has ever existed. Frankly, no state's ever tried to do this. And so you are correct that all of these issues are matters of first impression for you. In addition to being able to bring suit anywhere, if the plaintiff is a resident of Texas or in the location that they live, there's a 4-year statute of limitations for SB 8 claims. Which, as you know, Your Honor, is unusual for a tort. Most tort actions in Texas have a 2-year statute of limitations. I'm just pointing out the ongoing potential liability and how long lasting that is. That behavior that happens now can still be sued for in 4 years. And so the ongoing risk of lawsuits, even if the defendants don't currently have an intention, and again, we think all the evidence before you indicates they do, that if SB 8 is violated, their ability to bring lawsuits extends for 4 years.
On the other side of that, if there's anything the legislature has a track record of dealing with,
That is
garden variety stuff.
that is absolutely right, Your Honor, and we have not challenged the statute of limitations as being unconstitutional. I pointed it out with respect to the current intent of the defendants or their declared intent, which is we will not sue unless you violate SB 8. is a 4-year threat. Because any violation that happens then has a 4-year tail on it. And so it really goes to the harm and the threat that's being posed against the clients. But to be clear, we are not challenging the 4-year statute of limitations as unconstitutional or a violation directly. I do want to focus on the elimination of defenses in SB8. That's in section 171-208E.
You say E?
Yes, Your Honor.
Okay.
It says notwithstanding any other law, the following are not defenses. One obvious mistake of law is never a defense, so I'm not sure why the legislature decided to put it in there, but the second one, a defendant's belief that the requirements of this subchapter are unconstitutional or were unconstitutional. The legislature is trying to eliminate a defense that the statute itself is unconstitutional. As far as I know, there is no other law in Texas where the legislature is dictating to the court that a person cannot make a defense that SB8 is unconstitutional. The third one is,
as I read E2, it says, if a defendant comes in and says, well, I thought it was unconstitutional, that is not a defense. But if it really is unconstitutional and so held by a court, a final resort, that doesn't change that.
well, I think the first issue that you raised, Your Honor, will be covered by 1, which is ignorance or mistake of law, which is I believed it was unconstitutional, or that this law was unconstitutional, but I was mistaken. It's covered by 1. And so since we're required to give the legislative words meaning, I think 2 has to mean something different than 1. And that's why I've raised it. 3 is the elimination of a defense that the defendant is relying on any court decision that has been overruled, even if the court decision had not been overruled at the time the defendant made the decision. And this again goes to the defendant's recent public admissions that they viewed Judge Pittman's injunction order that said SB8 is not in force, that if our clients rely on that, and it turns out that Judge Pittman was wrong, that even in relying on the injunction issued by the federal court, they cannot raise that defense.
That's certainly not an ironclad defense. So in an ordinary case, I would think certainly that would be relevant on punishment. Because one gets probation or less than a sentence, there's no discretion in this law.
There's no discretion in this law, and it actually prohibits the court from considering it. The legislature is telling the court, you cannot consider that defense. So in addition to eliminating offenses, it's also, again, a separation of powers issue where the legislature is trying to dictate to the courts of Texas what they can and cannot consider. There are 4 more. So number 4 is the defendant's reliance on any state or federal court decision that's not binding. Again, I think a defendant is allowed to make any non-frivolous argument in their defense. And I'm unaware of any other law in Texas that says you cannot do that, or that the court cannot consider it. Non-mutual issue preclusion, non-mutual claim preclusion. Again, this is a judiciary issue. Whether claim preclusion or issue preclusion applies is a question for the courts. The legislature can't dictate on the front end what a court can and cannot consider with respect to a defense. And so the elimination of defenses causes harm to the potential defendants who are our clients, but it also violates the separation of powers because the legislature doesn't get to tell courts what to do with respect to their adjudicative process.
Let me ask about that. Like rules of procedure. The legislature has given the Texas Supreme Court different degrees of flexibility and authority to make rules.
Yes, sure.
And It's always understood that on most of those rules, the legislature didn't have to do that. And there was a time in this state when, you know, before we had the rules of civil procedure in 1941, whenever they came in the state court, wasn't it all statutory? So I think it was, and then we had, the court has had rulemaking authority for a long time now. But to say that a legislature cannot, as a general rule, tinker with rules of procedure, as a judge, I kind of would like to feel that way because I have great confidence in the courts in making their own rules. But when push comes to shove, it's quite a stretch to say, issue preclusion. I'm not aware that very much has been done by any legislature in that area. To say that that's a judicial issue and the legislature can't touch it.
Well, so I think with respect that the issue is easier to understand with respect to claim preclusion. And I'll grant you that there may be some wiggle room around issue preclusion because if it's non-mutual, and there's a judicial doctrine around non-mutual issue preclusion as well. There are exceptions to it. But with respect to claim preclusion, and there's another example in SB8, which is the provision I referenced earlier about joint and several liability, where the legislature actually says, regardless of mutual claim preclusion, you can still bring additional lawsuits. The idea that the legislature can eliminate res judicata, which is what claim preclusion is, and that a binding decision from a court about the rights of two parties before it, that you can just go to another court and argue the exact same things amongst the same parties, is a usurpation of the judicial function. It's the legislature saying courts don't matter. If you don't like what that court did, go to another one. It also raises an equal protection issue.
I'm looking at 5. That's limited to non-mutual. So if that tells me that mutual claim preclusion is still the law under SB8 for SB8 cases, meaning if both parties are bound by it.
It's not with respect to section 30.022. Your Honor, there's two different places where the legislature is trying to dictate claim preclusion and issue preclusion rules for the judiciary. This one is, I will grant you, not as offensive as the one in 30.022. And I will get to that.
Go ahead.
It does also raise an equal protection issue, Your Honor, because this is the only statute that I'm aware of where the legislature is eliminating defenses and saying, you set of potential defendants who will always be the people who are providing access to abortion, advocating for abortion, funding abortion, you get a different set of civil procedure rules because it only applies in SB8 cases. And that's an equal protection issue because litigants in Texas, every other defendant, in whatever form SB8 actually is, gets to have the benefit of all the Texas rules of civil procedure. And so it raises two issues. And 30.022 has the same problems.
You are making the broader claim that this set of procedures taken together, which for these abortion provider cases, SBA cases, are taken out of the rules of civil procedure, given their own set of rules. And I guess anything that's not dealt with will still apply. And that's an equal protection.
Yeah, and Your Honor, it's an equal protection issue because it's content and belief based. The definition of the defendants who are subject to this one-of-a-kind enforcement statute necessarily will only be people who provide abortions, fund abortions, help people get access to abortions. That is the class of defendants. There is no other set of defendants who have to abide by these very special rules that are all set up to the detriment of that class of defendants. 30.022, it may in fact be the most obvious example within SB 8, and it's at the very back because SB 8 actually was codified in section 171 of the Texas Health and Safety Code, and then also in this Texas Civil Practice and Remedies Code. So section 30.022 is award of attorney's fees and actions challenging abortion laws. It's the provision I referenced earlier when I said that everybody on the side of the courtroom was facing joint and several liability for costs and fees. It's a very lengthy provision within the statute. And with the court's permission and indulgence, I would like to go through it in some fairly specific detail. And I would like to use this case as an example of how this works in real life. Because by bringing these pre-enforcement challenges, our clients and all the counsel of record for them are subject to this provision specifically. And so I think in order to sort of work through the technicalities of it, it might make sense to talk about it in real life. So subsection A says, notwithstanding any other law, any person, including an attorney or law firm, who seeks declaratory or injunctive relief to prevent any person in this state, so it's the government officials and then any person in this state, from enforcing any statute, ordinance, rule, regulation, or any other type of law that regulates or restricts abortion. And then the last two sentences, or the last two lines, is jointly and severally liable to pay the costs and attorney fees. This is a profoundly important provision because it defines the class of people who can be jointly and severally liable. It is only any person or their lawyer who seeks declaratory or injunctive relief to prevent anybody from enforcing a statute related to abortion. The only people who can ever be jointly and severally liable are the people who bring pre-enforcement challenges to abortion regulations. And it's not just the plaintiffs, it's their lawyers. This is meant to directly chill any pre-enforcement review of an unconstitutional statute. And it's meant to keep people from having lawyers who can bring those challenges. And again, I'll say again, this is happening right now. It's not hypothetical. Our clients have brought a pre-enforcement challenge that seeks declaratory relief to SB 8. SB 8 is an abortion regulation. They are seeking their fees. The defendants are seeking their fees under section 30.022. They've invoked that. .022 has some other provisions. Subsection B talks about when the people challenging an abortion regulation and their lawyers, when that joint and several liability kicks in. And it kicks in if the court dismisses any claim brought by the challengers. So, Your Honor, you know that we've challenged SB 8 for 7 different reasons under the Texas Constitution. If you agree with us 6 out of 7 times, and you declare that SB 8 violates the Texas Constitution and is therefore void, but you don't agree with us on the 7th, the defendants under SB 8 get their costs and fees. It's not the same though, it's not reversed, because 2 says they just have to win 1.
You're really talking about the prevailing party definition right now.
I am, except it's not actually a prevailing party provision, Your Honor, because remember subsection A says that only people who bring injunctive and declaratory challenges can ever be jointly and severally liable. So the legislature is trying to dress this up as a prevailing party provision. But it's actually only, you can only impose joint and several liability for these costs and fees on the people who are challenging the abortion laws. That's in subsection A. Subsection C says a person who's trying to get these fees from someone who is jointly and severally liable because they brought a declaratory or injunctive relief claim challenging an abortion statute or ordinance. They can bring the claim for fees 3 years after the final judgment in the underlying case, which means any case that has been brought before September 1st that is still pending and has not reached final judgment, the defendants who prevail there can try to get attorney's fees. It is necessarily and specifically retroactive because at the time the first lawsuits were filed, let's say 2 years ago, challenging an abortion regulation, this liability did not exist.
Tell me again. I understand that has a 3-year statute of limitations on it. But what language do you point to that says that would apply to something that happened before the effective date?
Because it says regardless of whether a prevailing party sought to recover costs or attorney's fees in the underlying action. At the time the underlying action was filed before September 1st, there was no ability to seek these fees. So it's not dependent on them having sought the fees. It's dependent on whether there was a challenge brought. D. Again, this is the legislature telling the courts what defenses don't apply. So 1 is, it's not a defense if the prevailing party didn't seek to recover the cost of attorney's fees. Even if they don't ask for them in the underlying action, they can go to another court and say, I won on 1 issue. I want my fees. 2, the court in the underlying action declined to recognize or enforce this section. So even if they ask the court and they are denied, they can go to another court and say, I want my fees. 3, even if they asked for fees and the court said, these provisions are invalid, unconstitutional, they can go ask for fees again. So let's assume that Your Honor agrees with us and says section 30.022 is unconstitutional. They have 3 years from the final judgment in this case to go find another court to try to get a different decision. The legislature is eliminating res judicata. And that is absolutely an invalid usurpation of the judiciary's function. So with respect to the two fee shifting issues, Your Honor, the violations of the Texas Constitution, all of this gets subsumed in the standing without injury. Obviously, to the extent there's a creation of a cause of action without injury that exceeds the constitutional standing requirements, everything falls away. But these provisions in particular, they violate open courts, they violate retroactivity, they violate equal protection, they violate the separation of powers. Because again, there is only one subset of potential litigants in Texas who can ever be forced to litigate under these rules. And it's the people who bring pre-enforcement challenges to abortion regulations. The legislature can't decide to just treat some citizens differently because they want to petition the court and get a declaration about their own constitutional rights. I don't have anything further on those two issues, Your Honor, unless you have questions.
Ms. Murray, do you?
So a few follow-up points on that, Your Honor. With respect to the various aspects of the law that we contend are unconstitutional, of course, as I said before the break, we think there are some claims that would be more streamlined for resolving the Planned Parenthood plaintiff's dispute with the defendants in this case. The non-delegation claim is one of them, and the right to privacy claim. If the prohibition on pre-viability abortion is unlawful under Texas constitutional law, then the enforcement mechanism for that prohibition is irrelevant because there is no such prohibition. And aiding and abetting liability cannot follow without an underlying predicate prohibited act. In other words, you cannot aid and abet a prohibited abortion if the underlying prohibition on abortion is itself unconstitutional. So we think that those would be the most streamlined ways to resolve this case, either on a non-delegation or potentially sort of standing-based theory. Although we think the non-delegation angle is clearer for the reasons that I articulated before lunch, or on a right to privacy theory that the prohibition on abortion is unconstitutional under Texas constitutional law. If, however, Your Honor goes further, and I think you certainly could decide the claims in this case under the rationales that I've just identified, and then in the alternative, address some of the other claims that are raised by the Planned Parenthood and non-Planned Parenthood plaintiffs. If you do that, I would direct you to pages 7 and 8 of our motion for summary judgment, where we lay out in bullets the various aspects of SB 8's enforcement mechanism that we believe are unconstitutional, either because they violate equal protection, due process, the prohibition against retroactive laws under the Texas Constitution. So those are at pages 7 and 8 of our brief, and also identify the particular statutory sections that correspond to those features of the law. In terms of the features that Ms. Myers identified, I did want to add a couple of points. One is that on this issue of non-mutual claim preclusion, I know Your Honor was suggesting that perhaps it's within the legislature's authority to, for particular claims, get rid of, or change the normal claim preclusion rules. And the one thing that I would direct Your Honor to, though, to keep in mind about how that change to the claim preclusion defense works is that it applies also to federal judgments. And it is not within the power of the Texas legislature to decide whether a federal judgment against Mr. Seago, for example, whether that would bind a Texas state court. It would, and it would do so as a matter of federal, not state law. So I do think that that provision is actually more problematic than one might think if you are viewing it only as a matter of overriding Texas state court judgments. It applies to federal judgments as well.
Really, all I meant to suggest is that it used to be pretty much all the legislature in making court rules, and even in the rules of civil procedure era, but we still sometimes speak and the courts acquiesce. And this may be different and more serious, but it's not as different and unusual and unique as a lot of reps. That's really all I was.
Yeah, and to that point, Your Honor, I guess one thing that I would say is that, you know, I think you're absolutely right. Legislatures, the Texas legislature included, and court systems regularly do make rules that govern procedure in litigation. And that is not in and of itself an unconstitutional act, of course. It happens all the time. But whether it is the legislature setting the rules or the Supreme Court of a state that is setting the rules, it is state action that is still subject to the bounds of, for example, equal protection. And when a party like Texas Right to Life or Mr. Seago attempts to use those procedures as they have threatened to do against our clients, equal protection limitations, for example, would constrain the types of rules that a legislature could adopt. So, for example, if the Texas legislature said that men who wanted to file a tort action could do so in any district within the state of Texas, but women for the same exact tort could only do so in their home county. There's nothing wrong necessarily with a rule that you could file statewide. There are certainly possibilities of statewide venue, or a rule that you can only file where you reside, or a rule that you can only file where a defendant resides. But to make a distinction between, as SB8 does, abortion providers and those who assist abortion patients and everybody else is still subject to an equal protection limitation. We think that it is, the court would actually apply strict scrutiny to that because it is obviously, the distinction is targeting both a constitutional fundamental right to privacy and because it is targeting individuals who advocate and support abortion rights, thereby impinging on their free speech rights as well. So under Texas state equal protection law, where a distinction is made between classifications of individuals based on or to target a fundamental right, if it impinges on a fundamental right, strict scrutiny applies. But even if it didn't, Your Honor, if for example, the Texas legislature said from here on out, anyone with, you know, brown eyes can get attorney's fees if any claim against them is dismissed, but anyone with any other color eyes cannot. Again, even under rational basis review, there has to be some legitimate purpose for the classification. And here, that purpose of the law is plainly not legitimate because it is to target a clearly protected constitutional right. That is not only not a rational basis, it is not a legitimate one for the state to use or to act on. So I think that equal protection may be in some ways the best way to think about all these various aspects of SB8 that single out every step along the way, abortion providers and others who assist with patients who need abortion, and set them apart with a special set of rules distinct from those applicable to everyone else. With respect to the fee shifting provision, I did want to clarify, and I know Your Honor has looked at both of these provisions, but we think that 30.022, and my apologies if I misunderstood Ms. Myers, I may have. That would apply not just in the pre-enforcement context, although we think she is absolutely correct that it could apply to Your Honor's decision in this case. If, for example, you dismissed some of our claims as moot or, on other grounds, that could well be a basis under SB 8 for the defendants to claim that they are entitled to fees. Now, of course, we would have a range of arguments against that. But I agree with her that 30.022 that you all were discussing applies in the pre-enforcement context. But I think in actually, at least as pernicious is the fact that 30.022 would apply in SB 8 enforcement proceedings. So for example, if Mr. Seago were to sue a Planned Parenthood client of mine under SB 8 alleging a violation of the prohibition on abortion after 6 weeks, I, as the attorney or Mr. Kaplan or whomever would be representing that client, would at that point have a strategic decision to make. Are you just going to defend, or are you going to, and I believe Ms. Hacker even said this is the appropriate way in her view to do it, that in those defensive proceedings, you would argue that SB 8 is unconstitutional. You would, seek relief in that respect. But as soon as you do that by asking for a declaration of SB 8's unconstitutionality, or by asking for an injunction against future litigation. So if you turn around and counterclaim in an SB 8 enforcement proceeding and challenge SB 8, 30.022 says you're on the hook for fees if you lose on any of those claims. And again, it's not losing in the traditional sense of what a prevailing party analysis would look at. It's, if you have a claim that's dismissed for mootness, that is enough to trigger fees. If you have a claim that is dismissed because you've done alternative pleading, for example, that could be a basis for awarding fees. So I do think that as applied to potential claims from Texas Right to Life and Mr. Seago, 30.022 has real effect, not set aside this case. If they carried through on their threats to sue abortion providers, including my clients, it would put them and their attorneys in the position of having to either make the claims that may well be best serving those clients and to vindicate their interests, and risking potentially ruinous liability from attorney fee shifting under 30.022. And I would say, I think all in this courtroom who have been involved in abortion litigation understand that it is hard fought in Texas. A few years ago, there was a case, Whole Woman's Health v. Hellerstedt, and we looked back at that to get a sense of how much would a case like that cost if it went up. In that case, the attorney's fees that were awarded at that point against the state, because it was under Section 1983, a federal challenge, were more than $2 million. So, Your Honor, of course, you have been a practicing attorney. I think it is hard to envision any attorney, no matter how dedicated to the client, who is willing to say, particularly in a pro bono capacity or as a solo practitioner, yes, I am willing to take the risk of being personally, jointly and severally liable for these fees in order to help my client vindicate their rights against this patently unconstitutional law. So it is very much designed to chill access to legal counsel in SB 8 enforcement proceedings, and by threatening to use SB 8 against our clients, Mr. Seago and Texas Right to Life have taken part in that unconstitutional state action. And can this court can, of course, resolve that issue should it reach the necessity, should it be necessary for the court to reach the issue of attorney's fees in this case. With that, the only other thing that I would say, Your Honor, while we're talking about other aspects of the summary judgment motion, is that I do want to make sure that you know, and I said this a bit earlier, but just to confirm, we do have a right to privacy claim in this case. It is not, as I said, it is not a federal claim. It's under state constitutional law, but as we say in our summary judgment motion, the Texas courts have incorporated Roe v. Wade into the case law. They have recognized a right to privacy and bodily autonomy. And we have also brought a right to privacy claim that is distinct from that, related to a patient's right to keep their personal medical decision-making and records out of litigation over which they have no control, and it is not based at all on their consent. So by what SB8 has done is created a system in which any stranger, if they get wind of someone's abortion, can come into court and can place that person's abortion decision at issue in litigation. Now, in the defendant's response to our motion for summary judgment, they indicated that, you know, I think they spent maybe a paragraph on it, basically. They just said there is no right to abortion, no citation to any authority or response to any of the cases that we've cited. And then with respect to this issue of keeping one's private medical decision-making personal, the only response in that opposition was, well, courts can sort it out with protective orders or, you know, discovery orders. But of course, for any patient who has trusted a healthcare provider to offer them abortion services, the idea that, for example, a litigant could have access to their personal medical records, which of course SBA has a record keeping requirement, so that documentation of SBA compliance is actually incorporated into a patient's medical record. So it is the statute is actually setting up a system in which the patient's medical record becomes the repository for demonstrating SBA compliance. And my understanding under Texas Rule of Evidence 509, I believe, is that although there is a privilege for certain patient information, that privilege does not apply where a patient's care was at issue in a claim brought by someone else and is relevant to that claim. So defendants have not explained how you could litigate an SBA abortion claim without reference to a particular abortion. And to the extent that SBA opens up the courts in Texas to any litigant, no matter how unrelated they are to the abortion patient, and in fact says that the doctor can't defend herself on the ground that the patient consented to the abortion, that in and of itself is a violation of patient's right to privacy. This, you know, in this context, it doesn't matter that it's abortion necessarily, although that's certainly, you know, there are issues of stigma and harassment for abortion patients that patients seeking other medical care may not face. But I think anyone who has received medical care that they may not want to share with the world would be offended and have a reasonable expectation of privacy that that care cannot be placed at issue in litigation that has nothing to do with them, that is against their interests, and over which they have no control. So I think we would urge Your Honor to consider seriously the right to privacy claims that we have brought, both with respect to a right, a substantive due process right to abortion under state constitutional law, but also with respect to a right to privacy in one's own medical records and information. And that right is violated by opening up to any stranger the ability to put someone's abortion choice at issue in litigation under SBA. So with that, Your Honor, that's all I have unless you have further questions.
There are a number of claims that were addressed at various points in the discussion by the plaintiffs of certain provisions of the statute. I'd like to address those in the context of what claims, what constitutional claims the plaintiffs are actually making. In other words, they're making claims that those provisions violate the Texas Constitution. So as we've laid it out in our response to summary judgment, we've said the plaintiffs claim that this specific provision of the statute, for example, violates the open courts provision in the Texas Constitution. So I think it makes sense to look at what the Texas constitutional provision is that they're claiming is violated and say, well, what law defines a violation of that provision? In other words, what does the Constitution protect and what does it not protect? So a number of the provisions that the plaintiffs raised as to, for example, the fee shifting, damages awards, the potential attorney's fees liability as to the lawyers involved in the case. Those claims, at least as we've read their motion for summary judgment, fall within their challenge to those provisions under the open courts provision of the Texas Constitution. The problem with those arguments and their claim that the specific provisions violate the open courts provision is there isn't authority to support the position and the arguments that they're making as to those provisions. For example, if we look at the fee shifting, that they're arguing that, and I'll look at that approach on our end, a copy of our motion for summary judgment, just if you want to follow along with where I am. So this starts on page 23 of our response to the plaintiff's motion for summary judgment. And what the constitutional provision on open courts provides is that all courts shall be open and every person for an injury done them in their lands, goods, person, or reputation shall have remedy by due course of law. Their argument is that these provisions of SB 8 or a number of these provisions of SB 8 violate that provision of the Texas Constitution. So for example, they complained that the fee shifting provision impede their access to the courts. The problem with that argument is there is no authority, and they haven't cited any authority to support the position that a fee shifting provision violates the open courts provision of the Texas Constitution. In fact, there are other statutes that have fee shifting provisions. Texas Rule of Civil Procedure 91A on a motion to dismiss. There's fee shifting. TCPA has fee shifting, and there's no case law that says that such a provision in a statute enacted by the legislature is somehow unconstitutional or a violation of the open courts provision based on an argument that it might deter some plaintiff from bringing a claim. If we go further, and I'm now on page 24, they talk about, they talk in their motion, and they may have mentioned it in their argument there, and I missed it, but the limitation on the amount of recovery, right? There's an allegation that the $10,000, there's no maximum cap on the potential damages award. That is true of almost every common law tort, that there's not a statutory cap that would limit the scope of liability for a tort that's brought. And again, in this context, or in the context of an argument that the open courts provision is violated because there is no statutory damages cap, no court has ever held that. No court has ever held that statutory caps on plaintiff's recovery are constitutionally mandated. They go further and argue, and I believe they brought up section 30.022, or the provision that they claim subjects attorneys to liability
if they unsuccessfully assert a constitutional claim as a defense to liability. In other words, if an SB 8 enforcement action were to be brought by a plaintiff against an abortion provider for a post-heartbeat abortion, they claim that the provision that applies to, or that would subject the attorney defending the provider to liability is, again, a violation of the open courts provision. The problem with that argument is that the statute itself only applies if the defendant or if the party challenging the constitutionality is seeking declaratory or injunctive relief. So in other words, if the claim is brought and the defense in the claim in the enforcement action or SB 8 lawsuit is that this statute's unconstitutional or these provisions are unconstitutional under, it could be any of the arguments that they're making in this case, then that provision of potential that they argue is potential liability to the attorneys isn't implicated. And that's from the plain language of the statute. There's not the case law on that. It just says that it would only apply if the defense, if there's a request for declaratory or injunctive relief. There was also discussion, I believe by Ms. Myers, about retroactivity. And I believe part of the argument was that, and that may or may not have been in the context of the statute of limitations discussion that she was raising, but the argument they're making, at least in their motion for summary judgment, is that SB 8 is unconstitutionally retroactive. But it's not unconstitutionally retroactive because it only applies to post-heartbeat abortions performed after September 1st, 2021, the effective date. To be unconstitutionally retroactive, it would have to say this statute imposes liability or potential liability on a provider who performs a post-heartbeat abortion in 2020 or before the effective date of the law. So there's no retroactivity issue here or claim that they can seek summary judgment on or any judgment for that matter. The next argument, and I don't know if they brought this up in the argument that they just made, but it is something that they've alleged and that they've briefed on summary judgment, is a violation of the due course of law provision in the Texas Constitution. And again, all these constitutional claims are under the Texas Constitution. And so that's why we're looking at what the law is in the Texas Constitution and the Texas constitutional provision that are at issue. So the due course of law clause argument is essentially, as I understand it, their allegation that SB is unconstitutionally vague. What they cite to in support of that argument is the term aiding and abetting. Aiding and abetting is a term that is very well known. It comes from criminal law. It's used in the same way, anyone who assisted, and it's defined, and has been litigated in the criminal law context for decades. If the term aiding and abetting is unconstitutionally vague, then every accomplice liability statute, criminal statute in Texas would be unconstitutional, and that just can't be the case. Nor do they cite any authority for that proposition. Similarly, the mens rea requirement of knowingly is very well, it's used throughout hundreds of statutes. There's nothing unconstitutional or unconstitutionally vague that would violate due course of law by using the term knowingly in a civil statute. Ms. Murray mentioned, and I believe Ms. Myers as well, equal protection, or the Texas constitutional equivalent of the equality clause. The Texas Constitution says, quote, equality under the law shall not be denied or abridged because of sex, race, color, creed, or national origin. There's nothing in SB 8 that discriminates on the account of sex, race, color, creed, or national origin. Ms. Murray seems to suggest that abortion providers or abortion doctors or abortion patients are somehow protected by the Texas constitutional provision as to the equality clause. No court has ever held that, and the plain language does not apply or support an equal protection or violation of the equality clause of the Texas Constitution. Let's see, equality, and then Ms. Murray also raised two arguments about the right to privacy. And she said, and it's as I understand it as well, from their motion and from their pleadings, is that this is a claim brought under the Texas Constitution. This isn't a federal constitutional claim. Well, the Texas courts have never recognized a right to abortion under the Texas Constitution. Now, in federal court and under federal law, that may be different, but that right is not recognized by Texas courts. And so for her to argue that they're entitled to summary judgment on a right to privacy that has never been established under the Texas Constitution, there's simply no basis for that. And her second argument is on the right to privacy claim, is that, as I understand it, that these lawsuits might lead to medical records being at issue and therefore violate some right that a patient would have to the confidentiality or privacy of those medical records or procedures. That argument, people litigate over medical records all the time. I don't think there's authority or case law that says that litigation that would somehow implicate medical records or a statute like a medical malpractice statute that somehow could give rise to medical records being at issue is unconstitutional, violates the right to privacy. I'm not aware of any case law that has held that, certainly not in Texas. And so the claims that they're making on right to privacy under the Texas Constitution simply aren't rights that exist under the Texas Constitution. There are several other claims that they make under the Texas Constitution. They haven't addressed those yet or raised those. If they do, I'm happy to respond, but to the extent they don't and want to move it more quickly, we can just refer to our briefing, and those claims are laid out in their motions for summary judgment, but those pertain to free speech, ex post facto clause. I'm not sure which of the two groups of plaintiffs are alleging those, but my response to those is similarly fairly straightforward, and that Texas law does not support motions. There's certainly not the grant of summary judgment on those issues.
Yes.
Your Honor, I'm going to move in just a second into the First Amendment piece that Mr. Stevens just began touching on with regard to aiding and abetting liability. But first, I just wanted to point the court to a couple of things related to the rebuttal that he gave. One is on the retroactivity piece. There's a difference between what SB8 says in terms of its prohibition for the 6-week ban, which became effective September 1st, and the statute that Ms. Myers walked you through, which is 30.022, which affects cases that might have been filed beforehand. And that was the retroactivity argument that she was making. So I just wanted to make that clear. Also on the open courts.
You're thinking about abortion happened before September 1st.
I'm thinking about a challenge to the abortion law, because section 30.022 doesn't specifically relate to any abortion that took place after September 1st. It relates to plaintiffs or defendants who might raise a challenge to any abortion law. And it makes the attorneys and the party jointly and severally liable if they're the person challenging the law. That's the provision that Ms. Myers was referring to in terms of retroactivity, because it's not dependent on a post-heartbeat abortion or the beginning sort of layout of SB8, if you will. This is codified in the Texas Civil Practice and Remedies Code and does not specifically apply only to SB8 actions. It applies to any constitutional challenge on abortion laws generally. As to the open courts issue and the fee shifting or the awarding of fees, what I would like to note for the court is what Ms. Myers already previewed, which is that this is a unique scenario in that the fees only ever shift one way. They only ever shift to people who are advocating for abortion rights, for abortion access, or challenging abortion laws. And the open courts provision of the Constitution of Texas provides that citizens must have access to the courts unimpeded by unreasonable financial barriers. That is one of the provisions. And it's in that context that we believe that SB8 is unconstitutional with regard to its fees shifting regime. Not just because it deprives them of access to the courts, but also because it only deprives one content-based group of people with this set of rules that impact them just because they're advocating for reproductive justice or reproductive choice. I'd like to move into now the discussion about vagueness and aiding and abetting liability that Mr. Stevens sort of began a minute ago, and talk again about the liability without injury provision, which is section 171-208. This is the one that I went into great length on the standing piece with earlier, but we didn't really look at the conduct that is prohibited by SB8 and the impact that has on the constitutional rights of the plaintiffs who are social workers, who are counselors, who are lawyers, who are advocates, who assist women who are trying to access abortion. And for the plaintiffs from the non-Planned Parenthood side, all the groups and individuals that I just described, this is the provision that most directly impacts their constitutional rights. And I think it's important that we take a look at it. We've already covered the standing piece, which is any person can bring the civil action regardless of injury. I want to look now at the prohibitions and who can be liable. The first is anyone who performs or induces an abortion in violation of this subchapter. The second is more complicated. It says knowingly engages in conduct that aids or abets the performance or inducement of an abortion, including paying for or reimbursing the cost of an abortion through insurance or otherwise, if the abortion is performed or induced in violation of this subchapter, regardless of whether the person knew or should have known that the abortion would be performed or induced in violation of the subchapter. So a few things. One, it starts with a sort of mens rea requirement, which Mr. Stevens alluded to. But then later in that very same subsection, it says it doesn't matter whether the person knew or should have known that the abortion would be performed in violation of this subchapter. It also gives us no context for what aids or abets means, other than we know it means paying for an abortion in violation of this subchapter. While they go to great lengths in their response to the motion for summary judgment to say aiding and abetting is a common criminal term, I find that curious because it is not in the Texas Criminal Code. There is not an aiding and abetting within the entire Texas Criminal Code. And whatever that means colloquially, whatever that means elsewhere, we don't have a definition either in SB 8 or in the Texas Criminal Code to look at for what that means. What I'd like to point out, though, with regard to this is not only is it vague, not only could it apply to all kinds of things that the plaintiffs that I represent do, whether it's funding, advocacy, just donating to an abortion fund, referring someone to an abortion services provider, counseling, providing information, transportation, frankly, even just being compassionate could be constituted as aiding and abetting under this statute because it is so vague. But they're giving away the game when they point out the corollary to criminal law. What they're trying to do is criminalize something that the state cannot criminalize. And instead, they've taken all of these procedures that subvert the integrity of our judicial system and put them on top of a civil tort and said, we can't do it, but you can. And they're turning these people into criminals. That is the entirety of the purpose of SB 8. Even though they don't define aiding and abetting, even though they don't tell you what all might constitute that type of conduct, that's why the threat to the plaintiffs that I represent is so very real. They don't know what the contours of aid or abetting are. Anyone who helps pay for an abortion in whatever context, whether they knew it or not, according to this statute, could be held liable, strictly liable for the $10,000 penalty. Once again, that penalty gives away the game. That is a criminal penalty without the process associated with criminal law to ensure that your rights are not violated under the Constitution. And the belief of those who passed this law is that people can enforce in civil tort what the state cannot do criminally. But what they've done is taken a criminal rubric and put it in the hands of people who they don't even know. Texas Right to Life and John Segal are some of those people, and the people acting in concert with them certainly are. And that's why the declaratory judgment as to the constitutional rights of my clients under SB 8 is relevant with regard to Texas Right to Life and John Segal. But at the end of the day, we have a statute that violates the First Amendment in a variety of ways. One, it's vague. The aiding and abetting language doesn't tell you what counts. The next provision in the section says, section 3, intends to engage in the conduct described by subdivision 1 or 2. This subsection punishes mere intent. You don't have to take any action. You don't have to have actually undertaken any conduct whatsoever. But if you intended to help your daughter who wanted to access an abortion, you could be held liable by someone else. It's a content-based restriction insofar as it targets only those people who support abortion access. And because it's a content-based restriction under the First Amendment, it gets strict scrutiny. The impact of this restriction, conceded by all sides, is the chilling of speech and action that has happened in response to SB 8. And it subjects any person with even an attenuated connection to an abortion to suit without notice of what the prohibited conduct really was. Basically, anything that you do, if it could be construed as supporting abortion that takes place in violation of this law, you could be hauled into court and you're automatically responsible for damages. It forces those defendants into liability for fees, potentially also their attorneys into liability for fees for constitutionally protected conduct, and subjects them to suit anywhere in Texas. Ultimately, the First Amendment rights that are violated here are independent rights, unrelated to the right of a woman under the US Constitution to obtain an abortion. These are the First Amendment rights of people who provide information, who provide funding, who provide care. And that is the source of the target here. Your Honor, I know I'm speaking too soon, I'm sure in your mind, because lawyers tend to do that. But rather than get back up here one more time, I think for our purposes, Your Honor, we've gone through each of the provisions for the 13 non-Planned Parenthood plaintiffs that we believe are the most constitutionally suspect. I just want to remind the court, in the process of trying to be done and give some more time for the other motions, that these provisions are problematic in concert and individually. The first one, obviously, the idea of tort with no injury requirement, no standing conferred on anyone without injury and contravention of the Texas Constitution, that's immediately problematic. Those things also, however, impact on citizens' rights to open courts, the constitutional requirements that the legislature not usurp or deny co-equal branches of government their power. As Ms. Myers covered in her last time before you, it also implicates equal protection and due process concerns with regard to the very specific group of people who are being targeted by special rules, special fees, special treatment by the courts because of something that they are advocating for or believe in. And under the First Amendment, the law is impermissibly vague. If it facially violates the First Amendment by preventing people from donating money, which Citizens United told us is permissible. That is an important function of speech. It prevents people from giving information, which is a quintessential speech activity. It's burdened there, and the contours of it are so vague that people cannot possibly know what they're doing. This is a law that requires no injury, has a mandatory damages penalty of $10,000 for each person that touches an abortion, not each abortion, but each person who might have had some influence. The defenses that those people can raise have been severely limited by the legislature. There's fee shifting that operates only to their detriment. Their attorneys may also be liable if they deign to argue that the law is unconstitutional And ultimately, there's no idea for those who may be worried about violating the law for whatever their conduct, even if it really is providing a ride to their own daughter. They don't know what makes them liable under the law. All that's left to decide in this case, Your Honor, is the declaratory judgment. The issues with regard to irreparable harm have been conceded. The temporary injunction is done. All that's left here is the question of whether we have a controversy, a justiciable controversy between the parties, which I think is abundantly clear at this point. And two, can that be resolved by the court? It doesn't have to resolve the controversy as between the plaintiffs and every single person in the state of Texas or beyond. The question is, can it resolve the controversy between these parties? And it absolutely can.
I'm going to try to be brief, and we will largely rest on our briefs with respect to our remaining claims, but I do want to make a few final points with respect to our summary judgment argument. On fee shifting, the 30.022 provision, Ms. Eklund noted, or maybe it was Ms. Myers, it's late in the day, that it only shifts one way. It always goes against the abortion provider. I think what I would like to emphasize is that it is not just the fact that it is one-way fee shifting. There are other one-way fee shifting provisions, for example, in private attorney general suits, where there is a legitimate public interest in which the government is trying to protect people's ability to bring public interest litigation. We are not saying that one-way fee shifting on its own would be unconstitutional. To the contrary, there are good reasons why such provisions exist elsewhere in the law. However, the distinction between that type of one-way fee shifting provision and what is at issue in 30.022 is that the interest being served by that one-way fee shifting is an interest in, again, the suppression of a constitutionally protected activity. Typically, for example, civil rights plaintiffs, if they are bringing a civil rights claim in federal court under Section 1983, for example, there's a one-way fee shifting provision where they can, if they prevail, get their fees from the government. But that fee is in service of the vindication of civil rights. Here, the fee shifting of SB 8 is in service of the suppression of a clearly established constitutional right, and in fact, the chill of that right such that people never are even able to bring suit. So I think that that is a distinction to the extent that Your Honor reaches the issues with respect to the fee shifting in this case. That distinction between SB 8 and other types of one-way fee shifting provisions, I think, is actually critical to why SB 8 is so harmful and why it is unconstitutional, whereas other one-way fee shifting provisions may be constitutionally appropriate. With respect to the equal protection claim, I do want to clear up a few things. Mr. Stevens quoted to this court language from the Texas equivalent to Equal Rights Amendment. So that is Article 1, Section 3A. Equality under the law shall not be denied or abridged because of sex, race, color, creed, or national origin. To be clear, that is not this constitutional provision under which we have asserted an equal protection violation. We are instead asserting an equal protection violation in reliance on Section 3, not Section 3A. Section 3 deals with equal rights and says all free men, when they form a social compact, have equal rights, and no man or set of men is entitled to exclusive separate public emoluments or privileges, but in consideration of public services. At pages 30 to 32 of our motion for summary judgment, we lay out why under this provision, the appropriate one that we have actually brought suit under, rational basis review alone, even if the court didn't apply strict scrutiny, rational basis review would require holding that the set of procedural and substantive rules that SB 8 applies to enforcement proceedings is a violation of the guarantee of equality under the law in Texas. And for that, I would, again, at page 32 of the motion for summary judgment, we cite, for example, Ford Motor v. Sheldon. That's 22 SW 3rd 444. And that case sets forth the standard for rational basis review under an equal protection challenge. With respect to the right to privacy, Mr. Stevens again stated without response to any authority that we have identified or citation to any authority of his own that there is no right to abortion under the Texas Constitution. Again, I would direct your honor to our motion for summary judgment, where we have identified numerous cases, including from the Texas Supreme Court, in which it has expressly interpreted the right to privacy under the Texas Constitution with reliance on Roe v. Wade and other seminal cases in the federal context, protecting a right to make decisions about procreation. So the Bell v. Low-Income Women of Texas case, the Ex parte Tucci case, there is a discussion of the Texas protection for a right to bodily autonomy and privacy in that case as well. Again, there's been no response from Mr. Stevens or his colleagues on that, either in writing or in this court today. And with respect to the other right to privacy things we have about someone's privacy to keep their medical records and medical decision-making to themselves, I would push back strongly to Mr. Stevens' suggestion that people litigate over medical records like this in the SB 8 context all the time. That is simply not true. This is not a medical malpractice case, for example, or a Social Security disability case, where a claimant themselves decides to put their own health condition at issue, understanding that as part of the public proceedings in a court, that part of their medical records may become open to the public and open to public scrutiny. In that case, it is the patient who has the decision whether or not to put their medical records at issue. Other contexts you could imagine, for example, include state medical boards. You could imagine, for example, if a doctor is accused of some kind of wrongdoing, that there may be patient records at issue in that context. But in that context, you are dealing with state officials who have some responsibility to uphold the Constitution, to maintain privacy. You are not dealing with any random stranger in Texas or elsewhere who is coming in and inserting themselves into the doctor-patient relationship and claiming a right to information about an abortion that has nothing to do with them. So I actually don't think that there is any other example, at least that I'm aware of, in which the state of Texas has allowed the public writ large a right to effectively invade a patient's medical records and put their decision-making at issue without their consent. And I would point the court to section 171.208 E6 of SB 8, where it expressly says that a patient's consent in an SB 8 enforcement proceeding is irrelevant. So even if a patient sought the abortion, consented to the abortion, and didn't want anyone suing over their abortion decision, that would be irrelevant under SB 8. Those were the only rebuttal points that I had as to the earlier topics that we were talking about. And then the final point that I would make, as I said, we will largely rest on our briefs with respect to our other claims. But the final point that I would make is that as to aiding and abetting liability, I do just want to be clear that the Planned Parenthood plaintiffs are asserting that SB 8 violates their rights, not only because it prevents them and their doctors from performing abortions after approximately 6 weeks, but because it also imposes aiding and abetting liability on them and their staff. So whatever the outer bounds of the aiding and abetting liability prohibition or aiding and abetting prohibition under SB 8, it is clear that it would apply, for example, to nurses who are involved in the provision of abortion, to ultrasound technicians who are involved in the provision of abortion, and of course, to my organizational clients who are, along with their staff, ensuring, helping to provide or to assist in the performance of abortions that if they were to defy SB 8 would be in violation of that prohibition. So I would point your honor as to aiding and abetting liability, the Melanie Linton Declaration at paragraph 7-8, the Barraza Declaration at paragraphs 3, 6, and 15, and the Lambert Declaration at paragraphs 8 and 9, where they lay out the activity in which they engage, not just the provision of abortion, but other activity that would clearly come within the scope of aiding and abetting liability under SB 8. So with that, your honor, I don't have any additional argument about our claims. As to our motion for summary judgment, we would urge your honor to decide the claims in our favor. And I think in terms of the scope of the claims would just emphasize that much of the discussion this afternoon about various provisions, whether they are unconstitutionally retroactive, whether they violate due process, whether certain provisions are violations of equal protection, I think the court need not reach those questions if it is deciding that SB 8 imposes an unconstitutional delegation of executive authority and grants that to the private citizenry. The court could essentially, certainly you could decide the case in any number of ways, but I think those claims are not strictly necessary to be resolved if the court instead, under a right to privacy theory or under a non-delegation theory, were to decide in favor of the Planned Parenthood plaintiffs, which we would urge you to do.
Do you think that severability provisions, if there were a ruling that the delegation is improper, follow the severability, wouldn't that be a whole lot of law?
Well, I think that severability is an issue that, to the extent that your honor is considering trying to sever out these various provisions, I think that I would urge your honor to permit additional briefing on that. That's not something that the defendants have raised in their opposition to our motion for summary judgment. So I do think that it would be helpful if your honor is wrestling with that to have some additional briefing on the issue of severability. What I would say with respect to non-delegation is that the non-delegation claim, if you were to decide it in our favor, would wipe out the enforcement scheme of SB 8. And because SB 8 expressly prohibits direct enforcement actions by government officials, there would be nothing left to enforce. Now, I think the Planned Parenthood plaintiffs do actually believe that there are other ways that government officials could indirectly enforce SB 8, and that is an issue in the federal litigation that the US Supreme Court is currently considering. But that, candidly, although that is certainly a problem for us, it is not a problem that your honor can solve in this case against Mr. Sego and Texas Right to Life. So that is something we are dealing with in the federal litigation. But for purposes of our claims against Mr. Sego and Texas Right to Life, a ruling on the non-delegation claim in our favor, I think would mean that you don't have to decide whether, for example, if the venue provision is an unconstitutional violation of equal protection, whether that can be kind of extracted from the law and letting everything else stand. I will say from the perspective of the Planned Parenthood plaintiffs as well, Your Honor, that the overwhelming threat of this litigation is incredibly strong. And so I would urge you, to the extent that you are inclined to rule in our favor on some claims, I guess I would impress upon you that kind of slicing and dicing the law, picking certain provisions, but leaving other enforcement provisions in place is very unlikely to provide full relief to the Planned Parenthood plaintiffs, even as against Texas right to life and Don Siegel. So I think the clearest, cleanest way to resolve our claims as against these defendants are on the grounds that I have mentioned. And certainly Your Honor could decide any number of those claims, but I do think that the more discrete claims about particular portions of the statute about venue or fee shifting, they are important claims. But resolving only one of them in our favor is not going to make the dispute go away. It would not actually resolve the dispute in a way that would provide kind of a streamlined way of dealing with
Unless
the
that
case.
one issue is non-delegation.
Non-delegation, or as I said, the right to privacy with respect to abortion. Because if you cannot prohibit the abortion, the aiding and abetting liability falls away, as does the enforcement mechanism. Thank you, Your Honor.
Judge, I don't have anything else, I guess, on this portion of the argument as to the specific claims, but would again reiterate that we don't think that it's appropriate for the court to consider the merits of summary judgment when we think lacks jurisdiction for standing reasons. And
We're going to move to those very quickly.
Okay, yeah.
Right.
Yes, Judge.
I'm not forgetting that.
Okay.
Mr. Stevens or Mr. Hackman, Ms. Hacker, ask a question or two. You're not going to go to the podium. If these procedures are constitutional, it's a matter of state law. I mean, that's the ultimate ruling. Well, I want you to talk to me about whether they could be transplanted by later legislatures in Texas or by other people around the country aimed at either different areas of Supreme Court law or different businesses. That some of us here might not like. I mean, in deciding constitutional challenges to a set of procedures like this, which are, this is the first time. Everybody agrees on that. There, it seems to me, could be people all over the country. And again, in later legislatures in Texas, as the years go by, that might say, those were upheld in the abortion case. Let's use those procedures to take out other businesses that we don't like. And here's an example. Colorado and the Masterpiece Cake Shop case. Suppose a state says, we're not satisfied with the effectiveness of our administrative agency. We're impressed with what Texas did and was upheld. We want to empower people to sue bakeries that won't put a message that they don't like on the cake and put them out of business that way. And that kind of thing might happen. And so it seems to me that when in deciding some of these issues, the potential of a set of procedural weapons that they might be used in other contexts, that's got to be on people's minds.
Your Honor, I think the Masterpiece Cake Shop example that you gave is a very good example because that is the state of the law right now. People can sue cake bakers for not making a cake with the message they like. That's what the Masterpiece Cake Shop case was about. The baker didn't want to bake a cake that he felt would violate that conveyed a message that violated his religious beliefs.
It may have been religiously based, but the principle is still there.
Yes.
There's some First Amendment law that says I don't have to, you can't make me speak and state a message I don't agree with.
Right, but nonetheless, the Colorado anti-discrimination law said that a person could sue Mr. Phillips. And in fact, an action was brought against Mr. Phillips, and that was the genesis of the Masterpiece Cake Shop case. And so Mr. Phillips.
So that may have been an agency. They're an administrative agency, they're not a private lawsuit like these, I think.
Well, I think that the private individual had to bring a complaint to the administrative agency, but let's say it was a private individual. Still, I would say that our standing principles would not allow Mr. Phillips to preemptively sue everybody in the state or certain people that have expressed viewpoints against his religious views. Case law does not allow him to preemptively sue them, right? Instead, he had to wait to actually be sued. And so there was a chilling effect there. Like every business in Colorado that has to decide between their religious beliefs and potentially being liable under the anti-discrimination law had a choice to make. He made the choice that he was going to stick to his beliefs with respect to, and he was subject to civil proceedings as a result of that choice that he made. And he had to wait in order to be subject to those proceedings in order to assert his constitutional claim that in fact, this prosecution of me under this statute violates my First Amendment rights. And so that's really the issue here. And what's made these cases difficult is that it's because of this pre-enforcement context that we have that problem. And in that, so if we would not say that Mr. Phillips could preemptively sue people because he's afraid they might sue him, then we shouldn't say that in this case, the abortion providers should get to do the same thing. I just don't think that.
But if a legislature decides that Texas, their system was upheld, and we think we'd like to use those procedural tools for different goals. And the bakery, people are afraid to work there because if you work there, just clock in and get a paycheck, you're helping. And that person could be, could get a judgment against them for $10,000, be recorded in the real property records. They try to sell their house. Problems. And people might not want to aid and abet or help the little bakery. And I'm just wondering if Pandora's box is getting ready to be opened.
I don't think that it is, Your Honor, because I think the thing that makes that I think under normal circumstances, if the right is clearly established, then I don't think people would reasonably fear being held liable in a civil action. They would be willing to just say, no, I'm going to assert my rights here and have confidence in the fact that case law protects that right. If SB 8 is as blatantly unconstitutional as the plaintiffs think it is, I don't know what they're afraid of in this context. It seems to me that, and actually I believe it was the US Solicitor General in the United States versus Texas argument, said that we expect that any actions brought under SBA, so that there will be no liability because SBA is clearly unconstitutional according to her. If that's the case, there is no reasonable fear of liability. I think the problem here is that everyone knows that the right to abortion is not sufficiently clearly established because the Supreme Court is hearing arguments in the Mississippi case on December 1st. And the question presented in that case goes directly to the continuing validity of Planned Parenthood versus Casey. And so if it was another type of right that was clearly established, say the right to religious beliefs or the right to own a handgun, no reasonable person would think that a court would actually hold them liable for the exercise of that constitutional right. So I think that's what makes this situation different from those other ones.
We'll weigh in on that question.
Yeah, sure, just briefly, I think you're asking exactly the right question. Oh, my apologies. And it really is crystallized by the claims brought by our 13 clients, because again, we are not challenging the 6-week ban directly. Frankly, for purposes of our summary judgment, you can assume that the 6-week ban is fine. And that it is the enforcement mechanism that is the problem. And so that enforcement mechanism can be picked up and attached to any right, constitutional or not. And the problem is the constitutional infirmities of the procedures themselves. I'm not going to say that there's not a constitutional right to abortion. Roe v. Wade's the law of the land. But with respect to the constitutional challenges before you in our cases, it is simply to the enforcement mechanisms itself. And it's because the state is delegating a state desire to a private set of citizens, all citizens, regardless of harm. And for a private cause of action, which is what the defendants keep saying this is, you need an injury. You need a duty that gets violated, you need an injury to the defendant, and you need to link those things together to get damages. There is no harm required here. Anybody can just file the lawsuit, prove an abortion happened, and get $10,000 or more and fees. And I think the reason everyone is struggling with how do you cabin this into the various lines of precedent is, one, as you properly recognize, no law has ever done this. No state legislature has ever tried to do this. And the reason that we keep coming back to the defendant's argument of, well, of course we can do this, is because they don't recognize that you need an injury. There has to be an injury for a private tort cause of action, which is what they keep saying this is. They keep saying there's no state action. It's not penal. It's not actually criminal. The truth is it is. It's a prohibition on behavior that is enforced through a minimum statutory penalty that is not compensatory. It's punitive, and it's meant to deter behavior. It is a functionally criminal statute that they know they cannot enforce through government action. And so instead, they're saying everybody in the world can pursue our government interest. It's never been done before, and frankly, I think it's an interesting thought experiment, I guess, about whether you could do it. But the state's not here before you because they say they have no interest in anything. So there's no state interest, there's no state harm. There's no harm to the individuals who are bringing the cause of action. And you're absolutely right that it's not dependent on it being an abortion restriction. That set of procedures can be lifted and moved to anything else.
Just a couple of points. On the masterpiece cake example, I did want to follow up on Ms. Hacker's comments because I actually looked at the Colorado statute, and that said Colorado Code 24-34-602. It grants the right to sue not to anyone in the world or anyone in the country, as SB8 does, but to quote, a person aggrieved by a violation, end quote. And the same with respect to a complaint going to the, as Your Honor correctly said, that case involved an agency. The agency complaint process at issue in that case, the statute applicable to that's at 24-34-306 of the Colorado Code. It also says that, quote, any person claiming to be aggrieved by a discriminatory practice, end quote, can file a complaint. There is nothing like SB8. And I think in terms of the implications of what defendants are arguing with respect to SB8, I would actually point, Your Honor, to what the Texas Solicitor General candidly said to the US Supreme Court just days ago in admitting that the model of SB8 could be used, it doesn't depend on the right at issue, and it could be used for other things, including gun rights, including First Amendment issues. I think that Your Honor is exactly right to be concerned about where this experiment of Texas's ends, because it's not going to end with abortion. You could envision, for example, a state doing the same thing with birth control, with same-sex marriage, with interracial marriage, with free speech issues, with public health issues if people refuse to get vaccinated. You can envision all sorts of scenarios in which a state decides if they can't do something themselves, they're going to turn it over to the populace at large and let the mob essentially threaten people who are engaging in conduct that the state doesn't like. I think you are absolutely right to be concerned with that. And for those reasons, we would ask Your Honor to grant summary judgment in our favor.
We still have on our agenda the motion to dismiss based upon the TCPA and the view of the jurisdiction. Let's take 15 minutes.
Exactly. All the way up there. And then there's water. It's also like that.
I know. I'm just like looking for a charger. I'm gonna go over there. I'm not looking to do
Oh, yeah. She can,
I mean, you can carry me back.
yeah. But she can like fend for herself for a while.
Yeah. Anna, your cute computer. Huh? Your cute computer. Oh, yeah, there's not much.
Cute computer.
Oh, yeah. I love it. Very clever.
Yeah.
Is anyone staying in there?
I am. I'm just looking at pace. That's what I'm doing.
It's like, I want to go take some stuff to the car and come back.
You can leave your bag here.
Girl, I want my bag, but I don't want chips and.
That's, no one's gonna go that way.
I'm gonna take
Just put it
my
under the
chips
chips.
to the,
And then-
oh, there's cheese. That should be. No.
I'm gonna just put it on the TV. I might go get soda. Let me check.
Does it take cards?
I don't know, but I'm gonna go check. You want something? What do you want?
Coke Zero, I love it.
Okay.
I might do full Coke.
Huh?
Full Coke.
You wanna come?
Yeah.
I know, I might do full
You
cook
staying
too.
here?
I'll stay here till y'all get back.
Okay.
I'm leaving
I was like,
my
I'm here. I was like, my laptop's right there.
I gotta get with you on the bag to go to that. This is a good wallet.
I
You
have
got, you know
a-
what I mean?
I have a
You're good at
Samsonite.
packing.
I have a
You need to
Samsonite
do
one like this.
packing video.
Well, maybe I'll do a packing.
Yeah, you should.
Section.
You should.
Oh my God. I'm like the worst. I'm like the worst.
Oh, thank you.
I'm worth like 18 things for everything. Right. Different things are like things that I'm doing with.
Been wearing a mask for 2 years, so I haven't gotten a cold until right now.
No, I'm mad about it.
2 days ago, I was like, what?
What is this? I don't even know what this is anymore. But I feel like my house, unless I do like air right now, does do a good job, like.
People won't email you.
It really
Like
does.
they're like, oh,
Yeah.
we'll leave them off,
That
or
really
we'll wait.
kind of amazing.
Yeah, I love it.
I
It's
email
true,
you
you
no
can-
matter what. I
You
know
emailed
you-
me, yeah,
no
that's
matter
fine. You're an exception. I'm talking about the general.
Like, Conrad's busy. It's not busy.
No, never, John. I think we got, I'm Conrad.
Hi, I'm Cammy
I
on.
can't, yeah. I think
Yeah.
we actually have. At some point, maybe it was virtually.
Probably on the computer.
Yeah, that's right.
I'm gonna stand in front of the air conditioner for a minute.
Do anything you need. Y'all with these heels, I just can't do it.
It's
3 minutes to turn on here.
Yeah, I didn't either. I guess it's like year end. 7.
Do y'all have like a little secret room? No,
Back to the office, that trial.
Yeah. Not for one day here.
That's a lot of years.
Chilling, trying to digest it all. Man.
We see like.
I'm gonna go switching channels until
I keep using your phone. It's in the phone.
Which
It's in
one?
your phone. The one about.
Oh, yeah.
I hear that so many meetings. And I'm just like, it's so true.
Because also like,
We do.
on top of the year or
Right.
two that everyone's had,
Right.
like, this is too much.
I know. Well, it's just like. It's just like, you know, I poke you a lot. That's true. It's like. It's like this was- Yeah. So, yeah, totally. Thanks for everything you guys have done.
I'm so glad you're here and people, I'm so glad we had.
I know we had good.
And we couldn't have taken photos of them.
I think we should get on the room.
This area is empty.
Yeah, I just did a couple of these. I'm sitting over there. But
Good.
not everyone. isn't. But we could have like, actually, no. No, for a while.
I thought we were not. But I understand the issue.
Oh, no.
They missed it, I mean, not like that, but it was kind of big, so.
Because
I
I
might
think
actually
it's funny
try
that it's
something
really
how to do it.
Okay. It's giving me my own person.
That is-
All day.
Whatever cut, already covered everything.
I saw carved in the ear.
I saw all the years, I saw the years. It's the, it's the, like their Mexican.
So I was curious what you looked up.
Oh, really, y'all? Wow.
Crazy.
That is wild.
And then like, they look like they're out of an Angelina ad, like.
Very fair.
I was gonna say that also.
Yes. Anyway.
Yeah.
We're seeing that while we're in here.
Yeah.
You know.
Yeah.
Yeah.
Included.
So that was.
They
That would be entertaining for a minute.
issues and we kind of heard a professor that.
Someone
Specific
honor.
and specific development.
Yeah.
Everyone was.
I mean, I went and talked to my partner. Also, it's just like a learning
Issue that we address throughout the whole year. And then we presented.
I know, I
to
kind of
the
feel like.
last month. And created.
I forgot, I didn't bring my gift in here, but it's a picnic, I have to take outside and I have to take to differentiate.
Right.
This is a little more. It's a pattern. Yeah, precisely.
You really can't see that all.
Yeah, I gave her a little gift bag.
Well, sir.
Yeah, exactly. And then about a year ago, our firm, on the staff, created a culture. Like the main committee, culture club, where boy charge out. But we've had a book club. Every Friday.
I definitely.
Absolutely. I haven't heard that. I'm on there.
Oh. I someone just did it very
Yeah, yeah, yeah. I didn't know that she had.
Well, this is well. We're checking with the lot, and then-
Wasn't it turned out, so it wasn't?
I'm fairly sure.
No, it's a screen.
I'm gonna turn this off.
Yeah, I mean, that's what I'm like.
Right.
Right, all the way back.
So what's the long run?
That's what they consider an anti-racist. But it's also the one that's not very-
Right.
Five simple words.
I always said I'd do it.
Sure, right.
You're on the clock now.
Oh, okay, you're like, okay.
I was one to three lessons. And then I was, because I had small children.
Oh, you mean during the break?
Okay, I'm sorry. Yeah. Probably the higher. Yeah.
Through,
Yeah.
Zoom, like they don't want to be like right now.
Yeah.
He moves down.
Right. The nice. When I first did,
I wonder if
because
we said
No, nightclub was like a company. Like, look. What are you doing?
Yeah, you can do
Information about things like that.
Oh, yeah.
Tomorrow morning. I was like, I just dropped me out. Yeah. I don't think I do have a car.
Yeah.
Yeah.
He's
Right. Oh, yeah. I mean, I write great. Or I do not start giving them the training. Yeah, I can understand. Yeah.
Wouldn't stood there for a minute in the corner.
Well.
You see it, 3:30. Please, verification of that motion, research, the one you get first, to recommend.
So the defendant's plea to the jurisdiction was filed as to the Planned Parenthood plaintiffs on September 12th of this year. We believe that this motion is important to resolve before reaching merits because it ensures that the court has jurisdiction to entertain the rest of what's going on in this case. We've already covered some of the issues in the plea to the jurisdiction, so I won't beat the dead horse, as I think has been mentioned a couple of times here today, but I would like to just give another brief overview of the issues in the plea to the jurisdiction. There's 5 reasons that the court lacks jurisdiction here in each warrant dismissal. 1, the plaintiffs lack standing. 2, their claims are not ripe. 3, the plaintiffs lack third-party standing. 4, the plaintiffs assert constitutional claims against private actors. And 5, the plaintiff's claims for declaratory judgment cannot create standing where none otherwise exists. All of these 5 reasons are briefed, but for brevity, I'm going to just focus on the major issues here, or the most egregious. As we discussed earlier, the plaintiffs have brought constitutional claims against private actors. And as the Texas Supreme Court held in Republican Party versus Dietz, the Constitution applies only to restrain the government, and you cannot bring claims under the Texas Bill of Rights against private parties. That issue was raised, at least in my mind, when I was listening to the arguments on the merits of the constitutional provisions. Great example is non-delegation. How it has Texas Right to Life or John Seago delegated government authority. They have not done any actions that would violate the Texas Constitution under binding Texas precedent, which requires state action here. To the extent that the plaintiffs argue that they do have a cause of action under the UDJA, as the Texas Supreme Court held in Chenault, the UDJA does not create or confer standing. A plaintiff must establish standing in order to be able to establish a UDJA claim. And that's where the plaintiff's case runs into another roadblock. All of the plaintiffs lack standing, as we've talked about at length. The non-Planned Parenthood plaintiffs have contended here today that we have somehow waived the issue of standing because we agreed to the temporary injunction. That is blatantly false as a factual matter, but it is also false as a legal matter because standing is jurisdictional and therefore cannot be conceded or waived. In fact, even if the parties don't raise the issue of subject matter jurisdiction, the court is under the obligation itself to ensure that it has subject matter jurisdiction to entertain the claims. Even assuming that the plaintiffs have injury, which is what most of their arguments consisted of, that there's still a problem with causation and traceability because there is no action of Texas Right to Life or John Seago that is causing the plaintiffs not to perform abortions or not to aid and abet abortions. And the conduct that they are pointing to that's attributable to Texas Right to Life and John Seago is not unlawful conduct, with which the Texas Supreme Court in the Myers case, MEYERS, and the US Supreme Court just reiterated in California v. Texas that traceability requires allegedly unlawful conduct of the defendants. Nothing that Texas Right to Life or John Seago has done is illegal. As the other issue is redressability, as we've also discussed. And I think that the way that you can look at the two prongs that sort of illustrates what the problem is here is that if the plaintiffs got everything that they were asking, their injury would not be rectified because maybe they couldn't be sued by Texas Right to Life and John Seago, even though Texas Right to Life and John Seago said that they don't intend to sue them anyway. But assuming that they couldn't sue based on the court granting their relief, post-heartbeat abortions in Texas will not be resumed. And that is because Texas Right to Life and John Seago are only two people. So the injury that they're complaining of doesn't have anything to do with Texas Right to Life and John Seago. The redressability problem is also illustrated by the fact that if everyone else can sue the plaintiff still, and they're still going to be abiding by the law, a declaratory judgment or an injunction can only run against the parties to this case. There was discussion earlier about the persuasive effect a judgment of this court might have. But again, I would remind the court that that is the definition of an advisory opinion. And to the extent helpful, I would refer the court to an order issued by the Northern District of Texas in a recent case, Planned Parenthood Greater Texas Surgical Health Services versus the City of Lubbock. And at issue in that case was and actually a similar type law, but instead of prohibiting post-heartbeat abortions, it prohibited all abortions within the city limits of Lubbock, Texas, and it was enforceable by private right of action. And the federal judge in that case, so it was a slightly different law that we're talking about, but there were some of the same issues that came up in terms of standing, redressability, causation, all of that. And the court there recognized, because there, as here, Planned Parenthood asserted, just enter a judgment and that will prevent people from suing us. And the court rejected that, saying that that is the definition of an advisory opinion, which would exceed his jurisdiction. Now, he was talking about jurisdiction under Article 3 of the US Constitution. But I think that would apply here under these circumstances as well. Because the plaintiffs don't have standing, they cannot bring an EDJA claim. And again, an EDJA claim cannot reach other parties before this court. So if the court is concerned about the merits of the law, or picking out which parts of the law it feels are unconstitutional or not, it doesn't have to answer those questions if it looks at whether the court has jurisdiction to answer those questions to begin with. And again, we can't be distracted by the plaintiff's obviously very strong feelings about the validity of this law when they can't get past the first hurdle, which has to be, and which is important to constitutional jurisdiction or constitutional adjudication, which is, does the court have jurisdiction to entertain these claims in the first place? The answer here is no. And so we would respectfully request that the court grant the plaintiff or the defendants pleaded the jurisdiction as to all of the plaintiffs and dismiss the case. I'm prepared to talk about the TCPA motion to dismiss now, or would you like me to allow them to respond on the PJ?
If you want to do it all together, that's fine with that.
So moving to the TCPA motions to dismiss, the Texas Citizens Participation Act allows a defendant to seek dismissal of a legal action that is based on or is in response to a party's exercise of the right to free speech, right to petition, or right of association. Here, the plaintiff's lawsuits are based on and in response to the defendant's exercise of all three of those rights, and the defendants can easily meet the standard required to invoke the statute. I think that's become even more clear today, Your Honor, with the arguments that the plaintiffs have presented. In fact, it's a little ironic that I believe it was Ms. Eklund who said that people who advocate for, quote, reproductive justice shouldn't be sued for that. But apparently, if you advocate for pro-life principles or in favor of SB 8, I guess it's okay for them to be sued for it. Well, the Texas Citizens Participation Act says no, and that was exactly why the legislature enacted this law. Throughout their pleadings, they consistently attack Texas Right to Life and John Seago, and consistently here today for their advocacy of SB 8, for encouraging people to bring lawsuits if SB 8 is violated, and for a website that they had that was up for 3 days while the law was in effect. Those things are all protected by the First Amendment. Texas Right to Life and John Seago, even if they wanted to bring a lawsuit under SB 8, that's protected under the right to petition under the First Amendment and under the open courts provision of the Texas Constitution. They've done nothing illegal by advocating for these things. And in fact, all of these things are affirmatively protected by the federal and state constitutions. This is a textbook example of a case that is brought against the plaintiffs because of the exercise of those rights. And that is why the court should grant the TCPA motions to dismiss. Now, getting into what the defendants have to satisfy in order to invoke the statute. The TCPA, so that's Civil Practice and Remedies Code, Section 27, defines exercise of the right of free speech as a communication made in connection with a matter of public concern. Abortion, and specifically SB 8, are an issue of concern to the public. The plaintiffs are suing Texas Right to Life and John Seago because they advocated for the passage of SB 8 in the legislature, made public statements in favor of SB 8, and because they had a website. Those are all core First Amendment protected speech activities. A plaintiff's lawsuits are also aimed at Texas Right to Life and John Seago because of the exercise of their right to petition, which the statute defines as either pertaining to a proceeding of a government body, such as the legislature, or, quote, communication that is reasonably likely to encourage consideration of an issue by a judicial body or public participation in an effort to effect consideration of an issue by a judicial body. Texas Right to Life and John Seago's speech related to the legislative consideration of SB 8 and in favor of encouraging individuals to bring lawsuits under SB 8 falls squarely under the protection of both the First Amendment and the Texas Citizens Participation Act. We can clearly meet the standard required to invoke the statute. So now the burden shifts to the plaintiffs to establish a prima facie case by clear and specific evidence for each essential element of the claim in question, and that's section 27.005C. The plaintiffs cannot establish a prima facie case because of the problems that we've consistently pointed out in our plea to the jurisdiction, as we've briefed in the TCPA motions to dismiss, as we've briefed in our MSJ response. Just a few, there's no cause of action because there's no state action. There's no standing because there's no traceability and causation to either the acts of Texas Right to Life and John Seago or any acts by them that are unlawful. And there's no redressability because relief will not rectify the injury that plaintiffs are claiming to suffer. The case isn't right. And also, if one gets beyond those jurisdictional arguments, all of their claims fail on the merits for the reasons that we've briefed in the motion for summary judgment response. So the plaintiffs cannot establish a prima facie case, and that means that the court should grant the TCPA motions to dismiss. We request that the court grant those motions and award defendants attorney's fees, and that the court would also provide an opportunity for us to submit evidence quantifying those fees at a later date.
As I mentioned earlier today, I mean, I'll agree with Ms. Hacker that there's a lot of irony in the courtroom, given what the law does and what this case seeks to figure out in terms of what is and is not constitutional. But again, the temporary injunction, the standard for the temporary injunction has been agreed to, and this court has already entered findings which the defendants agreed to in form and substance that found there was an underlying cause of action and that restraint of the defendants was likely to prevent irreparable harm. That is an admission that this court can consider.
Somebody have a copy of the temporary injunction. Andy? get back to you. I just didn't bring all that.
Your Honor, it's actually,
Why don't you take
we
it
don't
out?
have a,
Take it out, there's 3 pages, I think. Yes.
this is the order and the exhibit that was attached to it.
Where's the language that, Mr. Stevens, the language that you say,
Language in the order is at. Well, it includes, it's in the findings. And the first finding is that the court finds plaintiffs will be imminently and irreparably harmed absent a temporary injunction. Is that corresponding to
yeah,
your?
let me read through.
Okay.
At the top of page 2 is the following language. In the interest of resolving the plaintiff's application, the defendants agree to stipulate to the entry of this order, provided that the defendants do not admit to the truth of plaintiff's allegations or to liability, and defendants do not waive any defenses or objections to this suit.
Yes, Your Honor.
How does that protect them from waiver?
It protects that they don't waive their defenses to the suit, and the court can take standing into consideration at any time. I'm not trying to argue
Is
that.
that not broad enough to keep you from saying they've agreed to irreparable
Well,
harm?
then let me rephrase, Your Honor. In 13 different TRO proceedings, a court found those things existed. This court entered a temporary injunction that they agreed
So
to.
it's not this injunction, it's the other ones?
There's 13 TROs that were entered, and then this one was entered with substantially the same language. The difference is that they agreed to this one rather than having the hearing. But the admissions in terms of,
I just want to make something very clear. If her position is that we have somehow agreed or consented to findings that the plaintiffs are now going to rely on as a factual basis for summary judgment, then we'll just withdraw our consent and agreement that led to the temporary injunction. Because that's absurd. I mean, we put that language in there for this express reason. I discussed it with Ms. Myers and said, we're not intending to stipulate to any of these findings for purposes of future proceedings or rulings by the court. And we put that language in there so that we're not held to some finding that was agreed to by the parties. If that's how they're going to interpret this, we'll withdraw our consent to the temporary injunction.
I understand there's an issue on that. And I will go ahead and hear you out.
Your Honor, and I don't mean to assert that that's our only evidence. We attached 2,000 pages of evidence to the TCPA
But you do
response.
mention that.
I'm sorry?
You do mention the injunction that I signed, which was agreed, and the other 13 that were before I was on this case.
Yes, I do for the purposes of establishing that this question has already come before the court. The question of whether there is standing has already been adjudicated in some form several times. And I'm just pointing it out for the court's addition to the evidence that we provided, that we would have provided at the temporary injunction period, which we instead attached to the TCPA response.
Let me make this statement. I'm inclined to agree that with the language that I read, I'm not prepared to accept your assertion that they waived anything or they're bound by anything in the injunction in terms of irreparable harm for summary judgment purposes. If I change my mind, I'll give you a chance to argue before I do. Okay, but if that's all there is to establish the recitals that were in there, I know it's not all, but if I'm going to give that any weight, I think that the defendants are entitled to know about it and to argue before I do that. I pledge that I will not give it weight without giving you a chance to come back. Okay, you're going to need to have something else, and you may have it. But that's enough on what was on their agreement to the injunction.
Understood. The plea of the jurisdiction against my 13 clients was filed last Friday, but because it's substantially the same as the standing argument they've made in the TCPA motion that they filed against our clients, I think the issues overlap entirely and dovetail. What the plea of the jurisdiction requires, or what Ms. Hacker listed as the 5 issues that were raised in the plea of the jurisdiction, which are, again, for us, our response was filed in advance of the plea of the jurisdiction, to the extent that the TCPA response was filed Wednesday and their plea was filed Friday. But I think all of those issues are taken care of in the TCPA response that we provided and all of the evidence that we attached to that. And we did file a plea to the jurisdiction response this week after we had received their motion on Friday. But as to the issues of standing, the question under the Declaratory Judgment Act is not whether there was some unlawful conduct. The Supreme Court of Texas has provided in Brooks versus North Glen Association to the question, does a trial court have jurisdiction to declare the rights of parties who are not before the court? They say a declaratory judgment requires a justiciable controversy as to the rights and status of parties actually before the court for adjudication, and the declaration sought must actually resolve the controversy. This is a unique law, Your Honor, in that the state does not enforce it. The question is, who are the parties who are going to enforce it, and are those parties before the court? Here, the plaintiffs in this case, as has been demonstrated throughout the evidence for an argument for summary judgment, the plaintiffs feared lawsuits. They feared it because Texas Right to Life repeatedly said, and that's part of the TCPA evidence that was provided to Your Honor, that they repeatedly said that they intended to enforce the law. They established a whistleblower website trying to get tips to bring people in who found like they knew there was aiding and abetting conduct. They sent out emails claiming credit for passage of the law and calling it their law. They put up a second whistleblower website after the first one came down, trying to do the same thing again. There's evidence attached to the TCPA response that is evidence of coordination between defendants and other groups, such as Texas Values, Right to Life East Texas, Students for Life America, which is related to enforcement of SB 8. There were declarations of the interveners in the USA versus Texas case that showed that there were people working to organize around SB 8 enforcement. There is evidence in the TCPA record, for Your Honor, that Texas Right to Life was advertising attorney training sessions related to SB 8. There's a transcript that's exhibit A18 to the TCPA response of Elizabeth Graham, who is the director and vice president of Texas Right to Life. It's a video where she talked, it's called What You Need to Know About the Texas Heartbeat Act. And it recruits and talks to people about the importance of enforcement and how they as private actors are planned to enforce. And even after the lawsuits were filed and restraining orders were issued, Texas Right to Life repeatedly posted on their own website that their plans didn't change, that they just couldn't enforce, they weren't going to enforce it, similar to their declarations here with regard to the summary judgment, Your Honor, that they were not going to enforce it against anybody who was complying with SB 8. Well, that's, I mean, it's a circular problem, because the whole problem is that they're worried about that the plaintiffs are legitimately worried about what conduct they believe violates SB 8, because the statute is vague, because there are plaintiffs who do provide funding for abortions, because there is a time period when the injunction was in effect, where abortion did take place. All of this evidence, and as I said to Your Honor, there's about 2,000 pages of it in the TCPA response, but all of it establishes what is important for standing under the Declaratory Judgment Act, which is the question of whether there's a controversy between the two parties and whether the declaration will resolve it. All the discussion about unlawful conduct doesn't make sense in terms of the Declaratory Judgment Act. The Declaratory Judgment Act, while it does not independently confer standing, it tells us what standing means for the Declaratory Judgment Act. If the Declaratory Judgment Act required unlawful conduct, it wouldn't make any sense. Two people who were parties to a contract couldn't come into court and ask the court to decide their legal status under the contract. That's exactly what the Declaratory Judgment Act is set up to do. That's also why it matters that you have the right parties in the room. They may argue that we don't have everybody in the state of Texas or elsewhere who may enforce the act in the room, and therefore we don't have the right parties. But we do have them, and we do know that they did intend and do intend, based on their repeated assertions, to continue being the voice advocating for enforcement of the act. So insofar as the question truly is there a controversy? It can be nothing but abundantly clear, if not just in regard to the opposition to the motion for summary judgment that these parties are on opposite sides of the issue of whether SB 8 is constitutional. There is evidence in this court's record with regard in the TCPA response, as well as the summary judgment record, as well as evidence that was submitted at previous hearings before the MDL was instituted, that established that there was a real risk of irreparable injury if they were to be sued. There were no lawsuits because restraining orders were put into effect. The causation and redressability issue that Ms. Hacker raises is unique because it is a Declaratory Judgment Act case. While it is true that that Texas Right to Life is not the legislature who passed SB 8, they are the enforcers to whom power was ceded by SB 8. So in one set of litigation, defendants are arguing we're the wrong people, you can't sue the state, we've washed our hands of it. And in this set of litigation, the people who took responsibility for being the enforcers are now saying there's no standing against us either, because we're saying today that we're not going to enforce it against you specifically, as long as you do what we've asked. The question then is there a controversy? And I think it's abundantly clear to the court that there is. It is right because the constitutional rights are already being invaded. And that is the status of the law with regard to when declaratory judgment actions ripen. You don't have to wait until the awful thing happens before the legal rights are declared. That's the purpose of the act itself. The question about private actors and constitutional claims is an interesting one because the declaration that is sought relates to the law itself. But the relief or the impact of that declaratory judgment would mean that Texas Right to Life could not sue the plaintiffs in this case because the law is void. That relief is real. These are the only people who have been taking credit and recruiting and trying to organize around lawsuits related to SB 8. So the idea that those parties would be bound is a very real form of relief to the plaintiffs in our case.
And that's different from an injunction?
It's different from an injunction, Your Honor, because a declaratory judgment declares the legal rights and status. So your declaratory judgment as to the constitutionality of the law doesn't have to enjoin anybody. I mean, I understand that Planned Parenthood has requested a permanent injunction. My understanding is that a declaratory judgment, were it to be issued, the courts expect that the parties will respect it. And if Texas Right to Life did not respect it, we would come back into court and seek enforcement around that. And that's my understanding of how Texas law works with regard to the declaration.
Temporary injunction, as long as it's still in effect, but I guess I'm not clear about how you enforce the declaratory judgment unless there's an injunction that goes along with it.
Well, and this raises the thing that keeps coming up in all of the litigation, Your Honor. The declaratory judgment expects that people will respect it. It expects that a declaration of the court is something that will be taken in and respected. It may only bind the two parties specifically, but every law, I think it's wrong to characterize law as persuasive. The fact of the matter is that Roe versus Wade decided a case as between two parties. And that is the point of Mr. Mitchell's writ of erasure fallacy article, that there are just those two parties and one of them is enjoined against the other. But the reality is abortion has been constitutionally protected everywhere in the United States since that decision was rendered. That decision has force and effect, and this court's decision does too. Presumably this goes up on appeal, and when it does, a decision by the Texas Supreme Court has impact on the entire state as well. The only way to determine the constitutionality of this law in a meaningful way is to make such a declaration, whether there's any injunction or injunctive relief sought or not. The plaintiffs in our case are entitled to come before you and ask for that declaration so that they can operate with confidence as to the constitutionality of this law, one way or the other. And that's what they've sought to do by invoking the Declaratory Judgment Act. Ms. Hacker brought up the case in Lubbock where the federal district judge said that they couldn't do anything because if they just said that the law shouldn't be enforced, it would be meaningless. That's because this was the precursor to SB 8 that was being considered in Lubbock. There was a city ordinance, much like city ordinances that have been passed throughout the state of Texas in the lead up to SB 8. And part of that city ordinance was the private enforcement mechanism that we've talked about all day today. And what that did was take the power out of the city and out of the city council and give it to private citizens. The scope of the act and the particulars were a little bit different. But what the federal judge decided was that his action towards the city council would be meaningless because they have no enforcement power. But Texas Right to Life does have enforcement power here. That is what makes them the necessary party. We didn't sue them based on First Amendment conduct. We sued them for declaratory judgment, not for damages, because that's what the Declaratory Judgment Act says is the proper thing to do. You have to join parties who have an interest. And they repeatedly, in the months leading up to enactment of SB 1, made clear that they were interested in enforcing the law and that they were going to take tips and they were going to take referrals and they were going to put their networks together to make sure that the law was enforced. That alone establishes the appropriateness of standing with regard to defendants. On the TCPA, Your Honor, the TCPA is not a scenario where a person complains that their First Amendment conduct is invoked and then the case goes away. What it is an early first look at the merits of the case to ensure that it's meritorious and not frivolous. In this case, they are obligated to first prove that their First Amendment rights are implicated. For purposes of today, I think we're willing to, let's say we assume, arguendo, that First Amendment conduct is implicated. But I would tell Your Honor, again, they weren't sued because of what they did. They're not being attacked for what they did. We're not seeking damages because of what they did. We joined them as a party to a declaration because they made it known that they had an interest. And that is what the law requires under the Declaratory Judgment Act. Having said that, all that is required next under the TCPA is for the plaintiffs to make a clear and specific showing of evidence of their own prima facie case. Once again, the elements in that case are that there's a justiciable controversy between the parties and that a resolution will resolve the controversy. Just because it won't resolve the controversy as to every person in Texas doesn't mean that it won't resolve this one. And the meaning of a declaration as between the primary declared enforcer of the law and my clients is incredibly significant. So we have to show Your Honor proof of those two elements. We did that for purposes of the TROs when we obtained them, and we've done that with regard to the evidence attached to the TCPA motion and to the summary judgment without going through, which I know would be painful for all of us, all of the evidence before the court with regard to those motions. I will point, Your Honor, to only a few things that I think are the perhaps most pertinent, but taken in combination with the total clearly establishes a prima facie case through the clear and specific evidence required. Those are the emails distributed by Texas Right to Life, calling the law their law and describing their intent to enforce it. The postings on their website, which are party admissions doing the exact same thing. The website set up by Texas Right to Life that started by asking for tips on abortionists and then shifted later to ask for tips on people who are making referrals to abortion providers. The evidence of coordination between Texas Right to Life and other groups and individuals, the declarations of Mr. Seago in the federal lawsuits, and the declaration of Mr. Markley Dixon in the federal lawsuits, all establishing that they know and have been working with people who plan to sue, and the transcripts from the video that I described from Elizabeth Graham talking about the enforcement mechanism and how they were recruiting for it. We've also have in the TCPA record, as well as attached to the temporary injunction before you, the declarations from our clients in terms of the services that they provided and have intended to provide in Texas despite SB 8. And I would direct your court also to the voluminous evidence that we attached to both sets of motions to establish the clear evidence that a controversy exists and that this court can resolve it. Once we've made a prima facie case and provided this court with clear and specific evidence to prove it, the burden shifts back to the, in this case, the defendant, but the movement of the TCPA to establish an affirmative defense, basically as a matter of law. They have not done so or attempted to do so, except for arguing that there is a standing issue, which is jurisdictional. Based on that, Your Honor, and on all the evidence that we've attached to the TCPA response, we believe that we've made the showing of a prima facie case that there is an actual live controversy and that this court's declaration can resolve it between these parties.
Right.
Right, thank you, Your Honor. On a few things on the plea to the jurisdiction and Ms. Hacker's presentation. As we discussed earlier today, we do have a cause of action that is appropriate in this case. I would point out, though, that these claims about whether we have pleaded the right cause of action are not claims that are jurisdictional. And so to the extent that defendants are arguing, with respect to the appropriateness of the pleas, we can certainly address that, but it is not a jurisdictional defect that would prevent Your Honor from reaching the merits of the case as opposed to providing some opportunity to replead. But I don't think that's necessary here for a couple of reasons. We have brought, the Planned Parenthood plaintiffs have brought their claims directly under the Constitution, as I explained earlier, on the theory that John Seago and Texas Right to Life are acting on behalf of the state, and therefore their activity should be attributable to the state as state action. So we can bring direct constitutional claims against them, for example, for violating our patient's right to privacy or violating the right to equal protection by attempting to enforce the unfair and discriminatory rules that SB8 would apply in SB8 enforcement proceedings that defendants might bring. However, Your Honor doesn't need to reach that issue because the Declaratory Judgment Act claim, we have also brought Declaratory Judgment Act claims. And as I explained earlier, the DJA claims can be brought between private parties and involve constitutional defenses. So I think the easiest way to think about this is that under the Declaratory Judgment Act, the idea is that the act provides a way for, as Ms. Eklund explained, adjudication of rights or interests of parties. And it's available even before there's a contract breach or something of that nature that's an issue in the Declaratory Judgment Act claim. So the DJ action is set up essentially as a mirror image of the underlying case. If you think about it, for example, in the patent context, it's frequently the case that someone is, threatening someone else that they have violated a patent that the person making the threats holds. And the person who receives that threat doesn't have to wait to get sued for infringement on a patent. They can instead, under federal law, file a federal declaratory judgment action. It's the mirror image of essentially the claim that is being threatened against the person who's bringing the DJ action. That is what we're doing here. Texas Right to Life and Mr. Seago have threatened to bring SB8 claims against us. That is the underlying cause of action. We, the Planned Parenthood plaintiffs, do not have to wait until Texas Right to Life and Mr. Seago actually do so. We can instead file a declaratory judgment action under Texas state law to seek this court's resolution of those claims. So the idea that our Declaratory Judgment Act claims are essentially these free-floating claims is just false. Even if Your Honor does not think of the defendants as state actors, the Declaratory Judgment Act claims are still proper because the underlying cause of action is the one created by SB8. In terms of the relief, I did want to follow up on something that the exchange with Ms. Eklund. The Planned Parenthood plaintiffs, as I indicated earlier, are seeking both a declaration of invalidity and a permanent injunction. And I can't speak for the non-Planned Parenthood plaintiffs, but I do think there are a number of reasons for that. But one of them, Your Honor, is that in the absence of a permanent injunction, if Texas Right to Life or Mr. Seago were to violate this court's declaration of SB8's invalidity as to their clients, we would not be able to seek contempt and sanctions against them in that litigation without the availability of an injunction. So for our clients, that is something that we are seeking in this litigation. I just wanted to be clear about the scope of relief that we're asking for. On the issue of standing that Ms. Hacker raised, we're not going to go through all of it. We certainly address standing both in our response to the plea to the jurisdiction and to the TCPA motion. And, you know, we have put in plenty of evidence, including on summary judgment, the declarations from our clients to support standing. But I do want to touch on a couple of things. One, Ms. Hacker argued that the injury here that our clients are suffering, and I would say that the defendants have conceded, they've not done so with respect to the non-Planned Parenthood plaintiffs, but they have conceded that the Planned Parenthood plaintiffs have suffered injury in fact. So that is something on which the parties agree. They haven't conceded causation and redressability, but they've conceded that the Planned Parenthood plaintiffs are suffering injury in fact. In terms of redressability,
Where did they do that?
I don't know, we can find the page site for you. I believe it was in the opposition to motion for summary judgment.
It's in our response to their motion for summary judgment.
Yes. So that part is conceded. It's just the causation and redressability that are at issue. With respect to, and we don't believe that those are meritorious arguments on their end for all the reasons we've set forth in our brief that I identified this morning. But I did want to touch briefly on the Lubbock case, which Ms. Hacker said was analogous here. The Lubbock case, the plaintiff in that case is in fact a plaintiff in this case. It's Planned Parenthood Greater Texas Surgical Health Services, which until the Lubbock ordinance took effect, provided abortions in Lubbock. That case is not analogous because the defendant there was in fact a municipality that did not have enforcement authority. It was a municipality that or didn't have the right to bring an action. It was the municipality that adopted the ordinance. We think that that case is wrongly decided on its own terms, and I would highlight for your honor that the time to appeal in that case has also not yet run. But in any event, the rationale there cannot possibly apply here, where the defendants are in fact people who have been delegated authority. And your honor, for the cite to that concession on injury, in fact, that's at page 7 of their opposition to the motion for summary judgment. So that is Lubbock. On the issue of third-party standing, we have brought some of our claims, the right to privacy claims, on behalf of our patients. But most of our claims refer to the constitutional rights held directly by the Planned Parenthood plaintiffs and their physicians and staff. They are not brought on behalf of our patients. So I would say, to the extent that your honor, these arguments about whether we have authority to bring third-party claims in Texas courts on behalf of patients, one, that argument goes only to a subset of the claims that the Planned Parenthood plaintiffs have brought. But two, as we identify in our summary judgment motion at page 16, footnote 2, there is case law to support a finding of third-party standing in Texas courts on behalf of patients and in analogous circumstances, or circumstances analogous to these. So there is case law that we've provided to your honor that would support third-party standing here. And I would note that even SB 8 itself, which attempts to kind of cabin when third-party standing can be used, recognizes at least some minimal third-party standing claim on behalf of patients that people can use in a defensive posture. So the idea that because we are bringing a declaratory judgment action as opposed to waiting to get sued, that we can't also invoke the rights of our patients, I think is refuted by SB 8, but more importantly, is not the law under in Texas courts. Those are the only comments that I would have with respect to the plea to the jurisdiction, unless your honor has questions as to that motion. So with respect to the Texas Citizens Participation Act, you know, I think, again, we will rest largely on our briefs. I do think that the conversation today has made that motion seem as if it's complicated, but I really think it's actually quite simple. based on the discussion that we have had in the court today, it is clear that the Planned Parenthood plaintiffs have made out a prima facie case with respect to their claims. If that's true, if Your Honor agrees with that, then this whole discussion about whether the defendants have been sued, the claims in this case are related to their First Amendment or otherwise protected speech activities is irrelevant, because what the TCPA says is that even if claims are related to or based on First Amendment activity, once the plaintiff bringing those claims sets out a prima facie case, that is enough. And we've done so clearly with the evidence of the briefing and the argument today. So I think that motion could be quite easily disposed of based on the discussion we've already had.
You've got 8 causes of action or whatever it is, you've made out a prima facie case on 2 or 3 of them, is that enough?
Well, Your Honor, I would say that we think that no, the TCPA says that it is with respect to each particular claim, and I haven't understood the defendants to be arguing that their motion applies to only some claims, although certainly they could correct me if I'm incorrect about that. But I do think that we have made out a prima facie case with respect to each of those claims that would make it unnecessary for this court even to consider whether the claims that we have brought are based on protected activity by Texas Right to Life and Mr. Sego. I would say, however, if Your Honor thinks that you have to address that first step in the TCPA analysis, whether there's, the claims here are based on protected activity by their clients, I think the answer to that is clearly no, for the reasons that we explained in our opposition to the TCPA motion. I do want to perhaps draw some distinction or just be clear about the fact that the Planned Parenthood plaintiffs and the non-Planned Parenthood plaintiffs have submitted different records with respect to the TCPA motion and summary judgment motion. And I do think that there is material in their record that we are not relying on with respect to our claims or to show the threats made by the defendants in this case. We are not, and I want to be very precise about this, Mr. Sego and Texas Right to Life are not being sued because they are pro-life, because they lobbied for SB 8, or because they have advocated generally and in the public support for SB 8 or restrictions on abortion. They are being sued because they have threatened to sue our clients and enforce an unconstitutional law against them. And I would direct Your Honor in our opposition opposition to the TCPA motion at pages 11 to 14, we identify and explain the case law in Texas courts and in the federal courts, because the TCPA also invokes First Amendment protection. Case law showing that frivolous litigation that is designed essentially as a way to harass, is not protected by the right to petition under Texas law or under the First Amendment. So to the extent Your Honor considers whether the claims in this case are related to protected activity, the answer to that is no, because the act of filing an SB 8 lawsuit and invoking the unconstitutional enforcement mechanism and goal of SB 8 is itself unlawful activity. It is precisely the kind of sham litigation that courts do not have an interest in adjudicating, and that the First Amendment and speech protections under Texas law do not, in fact, protect. In terms of some evidence, for example, defendants have pointed to statements about the website and the recruitment of plaintiffs through the website. That evidence goes not to the fact that they're engaging in some kind of associational conduct, but it's showing that they are in fact working with others in order to violate our clients' constitutional rights. And again, in our opposition to the TCPA motion, we cite cases in Texas that have said, look, just because someone uses written words or, orally communicate something in order to take part in an unlawful scheme doesn't mean that the TCPA applies and they can get their suit dismissed. Quite to the contrary, if the communication or the joining together is part of the unlawful activity that is being alleged, that is not what the TCPA is designed to protect against. It is designed to protect against cases where the claims really are being brought solely to chill First Amendment rights, as we explained in our opposition. So I don't think that the TCPA applies here, both because the conduct or the activity that is at issue by defendants is not protected under Texas or federal law, but also because even if this court were to assume that it is protected, the plaintiffs and the Planned Parenthood plaintiffs, I can speak for, have made out a prima facie claim on all of their causes of action. And then just one very small final point. The defendants have, and I believe this goes actually to the, my apologies, I'm skipping back to the plea of the jurisdiction, but I promise I will stop after this. The defendants have said that in order to have a Declaratory Judgment Act claim, the plaintiff has to show that the underlying conduct is unlawful, that it's not enough to allege that the law at issue is unlawful, but that the defendant is acting unlawfully. And, as I've explained, we think that the threats from Texas Right to Life and Mr. Sego do in fact meet the standard that defendants are advancing, that they are in fact engaged in unlawful conduct when threatening to enforce SB 8. But I also would say, to your honor, that that is not in fact the standard. And even the Myers case that the defendants cite for that proposition, that's 548 SW 3rd at 486, that says, quote, a plaintiff's asserted injury may arise from the government's allegedly unlawful act. So even the Myers case recognizes that whether the conduct itself is illegal, if you are taking steps to enforce a law that is allegedly unlawful, that is sufficient to justify a declaratory judgment action. And with that, unless your honor has further questions, we would urge you to deny the TCPA motion and the plea to the jurisdiction at the same time that you rule on summary judgment in this case.
Response?
There's some overlap here, but we'll talk about standing, which comes up in both. But I think one thing that I want to emphasize is that there is no evidence that the requested injunction or declaratory judgment that the plaintiffs are seeking will redress the plaintiff's alleged harm. There's no evidence of that in the record. They've said statements about that, but there is actually no evidence in the record of that. The plaintiffs allege that they have stopped performing post-heartbeat abortions because of SB 8. That's not because of John Sego or Texas Right to Life. And actually, in our brief, Miss Murray is correct that we did concede that there was injury in fact as to the 4 Planned Parenthood plaintiffs, but I want to clarify that because if you look at the whole discussion on page 7 of our response, it refers to the declarants, the Planned Parenthood declarants discussing the fact that they cannot perform post-heartbeat abortions. So to the extent that they're claiming that not being able to perform post-heartbeat abortions is their injury, that's what we've conceded. We have not conceded that they are suffering an injury because of any of the provisions of SB 8, you know, all of the things that we've been talking about here. So just to make that clear. With regard to causation, Ms. Murray has said several times that Texas Right to Life and John Seago have threatened to bring lawsuits against us or against her clients. They have never specified anything about Planned Parenthood at all. And with respect to Texas Right to Life and John Seago, in terms of the record, there's one statement by one of their doctors that says that plaintiffs stopped performing abortions because of Texas Right to Life and John Seago. But that is a disputed fact. I think we mentioned that earlier. So there's a genuine issue there. And it also doesn't make sense for the reasons that we discussed earlier. But as to redressability, there's no evidence by any plaintiff that the injunctive or declaratory judgment they're seeking will redress their alleged harm. The plaintiff's lawyers have argued today that the injunction against Texas Right to Life and John Seago will somehow help their clients. But again, there is no evidence of that. Now, with respect to the TCPA, with respect to the first part of it, which is whether the defendants have been sued because of the exercise of their First Amendment rights. The 2,000 pages of evidence that Ms. Eklund has referred to numerous times is 2,000 pages of evidence that they're being sued because of the exercise of their First Amendment rights. That's entirely what that is, Your Honor. Ms. Murray tries to cut it a little more finely, and instead she says that we're not suing Texas Right to Life and John Seago because of their speech, we're suing them because they've threatened to sue. Now, just to clarify, that is speech, and it also is protected. It's protected under the right to petition, under the federal constitution, the Texas Constitution Open Courts provision, and it's also protected under the TCPA, section 27.005B1B. States that the right to petition that is protected under the statute. And she said that threatening to sue is the unlawful conduct that is at issue here. But again, private parties cannot violate the Constitution. Even if the plaintiffs believe that having to defend an SB 8 lawsuit would violate their rights, that constitutional violation is not caused by the person, the private individual who brought the suit. Their rights would only be violated if a judge entered a judgment contrary to their rights against them in an SB 8 lawsuit. Private parties cannot violate the Constitution. With respect to this, so one thing about the declaratory judgment. The plaintiffs here are not asking for a declaratory judgment saying that Texas Right to Life and John Seago cannot sue them. They're asking for much broader relief, and that's the problem here. They're asking for sweeping declaratory relief, declaring all of SB 8 unconstitutional for all people, and that is not something that the court can issue. Now, if that is what's at issue here, I would point the court to Civil Practice and Remedies Code, chapter 37.006. And that's part of the UDJA. And that says, when declaratory relief is sought, all persons who have a claim or any interest that would be affected by the declaration must be made parties. A declaration does not prejudice the rights of a person not party to the proceeding. So a declaratory judgment cannot extend beyond the parties to the proceeding. And as far as any interest that's being affected, if the court is going to declare the entire law unconstitutional, the state has an interest there that is not being asserted here. And the state was a party, but the plaintiffs non-suited the state. So to the extent that the court would declare all of SB 8 unconstitutional, the state should be a party to that.
Now, I did ask Mr. Hilton on behalf of the AG's office, you all saw the email, and he said, we're not gonna be there. We know about it, we don't have an interest, and we're not going to be there. The pleadings have not changed since he was here.
So notice to the state is not the same thing as what the UDJA requires. The UDJA says must be made parties. And so the state is, it's true, the state is not required to be here if they are not made a party. But because of the fact that they were unmade parties,
Mr. Hilton's request, he was getting ready for the question.
well, Mr. Hilton was going to assert governmental immunity, which he was perfectly entitled to do under the law. And the plaintiffs made the tactical decision to non-sue him because he was going to assert those immunities. But that doesn't mean that that will fulfill the requirements of the UDJA statute. So with respect to standing under the UDJA, if the plaintiffs are now arguing that the UDJA creates a different standard for standing than constitutional standing, then that would be standing conferred by statute, which contradicts their arguments as to SB 8's conferral of standing by statute. So I'm not really sure exactly how to sort that out, but I would just say that constitutional standing is a matter of jurisdiction. It cannot be waived, it cannot be conceded. The court has an obligation to ensure that it has subject matter jurisdiction, and here it does not, which means that the court should grant the plea to the jurisdiction. Alternatively, the court should also grant the motion, or the court should also grant the TCPA motions to dismiss, because the plaintiffs or the defendants are being sued because of their protected First Amendment activity. And also the defendant or the plaintiffs, sorry, it's a long day. The plaintiffs have not made out a prima facie case on all elements or all claims at issue here. Ms. Murray was correct. The UDJ or the TCPA would be in force, and the court would be required to grant it if they have not made a prima facie case as to all of their claims that they are making here, because the entire reason that they have brought all of their claims is because of the protected First Amendment activity of the defendants. So if they haven't made a prima facie case as to all of their claims, the TCPA motion should be granted. I think that's all I have for now.
Let me ask you a question or two. You said the private parties can't violate the Constitution. But if a person files one of these SB 8 cases against a party or two, the defendant would be able to assert unconstitutionality, right now, if she knows.
Yes.
These pre-enforcement challenges, my thought is that it's basically the same legal analysis. It's just made before the bringing of the suit. It's a preemptive or a pre-enforcement challenge as opposed to waiting and defending the lawsuit. So why, if the argument is you can't bring these pre-enforcement actions, you've got to wait to be sued. I understand that, but the raising the constitutionality arguments against the private person that brings the lawsuit, I don't understand why there's a difference.
So I think the way to think about it is that if unconstitutionality of the statute is being asserted in defense, it's not a claim, it's not a counterclaim against the plaintiff. It's just, you can't get relief against me because the law you're seeking to apply against me is unconstitutional. That's the difference. Here, we have the plaintiffs making a claim against Texas Right to Life and John Seago, and that's why they have to establish standing before they can do that.
Since they're asking for a declaratory judgment, isn't the legal analysis the same as whether the law is constitutional or not?
Well, the UDJ does not confer standing, so you still have to get
I
through the
understand
standing
that,
issue.
but whether open courts, equal protection, you know, whatever it is, non-delegation, whether those are violated or not. I guess my question is the analysis for me different now than it would be on the merits, than it would be if I had one of those cases and sued for $10,000?
Well, I think it would, Your Honor, because, and that's something that I think has been sort of missed, ironically, in all of the extensive discussion that we've had here today, is sort of like how an SB 8 case would actually work. So if this was actually an SB 8 enforcement action that John Seago, say, brought against one of the plaintiffs, and you were the presiding judge, you know, if, first of all, it's an open question as to whether, you know, the plaintiff in the case, Mr. Seago, whoever it might be, would actually assert all of these aspects of the law that the plaintiffs don't like against them, right? They don't have to ask for attorney's fees. They don't have to make all of the arguments that SB 8 requires. So that's sort of speculative as to whether all of those things would even end up applying in an SB 8 enforcement suit. But beyond that, there is no reason why you as the presiding judge could not look at SB 8 at that point and say, yeah, I don't think you have standing. I think this law conflicts with constitutional standing, or any of the other provisions. There's no reason why the court would not be able to then decide whether or not it would be constitutional to apply all of these things. The plaintiffs could make all of their same arguments as to why they think all of these things are unconstitutional. And there you would not have the threshold problem of standing, because they wouldn't be asserting a claim against the SB 8 plaintiff. So I think that's the issue here. It's because they've brought this in a pre-enforcement context that raises all of those complicated issues. But they would 100% be able to raise every argument they've made here as to the merits of SB 8 and its unconstitutionality. They would be able to assert all of that as defenses in SB 8 litigation. And if it's asserted as a defense and not as an affirmative relief and as an injunction or declaratory judgment, they would not be liable for attorney's fees even under SB 8, assuming that would apply, for making those defensive arguments. Yes.
Your Honor, may I have 3 minutes?
Why don't you take those 3 at the podium?
Okay, I will. And I just want to address a few things that Ms. Hacker said. Just to clarify the record, our clients are in fact seeking declarations that SB 8 is unconstitutional for all the reasons that we put forward in our papers and also here today. We are also seeking a declaration that because SB 8 is unconstitutional, it is void, and therefore Mr. Seago and Texas Right to Life cannot bring lawsuits underneath SB 8. And if they were to do that, they would be frivolous. So we are seeking a declaration with respect to the defendants specifically, in addition to the underlying declaration that's required to get to that, which is that SB 8 is unconstitutional and void. With respect to the state defendants, Your Honor, the Declaratory Judgment Act itself tells us who the necessary parties are. And in section 37.006 B, it says that in any proceeding that involves the validity of a municipal ordinance, the municipality must be made a party. In any proceeding that a statute is alleged to be unconstitutional, the Attorney General of the state must also be served with a copy of the proceeding and is entitled to be heard. Those are 2 very different things. If someone is challenging a municipal ordinance, the municipality must be made a party. If someone is challenging a statute, ordinance, or franchise as unconstitutional, the Attorney General of the state must also be served with a copy and is entitled to be heard. The state is not a necessary party here. We asked them to be here. We invited them to be here. We said, it seems like you might have an interest in whether your law is actually constitutional. And they said, we don't want to be here. And in fact, if you make us be here, we're going to slow you down. But the Declaratory Judgment Act itself makes clear that the state doesn't have to be here. They have to be notified and they have to be given the option. With respect to the TCPA, Your Honor, just one final point. The TCPA is not a bar against lawsuits that implicate speech. Just because someone gets sued in connection with something that has to do with speech or First Amendment activity, it doesn't mean that that lawsuit goes away under the TCPA. What the TCPA requires is that if speech or other associational rights are implicated by the lawsuit, then unlike other cases in Texas, where the plaintiff doesn't really have any initial burden to come forward and say, no, this case is not frivolous. I can make out a prima facie case for this claim. Then the TCPA allows that case to go forward. It is a special early look for claims that implicate speech and other activity. It is not a bar against lawsuits that depend on speech or other protected activity. Here, we've more than satisfied the prima facie burden. That is clear and specific evidence that raises an inference that unrebutted satisfies our elements. That's more than satisfied here. Again, frankly, it was satisfied in the contested hearings of the TRO. Your Honor, unless you have other questions, I'm happy to sit down.
Just a general question, is there right to jury trial in these cases?
I don't believe the defendants have asked for a jury trial.
Not in this case, in these SB 8 cases.
Oh, I believe in SB 8 cases, there is a defendant could assert a right to a jury trial.
What would a jury be told about damages? What are they for? And I assume the plus beyond the $10,000 would be up to the jury if you ask for one.
I honestly don't know what the jury would be told, Your Honor, because the legislature hasn't made it clear what injury the damages are actually trying to compensate for.
I found myself thinking, what do you do when the note comes out saying, what's this for?
I honestly don't know what the jury charge might look like with respect to damages, Your Honor, because there is no indication of what harm to the person bringing the lawsuit would be and how to compensate for that.
Don't have any thoughts on that?
About the jury charge? No, I haven't thought, we have not thought about how that case would play out with respect to the jury or damages.
I would just add, Your Honor, that the $10,000 is statutory damages, which is not automatic and would only be awarded if the plaintiff proved their claim, which, as another matter, as I was mentioning earlier, giving thought to how these lawsuits would actually work in practice, I think it would probably be a rare instance that someone would have the evidence that they would need to prove a claim that an illegal abortion occurred, because abortions occur in abortion clinics and no one is in a clinic except for the doctors and the nurses and the patient. So, the idea that lots and lots of these suits would be brought and that there wouldn't be, an element of proof involved, I think is wrong. But assuming the plaintiff proved their claim and the statutory damages would apply if it was beyond $10,000, I'm guessing the parties would hash out what the appropriate jury charge would be, and then the judge would decide based on the law what that would be. I don't think SBA speaks to that.
If the lawyer was involved on the plaintiff's side, there would probably be a request for discovery request for the records.
I think they would have to have enough to get past a motion to dismiss.
It's in a distant forum. One of these little people might have trouble showing up. Nurses, staff people. Let's talk about the time constraints. I think we're finished, but if we're not, I'll let you go on. But let's talk about what timetables I have to meet. I've got this. I need to look at the TCPA again, but you all help me.
Your Honor, the TCPA has statutory timing requirements for you. The first is, yes. The first is you have to conduct the hearing within 60 days of the TCPA motion being on file. You are within that 60-day period. You've complied with that. And then it requires an order within 30 days of conducting the hearing. So you have to, if you don't rule on the TCPA within 30 days from today, it would be denied as a matter of law, by operation of law.
And does that mean I need to decide my summary judgment issues and standing and everything by 30 days?
Your Honor, I think our position will be that you could decide that anytime before the 30 days, to the extent you've heard the arguments you need to hear and don't have any further questions. The ruling on the jurisdiction doesn't create an interlocutory appellate right. The ruling on the summary judgment, depending on what Your Honor decided to do, could be a final judgment that could then go immediately upon appeal, or I think you mentioned in the earlier status conference that you could certify certain issues to go up on an interlocutory basis. The TCPA is the unique part of this, which is once you rule on the TCPA, either granting or denying, there's an immediate interlocutory appeal that then makes everything in the trial court stop.
And that would stay the summary judgment?
It would, Your Honor.
You all want me to do that?
Well, Your Honor, we do want to assert our rights under the TCPA, and we believe that it would be more procedurally proper and would better reflect the purpose that the legislature had in enacting the statute to allow us to assert our rights under that statute without having to go to final judgment on summary judgment.
Well, you've asserted them here, and we've had the summary judgment hearing too, and the work has been done on the summary judgment part of it. All right, rule so everything can go at the same time.
Well, I think to the extent that summary judgment would be, well, two things actually. To the extent that summary judgment would be granted without allowing us time for discovery, I think that's the big issue. The court had said that it would allow us to do discovery, but for those TCPA motions. And so basically, if the TCPA motions are held until summary judgment is entered against us, if that were to happen, then we would be prejudiced in not being able to seek discovery. The second point is that there are a couple of mandamus cases in which the court had not ruled on jurisdictional things before granting summary judgment. And part of the rights asserted under the statute is the right to interlocutory appeal. That is one of the movement's rights. And so, it's not to slow things down or for any sort of dilatory purpose. It's simply to assert our rights as given to us under the statute by the Texas legislature.
But if I were to rule first on the TCPA and everything, and hold off on summary judgment, that takes some time to get upstairs and back down. But now if it's granted and so forth, that ends it. But if they're right on their, the quicker thing to do it, let it all go at the same time. Wouldn't it?
Well,
And then whatever happens in the appellate court, it's over. No, am I wrong with that?
Well, he just said not if there's a remand, but
But why, well, they could remand it.
on the discovery.
They could, they certainly could.
I think that's the sticking point, is that if the court were to, if the court were to deny our TCPA motion and grant summary judgment, then that would be denying us the right to conduct discovery before the grant of summary judgment.
But if they are right, that they prove certain things as a matter of law, that ought to go up, shouldn't it be ruled and go up? I said if, but I don't know, but,
So,
it does seem to me that this case ought to get to the appellate court sooner rather than later. Or however it goes, it seems to me absolutely in the public interest that this issue be decided sooner rather than later. Now, I'm going to be reasonable with on that, but that just seems like a no-brainer to me.
so 2 points.
And you would get, you're going to get a ruling from me, and you get a ruling from the Supreme Court. I assume we'd want to go, whoever would want to go straight to the Supreme Court, maybe not. But whatever, the law is on that, it happens. But for it to, it just,
If I may, Your
for
Honor.
things to go up and come back down, up and down, when I read about that, it just seems frustrating, and I'm kind of embarrassed for the judicial system that it lets that happen. And I just am asking why I should let that happen in this case, no matter who wins or loses. I'll just tell you, no matter. It just seems to me the public interest, which is something I care about, is to let it all go up.
Quick points, Your Honor.
Sure.
So as Your Honor is aware, and as we've discussed, there is a merits aspect to the TCPA. And so if the TCPA goes up on appeal, it's not that the plaintiffs would have no opportunity to make their merits-based arguments to the appellate court. In fact, that would be part of the appeal. They would have to show that they've made a prima facie case on all of their claims. And so if the TCPA motion went up on appeal and the plaintiffs made their arguments as to prima facie case, then certainly whatever judgment happens on the TCPA motion on appeal would then have relevance to their claims on merits that would remain in the trial court. So they would not be without that remedy even on the appeal of the TCPA motion. But secondly, I would also point out that certainly appellate courts expedite proceedings. We've been involved in expedited proceedings for several months now. So that would also be an option if the plaintiffs felt like they needed relief more quickly. But they do have temporary injunctions. They're not suffering immediate harm. But to the extent that, the TCPA motion has the interlocutory appeal aspect to it, I hear your frustration, but that is part of the statute. That's what the legislature enacted. That's why they gave the interlocutory right of appeal, and we're entitled to exercise that under the statute.
Your Honor, may I briefly address one issue?
Yeah, I'm pretty sure you don't want to argue with me about what I just said.
I do not want to argue. I just wanted to correct a statement that Ms. Hacker said, which is that if the TCPA motion goes up on appeal, because it's a look at the merits, an early look at the merits, that the appellate court would then be able to weigh in on the merits. The TCPA statute actually specifically prohibits that, and any determination under the TCPA from the appellate court actually has no precedential value whatsoever. It's why the TCPA opinions always come out as memorandum opinions. It can't even be referred to as law of the case because it is just an early look at the merits.
Your Honor, can I make one point as to timing? I just wanted to flag, as discussed at last week's hearing, that we are planning after today to submit a proposed order to Your Honor for your consideration, and we will do that as soon as possible.
Both of you do that. And I understand not having it ready today, and maybe you didn't want, maybe you don't want the other side to see what a lot of what you're thinking is, but I understand that. Are both sides willing to let the other side see their proposed order? Any problem there?
That's fine, that's true.
That's fine, Judge. I did want to bring up that we've also filed objections to the plaintiff's summary
Yeah.
judgment evidence.
Yeah. Where are those?
I have a copy.
I mean, have they been sent to me?
They were filed, and I don't know if they've been emailed.
Let me tell you, I tried to log on to the Austin, the Travis County system, and it was user unfriendly to me. And I gave up. I'd rather get it things from you all. Very easy for you all to send me things, but that's why I asked for them. I did, Ms. Hacker, I said this in my email yesterday, I think it was, maybe the day before. My computer was suspicious about those links. It said, this is not a safe, something right there. And I clicked advanced and it didn't help, and I finally gave up and asked. So the thing, you had about 5 things, maybe 6, and I got several of them from you all. But the objections, I haven't looked at those, so get those to me. Why don't you, Ms. Hacker, Mr. Stevens, the things that were in those links, if I haven't been sent those by other people, send them to me. But I think I have, the TCPA motion for the jurisdiction, your response to the summary judgment, those things I've gotten and read, but the objections I didn't look at. So let me see those. And I'll tell you, if when I dig into things, if I think that there are objections to declarations or whatever it is from the plaintiffs that are crucial, I'll deal with it. I may, we'll just have to see. But if it doesn't, some things are going to be clear, positive, and direct, and could have been easily controverted, whatever the rule says, and it depends on what it is. And then some of it may be cumulative of other things. I just don't know, but I'll look at them and do those. But I guarantee you, I will understand them better now than I would have this morning at 9 o'clock or yesterday. That's for sure. So get those to me, and that'll be part of it.
Judge, we would just ask that to the extent the court relies on any of the evidence that's objected to, that we just get a written ruling on those specific objections. There are quite a few objections, but if the court's not relying on certain evidence or objective to evidence, then we don't.
You're entitled to an objection ruling by me. You're entitled to that, you'll get it. Not that I'll enjoy doing it, but you'll get it.
One other question I had on objections is it sounded that the non-Planned Parenthood plaintiffs are offering, and we had this discussion earlier today, certain evidence or affidavits that were not part of their summary judgment motion. That's something that I think we would ask for the opportunity to file a motion to strike or some briefing on that question. And then also,
you're talking about when they asked me to take judicial notice of what was in the files?
right, or relying on pleadings in support of summary judgment or other affidavits.
Why shouldn't I put the burden on you to single out whatever is in the files that you want me to consider under 166AC, I think, and it's not in your other things, because
Well, Your Honor, the most direct answer is that Rule 166 AC says that you can look to and rely on anything that is in the file. The other answer is we did identify.
It's hearsay.
Well, if it's hearsay, they can make an objection as to hearsay, but they're objecting to you even looking at what's in the file. The other point I would make, Your Honor, is our summary judgment motion actually specifically incorporated by reference the declarations of our clients. They weren't attached to the summary judgment because they were already in the files of the court, but they are specifically referenced in a footnote and incorporated by reference. And it's not the pleadings, it's the sworn testimony that I put before you, Your Honor, several times today.
Okay, if your motion for summary judgment expressly brings it to my attention and makes it part of the record, that's not the kind of thing he's concerned about, I don't think.
I'm concerned about their summary judgment evidence, including something other than what they say in their summary judgment motion, which is plaintiffs rely on the following exhibits as summary judgment evidence. And then it lists what they rely on, which I've provided objections to, and is my understanding of what their evidence is. But it appears that now they're saying that the entire case file is evidence that they're offering in support of summary judgment. Perhaps there's some footnote here that's.
It's 2 points, Mr. Stevens. It's footnote 9, where we specifically incorporate the declarations that were put in support of the text of the temporary restraining orders. So there's no hiding the ball here about the evidence of injury in fact.
If there's a declaration or an affidavit that was attached to a petition, and it is specifically referred to in your motion in that list.
It's not in the list, that's the problem.
It's not in the list of exhibits because Rule 166 AC says you have to identify specifically and authenticate via affidavit anything that is not already in the court's file. The declarations in support of the TROs were already in the court records. So the court can certainly consider anything that's on file with the court.
Let me read. Do you have a copy of 166 AC, Mr. Stevens?
Well, I have a copy of.
Can you use this one?
I can give them.
And Judge, if we could have an opportunity, if the court allows them to rely on that evidence that wasn't listed in the motion, then we would just simply ask for the opportunity to provide objections as we did to what was previously listed.
Looking at the language in the big middle of C, the judgment sought shall be rendered if, getting on down to the pleadings, admissions, understood, affidavits, stipulations, public records on file. Shows that, there's no judgment, no issue of material fact and so forth. That does say affidavits on file. I think an affidavit petition, I assume they are.
They were actually attached to the applications for TRO, Your Honor, and offered as evidence at the TRO hearings. They're also attached to your temporary injunction order.
Go ahead and give me a copy of your objections, and if there's material that you want to object to, I'll have to deal with what sub C says, but it does say affidavits. That word is in the rules. I'll have to deal with it, but I'll give you a chance to point out what you don't like and object to.
But the issue I have in thinking further about it is I don't know what specific evidence they're relying on because they're saying the entire case file. So if they could tell us which affidavits they're relying on in support of their motion, which is a requirement under the rules, then we would know what to object to.
Your Honor, we're happy to identify
Okay,
the
that's all I
affidavits
need.
that have been put in. Also, I just wanted to ask, to the extent that you have other objections to specific evidence, if we could have an opportunity to respond
Right,
to any
yeah.
of those objections once they're lodged. We have no problem with you making your objection.
That's fine.
Now, let me mention this. Ms. Murray has this one-page handout on non-delegation. She cites 2 Texas Supreme Court cases. I have not read those cases. But I intend to. And I frankly don't remember what your response to the motions for summary judgment said about this. But I'm going to be looking at this. And I want to take a look at it.
Yes, Your Honor. Well, I guess if we maybe submit a supplemental response.
Do it. Yeah.
I will say though, as of right now, I do know off the top of my head that Texas Bowl Legal has to do with the legislature delegating legislative authority to a board. So I'm not sure that that's factually analogous.
As opposed to adjudicative or prosecutorial authority.
Yes, it's legislative authority, the legislature delegating the legislative.
To make rules. It sounds like an agency. I'll have to read it, but okay. Check your list and see if there's anything else we need to do while everybody's here.
Proposed order on the motion seal. I just sent it to you guys. I don't know if you got a chance to look at it, but I think we need to get it entered just because you've already ruled on it. We got the variance. So
Why don't you let me have the original or a good copy, and then I'll give everybody a day or two to look at it.
okay, that way you'll have it.
Your Honor, I think the only other item that hasn't been addressed yet was the defendant's motion to designate lead counsel.
How many lead counsel do you want me to make them designate, Mr. Stevens? They've been going with 2.
That's one too many.
Judge,
Okay.
it is one too many, but I think we're okay if, with multiple people arguing, especially at hearings like this. The bigger issue we have is that the purpose of the MDL is to try to consolidate all this so that we're not responding to multiple filings. And so we're more concerned about getting multiple summary judgment motions rather than a consolidated filing, which is what an MDL is. You're supposed to serve one set of discovery, one all pretrial motions and discovery are supposed to be
I
consolidated.
know a thing or 2 about MDL.
Right.
But I'm persuaded that they need to be in 2 groups. I mean, and I don't think it's just the 1-2 punch, but I think 2 is plenty.
Okay.
What else maybe could we do? Okay, we're in recess. Thank you very much for your excuse.
All right.
John, I'm gonna go to the bathroom.
Yeah, we go.
Thank you very much. Yeah, I wanted 6:15. That's fine. We're gonna run.
Did I say Laura? I'm sorry.
Yeah.
That was my part.
Yeah, he's great. I kept, meetings.
No, I know, I mean, like.
Really?
I think so. I haven't mentioned.
A little bit. Okay, thank you. Good job. Yeah. Yeah, no problem. Bye.
Okay, yeah.
Okay. Okay.
I also didn't drive today.
Oh, I drove.
What?
They're gone.
Okay, so I want to stay there.
I'm not going to do.
Me too. Are you on the front side?
Yeah, yeah.
Oh,
Let's just wait. Yeah. It's in Dallas.
Yeah.
Our whole family's coming in for the weekend. We're doing like our wedding